May you raise up, please? We have also Dr. Charity Wibabara with us today. Welcome. Today we are with also Mr. Kalinda Jean Damasen Ndabirora. And we have an honor to be with Miss Gemma Aumann. So these 4 judges will be with us. On the agenda, we have a briefing with judges and the mooters. We tell them who will be in the first room and who will be in the second room. So, without further ado, I welcome all our guests today. We have universities who will participate in the competition: ULK, UR, INES, INLAC, and University of Kigali. So, I welcome you, but I will first welcome Dr. Fructose for the remark, and Dr. Fructose, the chairperson of the organizing committee of the National IHL MOOT Court Competition 2022. Welcome, Doctor.
Good morning. My name is Dr. Bigirimana Fructose. I'm the chairperson of the organizing committee of this National MOOT Court of Humanitarian Law. Sorry. Distinguished guests, or protocol observed, present here. Ladies and gentlemen, it is a great pleasure to welcome you to this academic event marking the launch of the 6th edition of IHL MOOT Court competition in Rwanda. The MOOT Court competition, its contribution to the promotion of international humanitarian law has been and remain essential and unique. It is for that reason that the International Committee of Red Cross, ICRC, in a partnership with Rwanda Red Cross Society and law schools in Rwanda, decided to organize the National MOOT Court competition on international humanitarian law from 2016 up to now. For this MOOT Court competition, this edition, 5 teams of 15 students from University of Rwanda, INES Ruhengeri, University of Kigali, Kigali Independent University, and University of Lay Adventist of Kigali in Iraq, are going to demonstrate their understanding of international humanitarian law before a simulated court. Each team will have to play the role of both prosecution and defense in a simulated war crime court. The winning team, with the support of ICRC Kigali delegation, we represent our country in our African MOOT Court competition in Arusha, Tanzania, in next month, November this year, 2022. Distinguished guests, the MOOT Court competition improve the most formative skills that law schools can communicate. The MOOT Court gives students supreme opportunities to advance their careers, whether or not they intend to litigate. For law students, moot court is a new, exciting, and unforgettable experience, one rooted basically in real world advocacy. The moot court is the genesis of legal career by giving law students opportunity to improve their legal writing, legal research, and oral advocacy in a competitive environment. The moot court prepares them for a competitive market. In this regard, I encourage you, dear students, to increase your skills and abilities through moot court practices and to not give up in this process. Thus, this is one of the rare opportunities for students to test their abilities and for law schools and lecturers to get updated their teaching methodology, to adapt them to the new dynamic of international humanitarian law. Dear guests, dear participants, in the context of our region, which has been facing genocide against Tutsi, armed conflicts, and other forms of violence, and in the context where nowadays many Rwandans are involved in peacekeeping operations in many countries, it is the right moment to develop our practical skills of international humanitarian law in academia, even in other different sectors. Dear students, you are the future judge, the law enforcement officers, law lecturers, political readers, senior government authorities, as well as potential military generals. The good way of promoting international humanitarian law is to equip you with the necessary current and factual skills of international humanitarian law. When law students, especially those participating in the moot court competition, are fully informed about IHL principles, you become and remain the good ambassadors of international humanitarian law. Distinguished guests, ladies and gentlemen, on behalf of the organizing committee of this moot court, I take this opportunity to address my sincere thanks to the delegation of International Committee of Red Cross in Rwanda. You continue to work closely with the academic cycles to promote and to improve international humanitarian law education here in Rwanda. Especially without your support in this moot court could not have been exist. Your support for academia in Rwanda is not only limited to the moot court competition. You have been assisting academia in other different activities or actions. Training of IHL for lecturers in Nairobi, you have supported. Roundtables for international humanitarian law lecturers. Providing academic resources, books, and other related resources. We recognize all those valuable actions. In the same way, we recognize the support from the Red Cross Rwanda Society. You have been working with us from a long time. We address you our sincere thanks. We recognize the importance role played by the MOOT court judge. You have promptly accepted all our requests as members of the panel's court and as assessors of the team memorials. We deeply thank you once again. This 6th edition MOOT court competition is further step toward ensuring promotion of international humanitarian law. We are grateful to all of you present here today for your work in the spirit of cooperation and effective encouragement. I wish good luck to each competitor, and I thank you all for your kind attention. Thank you very much.
Thank you very much, Dr. Fructose, for your good talk here. And the chairperson of this organizing committee reminds me that apart from judges and MOOT quotas, we have other important organizations here. First of all, let's recognize the presence of Rwanda Investigation Bureau, Rwanda Law Reform Commission, NPPA, UNHCR, Rwanda Red Cross, and ILPD. So welcome. This time, let's hear the welcome note from Ms. Gemma Arman from the International Red Cross community.
Good morning, dear participants, to the academic community present here today, supporting the students, to my esteemed panel of judges. All protocols are observed. First of all, I'd like to acknowledge with thanks the opening comments from Dr. Fructose. It's a pleasure to be here, and I feel like your comments have said it all in many ways, so I will simply compliment your comments. My name is Gemma Arman, and I am the Regional Legal Advisor for the International Committee of the Red Cross, based in Nairobi. My job as a Regional Legal Advisor is to support IHL programs, which have for the aim the implementation of IHL into domestic law in Eastern Africa. It's my absolute pleasure to be here in Kigali once more, a city that I am very, very fond of. I would like to start my opening comments by acknowledging the work of the organising committee for this MOOT court. In my work, I support many mooting competitions across Eastern Africa, and I am very quick to promote the style and organisation of the Rwanda's National IHL competition as being as close to good practice as we can possibly get. So congratulations to the organising committee. The commitment shown by the 5 law schools to come together and organise this MOOT is a credit to the institutions, and it helps to establish ownership and commitment to the program in the long term. So from my perspective, it is absolutely best practice, and it's something that I am trying to encourage other countries to adopt a similar model. I also would like to congratulate the organisers for their selection of the esteemed the esteemed judging panel, and I exclude myself obviously from this, but the fact is that you students here today have a panel of judges who are engaged in the practice of law, but also the practice of international law and specifically international humanitarian law. So as students, I feel like this is a wonderful opportunity for you to examine closely what does IHL look like in practice, and you can be confident that your judging panel will be providing you critique and feedback that is based on real world practice. This is a unique opportunity for you. And so my message for the students is for you to listen well. Listen to the feedback that you receive from your judges and think about it. Even if you aren't able to respond in your preliminary rounds, you still have time to incorporate it into your final rounds. And my hope is that the standard of discussion that we see in the first round will only get better and better. And by the grand final, we really will have a robust IHL, an international criminal law debate. My wider hope is that the students that win this competition will then go on to honourably represent Rwanda in the All Africa IHL competition in Arusha later this year. It will be a pleasure to see Rwanda once again represent Rwanda with pride in that competition. My final point of congratulations for this competition is in relation to the selection of the theme. Again, it is a credit to the organising committee for your incorporation of African Union themes related to IHL to again connect your competition with the wider dialogues that are happening in the African Union and the broader international community related to IHL. Last year's MOOT, of course, was on the protection of cultural property. This year we have the theme of IHL and sexual violence and armed conflict. Again, I think that's a credit to the organising committee in keeping this competition as closely connected to contemporary IHL debate and dialogue today. So again, congratulations to the organising committee. From the ICRC's perspective, we are delighted to support this competition. We are delighted to support IHL practice and dialogue in Rwanda, and we see this as a very useful avenue to achieve that. Our motivation is that we would like to see IHL further incorporated into the domestic legal framework within Rwanda, and echoing the comment of Dr. Fructos, we see the student population as being the next generation of lawmakers. We hope that we will continue this relationship with you beyond this mooting competition in the same way that we have a continuing dialogue with the academic community. We continue to seek to support relevant ministries as they implement IHL into domestic legal framework. And again, as Dr. Fructos has noted, the importance of maintaining a dialogue with arms carriers, essentially noting that arms carriers are on the ground responsible for the implementation of IHL. So we hope that this is just another part of our continuing relationship with current practitioners and our emerging relationship with future practitioners. So I will close there and say again, thank you very much to everyone involved, especially to the organising committee. We're very much looking forward to the debate amongst the students and listening to you wrestle with IHL concepts, and it's an absolute pleasure to be here. Thank you very much.
Thank you very much, Gemma. Big applause to Gemma, all the way from Nairobi to join us today. I would like to remind you that these events are live streamed on YouTube channel of ICRC Rwanda. This also is live on ICRC Twitter, IHL All Africa, all information about this moot court. So next we have a short video on the previous moot court competition 2021, which we show us how tough it was. So we expect another tough one today. Our camera crew will help us project it, and while doing so, we combine briefing judges and mooters with this activity. Thank you very much.
I wanted to wish you a very warm welcome in this 5th edition of the MOOT Code competition in Rwanda. So I wish you all a very fruitful competition, and I wish you good luck for the presentation. Thank you very much.
We'll discuss the contemporary issues related to the protection of cultural property during an armed conflict. Good luck.
Each of the parties shall have 20 minutes of presentation, of opening statements.
He did not mention to attack the civilian population.
Still within the facts of the case, none of them left with their properties, none.
In their submissions, they failed to classify the nature of conflict. So we are wondering, in what context did all these crimes committed?
They could not leave the city. These are people that IHL cares much for.
Actually, they agree with what we have said and also brought in different crimes.
None of the crimes on Article 5, as mentioned by the prosecution, were committed by Major General Dragon.
However, Major General Dragon, with that knowledge, used the prohibited weapons.
Wish you good luck for the next round.
In that context, because there was nothing wrong that was committed, there was nothing wrong for him to prevent or even punish.
The judge always has an intention why they're asking the question at a particular moment.
Thank you so much, judges. I'm sure we appreciate all their work. Now let's hear those claps. Yes.
For the two teams that are going to the finals, team D, ULK, and team C, UR.
Today, the 15th of October 2021, we have a case of prosecutor versus Major General Dragon, who is accused of committing crimes against humanity and war crimes that were committed in the year 2013.
Honorable Justices, allow me to invite you to the facts of the case. They used cluster munitions. They used multi-barrel rocket launchers. They used heavy weapons which are unguided. They attacked civilians in the hospitals and schools, killing them willfully.
I'm inviting you to read fact paragraph 12, the unwillingness. The conflict was not between Abasta Armed Forces and the military arsenal. People who were playing a major role in this case was LLA and Abasta. They had to attack. When you want to kill the snake, you cut its head. And that's exactly what they did.
The accused should be
held liable under Article 25(3)(a) for the commission of a crime or subversion as a means of warfare.
And I would like you to inform this court what you believe international humanitarian law talks about laying of siege.
The prosecution cannot charge Major General Dragon based on mere hearsay.
If yes, how and why?
The prosecution cannot have it both ways. They want to prosecute Major General Dragon with anything and everything. Be it international armed conflict elements, they go in that line.
But by the use of indiscriminate attack, this couldn't be possible. They would not spare the civilian lives or the civilian objects.
But we are quoting our client, the last words he said was not to attack. Major General Dragon cannot still be prosecuted under Article 28 of the Rome Statute. Why?
Explain how the occupation of a territory, even if there is no conflict, would not materialize to be called an international armed conflict.
Ordering to attack what was left of the cathedral.
There's no defense or explanation, and Major General Dragon attacking them is within legal bounds.
It was highly defended because LLA had acquired a military advantage.
What are they proving before you? Respectfully, this conflict, they are claiming it is a NIAC. There are two conflicts at hand. It is not one type.
Be convinced of your own ideas and your own position.
How would you legally assess the LLA's use of hospitals and schools during hostilities, or in line with the provisions of international humanitarian law?
Major General Dragon declared that no humanitarian aid would be allowed in the city.
These are not just allegations like they stated. We are basing on the law before you, and that is what we come with.
What does the IHL provide about the use of cluster munitions?
We are coming with you with authority, law.
We can now hear from the defense team of Major General Dragon.
How the case at hand ends and how the peace returns in Kuru is when this cathedral was destroyed.
The defense would also like this court to demand the prosecution to clarify on how they are charging Major General Dragon with a non-existent legal basis which stipulates another charge.
Peace returned in Kuru after the destruction of the cathedral. It could also be a fact, Your Honors, because we have proven to this honorable court that at times Major General Dragon had no effective control. Why not this time around?
Having heard the submissions of both the prosecution and defense regarding the case of Major General Dragon, who is here present in the pre-trial chamber of the International Criminal Court, seated in Kigali, for charges of crimes against humanity and war crimes that were committed in the year 2013, or in the territory of Wano, Vandaska City in Kuru Province. The court or the chamber hereby resolves the hearing for deliberation, and the pronouncement of the decision will be delivered on the 15th October 2021 at 1 p.m.
May the winning or may the best team win.
I'm sure everyone is waiting for that. I'll start with the run-up team. The run-up team is the team from the University of Rwanda, which was the prosecution team. Congratulations to the team. And the winning team was the defendant team, which is from the University of ILK. Congratulations.
IHL is indeed at the heart of our mandate and mission. The ICRC was then given the responsibility to be the promoter and the guardian of IHL. I would like to take this opportunity to wish the winning team a success in the Africa MOOT Court competition in Nairobi, and we count on you to make us proud, your country, your school, and the ICRC delegation in Rwanda. Thank you very much and good luck.
I wish first of all to congratulate all the participants. I think it has been repeated, and it was rightly repeated, that what matters is participation rather than winning. I would like to commit that the judiciary of Rwanda is willing to work with all the stakeholders, including the RCRC and as well as universities, to play its role in skills and the knowledge transfer in programs such as this one. Thank you.
Hello. How was the video? Was it tough? So I need a tougher one today. Next, let's go to coffee break. After coffee break, we take a group photo. Meanwhile, our court muta will be ready in their gowns. So round 1 and round 2 will be in the morning. Round 3 and round 4 will be in the afternoon. And we let you know the room which you are going to go to. So our coffee break will be here. So Welcome and enjoy your breakfast.
This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on Earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence and injuries. So ICRC work here is trying to mitigate that.
Today, 65 million people are fleeing conflict, more than any other time in history. For those on the move, we support them on the journey where we can. But for those who don't want to leave their homes, or can't, they remain stuck in besieged cities. Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized the children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
Again and again, we connect brothers and sisters, fathers and mothers. When the circumstances aren't so fortunate, our forensic experts work to bring closure and the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont l'affaire des femmes. C'est pour cela que nous allons continuer en tant que volontaires à faire nos sensibilisations pour qu'un jour, toute la communauté puisse être au courant et de savoir que le viol, c'est quoi.
Throughout the world, we work to help the most vulnerable people and those who may be overlooked. We care that detainees are treated humanely, no matter what they've done, visiting 1 million detainees in almost 100 countries.
Assalamu alaikum. Sa mga tarima po namin, ma'am, 23 inmates po kami, yung iba, nagdadalawa-dalawa na lang po sila. Dito sa sahig po, ma'am, mas marami po yung...
From the diplomatic level to the front line, we remind fighters on all sides that wars have limits. Named in the Geneva Conventions as an authority on the laws of war, we work to regulate the use of weapons, the methods of warfare, and to ensure civilians are spared. No matter who they are or what side they're on, we treat the sick and wounded.
Being an organization which is very neutral and impartial, that's what we do. So it's spontaneous. You don't even have to think about it. Anybody comes with emergency, you take them in, no question.
And in the wake of war, when weapons, bombs and mines are abandoned, we clean up what we can and help those whose lives have been changed by war regain their independence. Often first on the ground and the last to leave. neutral, impartial, and independent. We are the International Committee of the Red Cross. This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence and injuries. So ICRC work here is trying to mitigate that.
Today, 65 million people are fleeing conflict, more than any other time in history. For those on the move, we support them on the journey where we can. But for those who don't want to leave their homes, or can't, they remain stuck in besieged cities. Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized that children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
Again and again, we connect brothers and sisters, fathers and mothers. When the circumstances aren't so fortunate, our forensic experts work to bring closure and the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont l'affaire des femmes. C'est pour cela que nous allons continuer en tant que volontaires à faire nos sensibilisations pour qu'un jour, toute la communauté puisse être au courant et de savoir que le viol, c'est quoi.
Throughout the world, we work to help the most vulnerable people and those who may be overlooked. We care that detainees are treated humanely, no matter what they've done, visiting 1 million detainees in almost 100 countries.
Assalamu alaikum. Sa mga tarima po namin, ma'am, 23 inmates po kami, yung iba, nagdadalawa-dalawa na lang po sila. Dito sa sahig po, ma'am, mas marami po yung...
From the diplomatic level to the front line, we remind fighters on all sides that wars have limits. Named in the Geneva Conventions as an authority on the laws of war, we work to regulate the use of weapons, the methods of warfare, and to ensure civilians are spared. No matter who they are or what side they're on, we treat the sick and wounded.
Being an organization which is very neutral and impartial, that's what we do. So It's spontaneous. You don't even have to think about it. Anybody comes with emergency, you take them in, no question.
And in the wake of war, when weapons, bombs and mines are abandoned, we clean up what we can and help those whose lives have been changed by war regain their independence. Often first on the ground and the last to leave. Neutral, impartial, and independent, we are the International Committee of the Red Cross. This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence and injuries. So ICRC work here is trying to mitigate that.
Today, 65 million people are fleeing conflict, more than any other time in history. For those on the move, we support them on the journey where we can. But for those who don't want to leave their homes, or can't, they remain stuck in besieged cities. Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized that children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
Again and again, we connect brothers and sisters, fathers and mothers. When the circumstances aren't so fortunate, our forensic experts work to bring closure and the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont l'affaire des femmes. C'est pour cela que nous allons continuer en tant que volontaires à faire nos sensibilisations pour qu'un jour, toute la communauté puisse être au courant et de savoir que le viol, c'est quoi.
Throughout the world, we work to help the most vulnerable people and those who may be overlooked. We care that detainees are treated humanely, no matter what they've done. visiting 1 million detainees in almost 100 countries.
Assalamu alaikum. Sa mga tarima po namin, ma'am, 23 inmates po kami, yung iba, nagdadalawa-dalawa na lang po sila. Dito sa sahig po, ma'am, mas marami po yung...
From the diplomatic level to the front line, we remind fighters on all sides that wars have limits. Named in the Geneva Conventions as an authority on the laws of war, we work to regulate the use of weapons, the methods of warfare, and to ensure civilians are spared. No matter who they are or what side they're on, we treat the sick and wounded.
Being an organization which is very neutral and impartial, that's what we do. So it's spontaneous. You don't even have to think about it. Anybody comes with emergency, you take them in, no question.
And in the wake of war, when weapons, bombs and mines are abandoned, we clean up what we can and help those whose lives have been changed by war regain their independence. Often first on the ground and the last to leave. Neutral, impartial, and independent, we are the International Committee of the Red Cross. This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence and injuries. So ICRC work here is trying to mitigate that.
Today, 65 million people are fleeing conflict, more than any other time in history. For those on the move, we support them on the journey where we can. But for those who don't want to leave their homes, or can't, they remain stuck in besieged cities. Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized that children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
Again and again, we connect brothers and sisters, fathers and mothers. When the circumstances aren't so fortunate, our forensic experts work to bring closure, and the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont l'affaire des femmes. C'est pour cela que nous allons continuer en tant que volontaires à faire nos sensibilisations pour qu'un jour, toute la communauté puisse être au courant et de savoir que le viol, c'est quoi.
Throughout the world, we work to help the most vulnerable people and those who may be overlooked. We care that detainees are treated humanely, no matter what they've done, visiting 1 million detainees in almost 100 countries.
Assalamu alaikum. Sa mga tarima po namin, ma'am, 23 inmates po kami, yung iba, nagdadalawa-dalawa na lang po sila. Dito sa sahig po, ma'am, mas marami po yung...
From the diplomatic level to the front line, we remind fighters on all sides that wars have limits. Named in the Geneva Conventions as an authority on the laws of war, we work to regulate the use of weapons, the methods of warfare, and to ensure civilians are spared. No matter who they are or what side they're on, we treat the sick and wounded.
Being an organization which is very neutral and impartial, that's what we do. So it's spontaneous. You don't even have to think about it. Anybody comes with emergency, you take them in, no question.
And in the wake of war, when weapons, bombs and mines are abandoned, we clean up what we can and help those whose lives have been changed by war regain their independence. Often first on the ground and the last to leave. Neutral, impartial, and independent. We are the international...
Everyone, welcome to group photo. Let's go. Mazimaka. Not yet. The remaining one are guests. So, everyone. This is room 1. This is room 1. And down there is room 2. So we have 2 groups. Ines and the University of Kigali. Hmm? Okay. This was room 2.
So look at you are.
Okay, this one is room 2. This one is room 2. In this room, UR and ULK we start. And UR will be prosecutor, and ULK will be playing as defense. In room 1, Ines and the University of Kigali, Ines will be prosecutor, University of Kigali defense. Once the judges enter the courtroom, all the attendants will rise. Is that clear? You have to respect this honorable court. So as the French say, que le meilleur gagne. May the best win. Let's the battle begin then. In this room, you are and ULK. In another room, Ines and York. Then, as I shared with your team leaders, the procedure will proceed. And the MC will be in the audience like everyone else. Get in your seat. I called you. You are. Where are you? These are for you. You are prosecution first. And defense, ULK. All rise, the court.
Good morning. In court today, we'll be discussing a matter of international criminal law. The bench will be hearing from both sides, and this is how we'll be conducting the hearing. The prosecution has 15 minutes. The defense has 15 minutes. And then we'll have 10 minutes for the prosecution to give us its rebuttal and the judges to ask questions. And then we'll have 10 minutes for the defense rebuttal. And then the judges will ask questions during those 10 minutes. So in total, we are going to have 50 minutes of a hearing, and we are going to be very, very strict with the time. My colleague, the judge on my left, will be alerting you to the times. So please watch out for her when she puts up a paper to tell you how many minutes you have left. So the minutes that we have told you, you decide how to utilize them. Without further ado, shall we hear from the prosecution? You have 15 minutes.
Thank you. Thank you, my lords. I am Prosecutor Ngobo Kaviani, together with Co-Prosecutor Karigigwa Lilian and Co-Prosecutor Adkari Monisha. We are standing before this Honorable Court, the International Criminal Court, prosecuting General Vande for the crimes he committed during a non-international armed conflict in the Buba state of Turkana in Kuka province. The crimes we allege are prominent of which direct attack to the civilians not taking part in hostilities, the command responsibility for the crime of rape, and directing displacement of civilians. If it pleases the court, honorable judge, this is the structure of what I'm going to plead about. I'll talk about the summary of the arguments, the admissibility of the case, and the nature of the conflict. The conflict is of a non-international armed conflict in category, as it was referred in the Tadic case. There are substantive grounds to believe that General Vande never respected the rules of engagement. And the accused has the command responsibility for the crimes committed. Your Honor, I'll proceed with the admissibility of the case. The International Criminal Court has the jurisdiction to hear this case pursuant to Article 1 of the Rome Statute that gives the state the priority to prosecute the international crimes committed on its territory. Pursuant to Article 17, Paragraph 1, that the state, when it is prosecuting the international crimes committed on its territory, the court will not have jurisdiction except in cases where the state had never acted, when the acts of the court are not genuine, or when the state is unable or unwilling to prosecute. In this case, the state was not willing. Basing in the Katanga case, paragraph 78, it was ruled that the unwillingness of the state to prosecute the crime, it can be derived from the undue delay. Your Honor, it is in this regard that since the commencement of the acts, up to the arrest of General Vande, they never took any investigation or even the investigation. Your Honor, in the nature of the conflict, it was said in defining an armed conflict that it should have the protracted violence between the government authorities and the organized armed groups. Your Honor, according to Common Article 3 of the Geneva Convention and the ICRC commentary, they set the two criteria. One, a non-international armed conflict should have should reach a minimum level of intensity and also should have a level of organization. For the minimum level of the intensity, there are some things we can put in the consideration, like the number of occasions, the weapons, and the military equipment applied. Your Honor, it was also said in the Mbemba case, paragraph 140 in the ICTY, that any act should have the prolonged hostilities. In this regard, Your Honor, it took almost 2 years. If it pleases the court, I would like to also talk about the organization. The FKA was very organized. Since it had the generals and major generals, it had recruited the men and women who were very well equipped. Your Honor, I would like also to talk about the involvement of Hakova in the armed conflict. The involvement of Hakova will not change any...
The prosecution finds this case to be under ICC jurisdiction. Pursuant to the Article 5 of the Rome Statute, which categorizes the crime...
The acts of organizing, planning, and coordinating the military action. But in this case, it was the mere provision of finance and the military training. Your Honor, I would also refute the Nesuno links, which the prosecution calls the anonymous hearsay. And its credibility should be very essential, that the court should not rely on the hearsay, as it was also declared inadmissible in the case of Katanga and Gunjoro case. We also call upon this honorable court not to rely on this anonymous source of information. Your Honor, if it pleases the court, I would like to call upon my co-counsel, Karigirwa Lilian, to proceed.
Thank you, Your Honor. I'm Prosecutor Lilian Karigirwa, and I'm going to be proceeding with the first count. If it pleases the court, I'm going to demonstrate to this court how the elements of this crime have been fulfilled, and I'll also proceed to introducing the first charge that the accused is charged with by highlighting the key elements that constitute the crime. If it pleases the court, I'm going to begin with the first charge. General Vande is criminal liable under Article 25, paragraph 3, alinea B, for inducing the commission of war crime of intentionally directing attacks against civilians not taking part in the hostilities, which is punishable under Article 8, paragraph 2, subparagraph E, and 7, and alinea I of the Rome Statute. Beginning with the actus reus, the prosecution submits the accused directed an attack against civilians not taking direct part in the hostilities. Under Additional Protocol 1, an attack is Additional Protocol 1, Article 9. An attack is defined as an act of violence against an adversary. It might be in form of defense or in form of an offense. It is also a known rule in the international community that civilians not taking direct part in the hostilities are immune from such attacks, as provided Additional Protocol 2, Article 13, paragraph 1. Drawing from the facts of the case, the prosecution submits that on November 10th, 2014, General Vande ordered the leader of the task force, and I quote, protect the convoy with all necessary means, that was heading the FK-controlled areas. From the interpretation of this order, Your Honor, he put much emphasis on the protection of the convoy and left the leader of the task force to determine the necessary means needed to protect the convoy. That gap is what induced an indiscriminate attack against Umbrian civilians who had come to rob the trucks, leaving 110 dead and 30 injured, Your Honor. Honorable Judge, the prosecution further submits that during this indiscriminate attack, the principle of distinction and the principle of proportionality was not respected by the task force. The principle of distinction under Rule 1 of the IHL customary entails that combatants are supposed to distinguish between the parties, the armed combatants and civilians in an armed conflict. It is uncontested fact under paragraph 16 of the case facts that the first shots came from within the crowd, but nothing ties the shots to all civilians to entail their loss of protection. Thus, the task force should have distinguished between the armed civilians and unarmed civilians before engaging. Moreover, from the facts of the case, it is also provided that they had arms that would enable them to distinguish between who was attacking them and who was not attacking them. So this excessive force is also led to the violation of the principle of proportionality, which entails that armed forces must refrain from the use of excessive force and must also assess that the intended target is not a civilian, as it's provided under Rule 14 of the IHL customary rule, and it was also provided in the prosecution versus Garlic by the IC2I tri-chamber. Moving to the mental element of this crime, the accused intended for the civilians not taking part in the hostilities to be the object of attack. In the fulfillment of this crime, the prosecution submits the two elements were fulfilled. The accused intended for the civilians to be the object of attack, and the perpetrator was aware of circumstances establishing an armed conflict. Honorable judges, General Vande had actual knowledge that civilians robbed the trucks whenever they arrived at the FKA-controlled areas due to his affiliation with Lancaster Enterprises. Thus, when General Vande gave an order, I quote, protect the convoy with all necessary means, meant protect it from the civilians, and by interpretation, protection meant attack. It is upon those grounds that the prosecution bears General Vande criminal liable pursuant to Article 25 in paragraph 3, alinea B of the Rome Statute, which provides that commanders and superiors are criminally responsible for war crimes committed pursuant to their orders. General Vande gave an order to the task force, protect the convoy with all necessary means. Let this be brought to the attention of the court that had General Vande given a proper detailed order which covered the interaction with the civilians, upon which the accused knew was inevitable, since civilians were the one who posed the threat to the trucks, this attack would have been stopped. I would like to call upon to my prosecutor to continue with the second charge.
Thank you so much, Your Honors. I'm Prosecutor Monisha Adikari, and I'm going to continue with the second count and the third count. In the second count, I am going to show that I'm going to portray the evidence for the crime, and I'm also going to talk about the command liability that is established by the effective control that the accused had over the perpetrators. And the third count, I'm going to talk about the individual responsibility of ordering displacement of civilians, that the elements of the crime are fulfilled, and the consequence of his conduct was the displacement of civilians. Basing on paragraph 21 of the facts of the case, Your Honors, prosecution submits that in collaboration of the Guardian report and Human Rights Watch interview-based report, a system of predation, sexual predation within the tough soldiers was revealed. And this is where the crime of rape is initiated. The mode of liability, therefore, is derived from Article 28, paragraph A of the ICC statute, as well as Article 50 of the Second Geneva Convention and Rule 153 of the IHL customary law, which provides for punishment of commanders and their liability when their subordinates are the ones who have perpetrated. And this has been held in the Vigirishama case that it must constitute the existence of a superior subordinate relationship of effective control. And the superior have reason to know that the crimes were going to be committed or had been committed, and he failed to take the necessary measures. According to the case facts, paragraph 4, General Vande exercised effective control in his position as the Chief of Defense Staff. He was in charge of all military operations, including the deployment to Hakova. Therefore, he should have had that mens rea. He should have known, and it was said in the Muchik case that having reason to know is sufficient to make liability. He had reason to know where General Vande was made aware of the sexual practices by the the report of the Guardian in paragraph 21. And his response to this is what showed his failure. It showed he responded, and I quote, "I am not responsible for their activities during their free time." This showed that he was unwilling to even report or punish. Moving forward, for the sake of time, I can see my time is running out. Can I have additional 2 minutes to finish up?
Unfortunately not. We did inform everybody that this was a strict time frame.
Okay, thank you. To summarize, on the accusation of individual liability for ordering the displacement of civilians, prosecution submits that the order was done, and this order, even though it is an order to detain, prosecution concurs that it was an order to detain, but this order led to, its consequence was the displacement. It should be brought before this court that the consequence, the displacement, is the subject of the IHL. It's not the order itself. Moreover, the General Vande expressed his mens rea to displace the Ombrian religion by stating in paragraph 14 of the facts that the Ombrian religion constitutes a danger to the Bubans and it must be eliminated. Again, he said it is time to eliminate this religion from our country. This is enough, and this is sufficient ground to believe that he had the mens rea. When he ordered detention, he wanted the civilians to be displaced, to move from to Kanovan's territory. And it is upon this that the prosecution prays that all these allegations all these counts be fulfilled, as he is criminally liable and the case is admissible, as well as the sufficient grounds to hold General Vande liable. Thank you so much.
Thank you. We shall now hear from the defense.
Greetings, Your Honors. I'm Counsel 1, I'm Mr. Ramadan, and I'll be defending our client, General Gerard Vande, today. On the count 1, which is the alleged war crime of attacking civilians. The facts submitted by the prosecution are hereby admitted. With me here today, there is Counsel 2, who is Zaimana Esther, will be defending our client on the war crime of rape. And Counsel 3, Nzeimana Dedone Magwa, who will be defending our client on the war crime of ordering displacement of civilians. If it may please the court, I may proceed. The defense submits that the intention of General Gerard Vande was the protection of the convoy, not the attack on the civilian. And this can be inferred to facts paragraph 16, which is when he told the leader of the task force to protect the convoy at all, with all necessary means, not to attack the civilians. With regard to the participation of the civilians, the defense counsel finds that these civilians took direct part into hostilities, and thus they lost their protected status. And this is a prohibition under Article 13, paragraph 3 of the Protocol additional to the Geneva Convention, where it states that civilians will not be attacked unless for such time that they take a direct part in hostilities. Now, the prosecution finds that according to the interpretive guide on direct hostilities by Niels Milsma, legal advisor of the ICRC, it finds that it takes the approach that direct participation does not have to inflict physical harm, but essentially any consequences adversely affecting the military operations. With reference to the facts of the case, where these civilians tried to grab weapons from the task force, they were taking a direct hostilities they were taking a direct part in hostilities because they were affecting the military operations of the task force adversary, because they were adversaries of the Free Kukan army. So these civilians took direct part by, first of all, by establishing roadblocks, second, by trying to grab weapons from the task force. Second, the defense finds that the task force, according to rule number 20 of the Customary International Humanitarian Law, which provides about advance warning, that parties to the conflict must give an advance warning to the civilians that there is an attack taking place so that there are no harm to the civilians. Now, the task force took all measures by shooting warning shots, and this can be inferred to facts paragraph 16, where the task soldiers fired warning shots with an intention to disperse the crowd. They wanted the crowd to go away. They did not want to attack them. Therefore, the defense finds that there are sufficient grounds to believe that the civilians in question lost their protection status. The defense also commences on the civilians took a direct part in hostilities. These civilians, the defense submits that they were accomplices to perfidy. And perfidy, according to Rule 65 of the Customary International Humanitarian Law, which states that the enemy killing or wounding the adversary by treacherous means. These civilians, they are accomplices to whoever had the arms into that crowd. They made it difficult for the principle of distinction. So they are accomplices because they didn't make to distinct themselves. Therefore, by becoming accomplices or in perfidy, they became lawful targets. The defense finds that the attack was not intended for civilian population because, as I was saying, they gave warning shots. Also, the convoy employed precautions in the attack, according to the rule number 20, which is why some of the crowd were armed forces, and they were aiming at killing the task force treacherously, meaning to pretend to be civilians, and these civilians complied with it. Actually, they contributed to it. Therefore, the task force acted in defense, as this was necessitated by Article 31, Paragraph 1 of the ICC, that no one should be liable, given that they're acting in the means of defense. Therefore, linking back to the generals or orders to the leader of the task force, he was to protect the convoy at all necessary means, with all necessary means. And this is the all necessary means that he used. Because these civilians, they lost their protected status. If it may please the court, I would like to call upon my co-counsel to Uwizeyimana Esther to defend about count 2, which is war crime of rape.
My name is Uwizeyimana Esther Muhozi, and I am the second counsel on the defense, and I'm here to defend the war crime of rape, the alleged war crime of rape. First of all, the defense comes to ask the question, is this a war crime? For rape to be categorized as a war crime, it should be happening to the protected persons. Who are the protected persons? The protected persons are the persons that are not taking direct part in the conflict. Also, the hors du combat are the persons that are incapacitated due to sickness, wounds, or even surrender. According to Article Common 3 of Geneva Conventions and Article 4, 2E of Additional Protocol 2, the defense submits that for rape to be categorized as a war, it should be committed on the protected persons. Now, according to paragraph 17 of our facts, The people that were being raped, the alleged people to be raped, are soldiers. The soldiers that are being raped by their fellow soldiers. This court should put this as an underlined fact that these people are not protected. Now, the defense submits that due to the fact that these persons are not protected and they do not fall under the protected persons as constituted by IHL, our client should not be held liable of the alleged crime because, first of all, he did not order such a crime, Your Honors. Second of all, the crime that's being alleged to have been committed is not a war crime. Now, this crime that was committed is instead put in the categories of ordinary crimes. The crimes that are the military sexual assaults, the normal ordinary crimes. And this should not be adjudicated by the ICC because it does not fall under the jurisdiction of the ICC. Instead, it should be adjudicated by the normal courts of the military. So according to this, the defense counsel calls for the justice to be done here by letting go of the client that is being alleged to have committed a crime which is not even a war crime, a normal crime which is not to be adjudicated by ICC instead of the other courts that have proper jurisdiction, which is clearly not the ICC. Your Honors, allow me welcome Counsel 3 to proceed with count 3.
My name's Nzemana Diadone Magloire, Counsel 3 from the defense. Your Honor, please allow me to proceed with count 3, war crime of displacing the civilians. So for this count, the defense submits that the elements of war crime of displacing civilians are not fulfilled since there are insufficient grounds to believe that the statement and orders.
The case plead to the court to find that the case is still inadmissible. We request to find that the case is inadmissible. We request that it find that the prerequisite elements of attacking the civilian population are not fulfilled. Your Honor, under Article 8, 2, Paragraph 2E, I Roman numerals of the ICC statute covers the provision of intentionally directing attacks against civilians. Your Honor, I would like to repeat the word intentional. This means that the perpetrator must have intended the civilian population as the target of the attack, which is not true to the case in the case at hand. Your Honor, General Rwanda's intent was to provide protection to the humanitarian aid and not to attack the civilians. Furthermore, Your Honor, we would like the court to find that the individuals referred to as civilians during the incident of the 10th November 2014 are not civilians. Your Honor, the defense invoked the case of Prosecutor Vascalis, Barushimana, paragraph 148.
To displace civilians. Therefore, they stated the quoted speech of General Rwanda on his point of view on the Ombrian region and the others he gave of imprisonment do not in any case shows the mens rea of this crime. Therefore, this creates ambiguities on whether he wanted to displace those civilians or he just simply wanted to forcefully change them into Bubans. Therefore, in this case, the ICC, the Rome Statute of establishing ICC espoused its commitment to the principle nullum crimen sine lege, which means that when there is no law, there is no crime. This includes the guarantees that these definitions of crime will be strictly interpreted, and any analogy or ambiguity arising from these will favor the accused in dubio pro reo. In the case of prosecutor versus Fatima Rimaj, the appeal chamber was satisfied by the principle of in dubio pro reo as a corollary to the presumption of innocence and the burden of proof beyond reasonable doubt. So thus implies to the findings required to convict, which include the elements of crimes. Thus, this jurisprudence shows that the element of crime must be met in order to remove any ambiguity which may favor the accused. So, given the above presented facts from the prosecution, from the defense therefore prays for the court to declare that there is insufficient grounds to believe that Ombrians lost their lives. There are sufficient grounds to believe that Ombrians lost their lives upon direct participation into the conflict. Second, the court do not have the jurisdiction to prosecute defendant for the rapes and sexual abuses within the TAP troops deployed in the Kuka province. And lastly, the defendant cannot be held liable for the displacement of civilian under Article 8, Paragraph 2, E Roman 8 of element of crimes. Therefore, the defense raised our case.
Throughout the facts of the case, at no point was this mentioned. Let me draw attention also to the fact that the United Nations General Assembly mandated an investigation and come back with inconclusive results. Your Honor, on this we submit that the material element of this crime are not fulfilled. What is the moral element? The moral element here being in question would have been that for the crime of General Vande being criminally liable under article, for General Vande being criminally responsible with respect to the rapes and sexual abuse of the TAF troops deployed in Kuka province on the basis of command responsibility, Article 28, Section A. Let me point this out. There are two key elements to be fulfilled. One, the military commander or person either knew or owing to the circumstances at the time should have known that the forces were committing or about to commit such crimes. Your Honor, from the reports throughout the case files, we had no incident where there was, I was raped. No, it is hearsay from the Guardian. This Guardian report was also, in a way, was dismissed by the United Nations mandated investigation that ultimately found that it was inconclusive, that there was there is nobody who came forward and said, I was raped. Your Honor, element number 2, the military commander or person failed to take all necessary and reasonable measures within his or her power to prevent or repress their commission or submit a matter to competent authorities for investigation. Your Honor, basing on what we explained above, General Vande could not have forwarded a case that is in existence. General Vande could not have investigated allegations that are vague and very open to interpretation. Your Honor, let me point out to you that, again, the United Nations General Assembly pointed out that there was insufficient, that the report was inconclusive. This is from the facts of the case number 17. Your Honor, being in charge, it's okay. He was a military commander, we didn't deny that, but he was a military commander of a force that was engaged in war. Should he have removed resources from a war that was fighting, from a terrorist war he was fighting, to an investigation that is based on hearsay that was later dismissed by the United Nations General Assembly investigation, that came and said it was inconclusive. At no point was there a single. So this disqualifies this case. For this, we kindly ask the court that.
Or the absence of proportionality, is it an element of the crime that we're dealing with right now?
Well, the proportionality principle comes in the actus reus because it clearly further provides that the prosecution that the accused intended for the civilian to be the object of attack. So the principle of proportionality comes in the actus reus to give that element more probative value.
I'm not sure about that, counsel, but I'm not sure that I agree with you.
Okay.
Counsel, I guess my case is that if the accused was targeting a civilian who is directly participating in hostilities and therefore has lost their protection, then the crime is satisfied. Proportionality is not, a proportionality assessment is not part of the elements of the crime.
Well, thank you, Your Honor. Due to the fact that there were some unarmed civilians, as it is indicated in the facts of the case, the defendant should have used only the limited necessary force needed to direct the attack against the one who was attacking them.
But again, I'd say that's not an element of the crime. But thank you, counsel. Please keep going.
Moving forward, for the element of this crime to be fulfilled, the principle of proportionality is to show the gravity of the omission done by the defendant. That is what the principle of proportionality entails in this case, and that is why we brought it into the actus reus, to show the gravity of the attack that was directed at the civilians.
I'd suggest you move on, counsel. Thank you.
Okay. Thank you. I'm going to give my counsel to continue with the second count.
Thank you, Your Honors. The defense has taken a long time to elaborate that, to make their case that it does not amount to a war crime. And that basing on the fact that the victims were fellow combatants in the same armed group. However, the prosecution would like to show the court that this has been ruled by this very court before in the Naganda case of 2019 in paragraph 965, that permission, if I may have the permission to quote the case, rape against any persons is prohibited, and therefore members of the same armed forces are not per se excluded as potential victims of the war crime. This is a substantial case in IHL that has shown that even the members of the same combat or forces are protected from sexual violence and torture and things like that, acts like that. So defense should really make their research or elaborate more on this fact.
Counsel, how do you connect that to General Vande?
Yes, with the facts of the case of Naganda, it was seen that the rapes were being done to the children who were assimilated into the combat. And now they were made legal combatants. Yes.
My question was for you to actually elaborate on command responsibility in this particular instance.
Yes. Your Honor, for command responsibility to even occur, it needs the establishment that the crime was perpetrated by the subordinates. This is why defense replied saying that there was no crime. However, they were basing on the fact that the victims of the crime are the ones who are going to disqualify this as a crime. Prosecution is trying to show that the victim is not what matters in IHL. It is protection of all people. It was stated in the Naganda case, which is a substantial case in the matter.
What are the elements of command responsibility?
The elements of command responsibility, as we have said, is that they have to be effective control between the subordinates and the commander himself, that the commander should have known that the crimes are going to be committed, and he failed to take the necessary measures.
So, Counsel, I don't want to be the one reminding you that you have the duty as prosecution to prove beyond reasonable doubt these crimes, but for now you actually have to show a prima facie case. So how do you connect the acts of those soldiers to General Vande? Effectively, what I'm asking is for you to connect the facts of the case to effective control that Vande had. What are the facts in the case that actually show that he had effective control over the actual perpetrators?
Basing on paragraph 4 of the facts of the case, it shows what the duties of General Rwanda entailed, and it shows that he exercised effective control over the troops. He was in charge of all the tough soldiers, and the martial law power vested in him entails that he was in charge of countering the FKA forces. Your Honor, this rape was initiated, this practice was within the forces that were deployed to Kuka. So General Rwanda was in charge of those forces, and he should have known as the leader, or at least when he was made aware, he should have taken the appropriate measures. So this is where his liability falls. Thank you.
Thank you. Are you done with the rebuttal? Or?
I believe my time is done. Oh, I still have a minute. Thank you so much. Let me finish it. The defense also stated that we should interpret the literal, on the third count, that we should interpret the literal meaning of order. This was refuted. This has been refuted countless times in IHL, because interpreting the literal meaning of the word order in Additional Protocol 2, Article 17, means that it's going to give the opportunity to states to use indirect means to coerce people to leave. So an order is not what is necessary here. IHL is protecting people from displacement. The act is displacement, and prosecution has already shown that by ordering the detention and it being executed, people were forced to leave. They were coerced into leaving their territory to FKA-controlled territories and Hakova. This is seen in paragraph 21 of the facts of the case. Thank you.
Thank you to the prosecution. Can we have the rebuttal of the defense? 10 minutes, and we will be interrupting you as well and asking questions.
Thank you, Your Honors. With regard to the prosecution, alleged crimes that they are prosecuting, also with regard to the principle of proportionality, the defense submits that the assessment of weapons used, basing on the ones that were used by the task force, which was referred to by the prosecution, that the gravity of means that were used were harsh on the civilians. The defense submits that this is being one-sided, as there is uncertainty of weapons by the armed people in the crowd, because the shots were fired. And luckily, the task force, according to facts, paragraph 16, they had trucks, they had armored vehicles, which means the reason why, regarding to the deaths of civilians.
Counsel, can you please submit to the court using numbers? When you talk about the principle of proportionality, what were the losses on the side of your client, and what were the losses on the other side, and connect it to that principle?
If it pleases the court, I would like to consult with my defense.
Were ordered by General Rwanda to protect it by using all measurable means. They carried 50 caliber machine guns, which was not necessary, because they knew they were going to meet with several civilians, whereby in the paragraph they told us there were 200 local Ombrians. They did not say that there were 200 combatants, which means it is evident that they did not carry any weapons. They did not possess anything that was a threat to the tough soldiers, but yet they went on and fired and used the caliber machine guns to kill 110 local Ombrians and injured 30 of them. So we know that they only remained like very few who survived on that day. And also regarding the rape to be treated as a war crime, he explained that the reports were vague. The defense office explained that the reports were vague. Honorable judges, for example, when BBC News comes on the news and explains that there is a war of aggression,
which charge are you talking about?
I first of all talked about the charge of individually being the crime of intentional and attacks, to the civilians which were not taking their part in the hostilities. And now I'm on the card on the crime of rape. Yeah, thank you. So this crime of rape, they say that he failed to have effective control as a commander. They said that the reports were vague. Honorable judges, these reports were not vague because after the mutiny, they reported. Because if they were vague, this crime is being charged on him under command responsibility, honorable judges. Maybe the material element and the moral element might not have been satisfied, but we are charging General Bande under command responsibility of this crime because he was supposed to know under his authority what was going on with his combat with his soldiers. Whereby evidently, in paragraph 18, he just explained that he is not liable for everything that is being done by his soldiers during their free time. But they were there, as the defense office explained that they were there to fight the battle. Then while were they raping within the tough soldiers? While were these crimes being committed? While they were there for one thing, which was the battle with the FKA. So according to the facts says they were regulated from March 2014 to December 2015. So we can not only say that these reports were vague. How can a report from March 2014 to December 2015 be a vague report? Whereby he was even given an interview. He just explained and said, I am not responsible, which means he knew that something might be going on with his soldiers, but he didn't want to be involved because it was like, it is in their free time. But under command responsibility, he is liable because in their free time, honorable judges, even if you are a teacher and they ask you, why is the student being not having good marks in classes these days? Maybe teachers do follow up. So a command is an authority. You have to follow up what is being done because they were not there for other reasons. They were there for better reasons.
So can you associate your statement with the length of effective control?
Honorable judges, the length of effective control.
And maybe to add on what the presiding judge is saying, clearly established the nexus between the sexual violence that occurred and the armed force. Because in more crimes, there has to be that nexus that is clearly established.
Thank you, honorable judges. According to Article 3 of the Common Geneva Convention, it says that an international minimum protection to persons taking no active part in hostilities, including members of the armed forces in certain situations, specifically stated in the article, human and non-discriminatory treatment are two important protections offered under this provision. So, honorable judges, when we are charging him under effective control, it means that when he is in the authority of having to know whatever is going on with his staff soldiers, effective control means that he is supposed to be knowing. So the act of he had the reason to know is whereby it showed as evidence that he was negligent to the fact of what was going on. And him making the statement that he is not liable of what they do in their free time shows negligence because he was in the condition of having to know whatever is going on. And maybe he could have said, maybe I will investigate. But in his command authority, he did not want to be against honorable judges. Thank you.
Thank you. Time is up, please. So we shall proceed with the rebuttal from the defense.
Your Honor, if it pleases the court, I'd like to...
Is able to be targeted to killed because they've lost their protection as civilians?
If it may please the court, I would welcome my counsel to answer your question.
Your Honor, if it may so please the court, I would love to clarify what we meant when we said that they had lost their protection. With this, we talk of the moment they shot, the moment they took a gun and shot at the TAF. With this, we clarify that the moment one of the soldiers died, that is when there was a direct participation in the conflict.
And I find that more convincing because you've specifically limited it to the idea of taking a shot rather than the broader definition that was earlier provided.
Thank you, Your Honor. If it may so please the court, we will continue with our defense. The prosecution mentioned about the object of attack. And with this, they meant to show that the intentions of the TAF was to attack the civilians. But this is not so, according to the facts of the case, because these soldiers were going to the Cooker regions to take food. The operation was to deliver food to the Cooker regions. The objection was not to kill the civilians or harm them. So had the civilians not done what they did, there would have never been any harm, because usually, as it's said by in the fact that they usually would come every time, but nobody was killed. Your Honor, we would also love to continue with the objection about the distinction that they happened to mention. It is supported the perfidy. When the civilians knew that they had people, because this is a perpetrated attack, Your Honor, over 200 Umbrians came to attack the vehicle. This shows that this was perpetrated beforehand. Now tell me, how did you perpetrate to attack and you did not know of the people within your group that had arms? Your Honor, this shows that we come to rebuttal the distinction policy that they accuse of our client to have failed. Your Honor, I will welcome my fellow counsel to proceed with the rebuttal.
Continuing with the rebuttal on count 3, the prosecution was satisfied with stating, if I'm not mistaken, the Nganda case. They stated the Nganda case, and they did not manage to link this Nganda case to the fact and to show how General Vande is criminally liable according to this Nganda case. What they did, they based on a general impression of what General Vande did in his speeches and others. This clearly shows that they based on a general impression, though the burden of proof is on the prosecution to identify clearly the individual post and other that constitute a specific other or any other intention by the General Vande. Basing on Nahimana appeal judgment, paragraph 726 and paragraph 727, the court looks at each statement or other individually, not based on a general impression. So the prosecution did not manage to show clearly which of the statement induced the displacement of civilian. So that's all about the count 3 rebuttal from the prosecution. That's all they said.
So I have, do I still have time? No, 10 minutes of rebuttals. It's time up. Okay. Unfortunately, it's time up, so I don't get to ask my questions. It's time up for me too.
Thank you, Honor.
We thank both the prosecution and the defense for your submissions today. We will be letting
It is reality to the ground. What is going on there and then? Your Honor, the question of proportionality here cannot be an argument from the prosecution, because they have failed to establish how was it disproportionate. The soldiers shot in the air. And let me point it out to you that while they were firing, from the case file here, they were retreating. They were retreating. The prosecution failed to notice that. With that, Your Honor, I still say, with the count of directing civilian attacks and also the count of rape, they still lack the material element, they lack the moral element, and that, and henceforth, should not be considered.
Counsel, when does a civilian lose protection under international humanitarian law?
Thank you, Your Honor. May I refer that question to the...
Please.
Thank you, Your Honor. We would like to point to the court that whenever a civilian chooses to engage in a hostile manner, they can temporarily lose their status, disregarding the fact that they were not a part of any armed party, as long as they engaged, such as we see it in this case, and they fired first, which killed a guard and a truck driver, and then which prompted us, the task force, to retaliate while they are retreating to protect themselves. It is important to highlight that a civilian is not always going to be protected. Just because you are not officially belonging to an armed group does not give you the shield for you to go commit crimes and always claim, oh, I'm a civilian, I am protected, and I cannot commit crimes again. I cannot commit a crime. In this instance, the civilians having came with the intention to rob the truck, and then they saw the convoy, and instead of retreating, and the convoy was there to protect since they had been doing this, they chose to engage and try to grab the guns. And through that course, the soldiers took the action to first fire warning shots to try to disperse the crowd of those civilians. And from that crowd, those civilians shot to the convoy, which prompted the retaliation. And the soldiers have the right to self-defense as long as it is proportional. Regardless of which type of guns they are bringing, those guns were not brought for those civilians. They are brought for the security of the truck. And the civilians are the ones who chose to engage and disturb that security. And the soldiers chose to act accordingly to the situation on the ground. So that's why we want to establish that these civilians cannot claim that they are civilians due to their action being considered hostile in this incident of the 10th November 2014.
Thank you, Your Honor. I want to bring the notice here that we are in the pre-trial chamber. Your Honor, the prosecutors say that they are prosecuting the case here. No, we are here to beg the court to give us the permission to go ahead with it. We are not here to deal with who is the prosecutor and when. We are begging. That's one. Another one, there is no ordering of displacement here. There is no statement in the summary of facts of the case where they say General Vande ordered them. If I may say, there is no word he said, move. No, it's not there. There is, what is the meaning of ordering? Ordering, we should bring to the notice that ordering is whereby you take a stand and like, move. No, he did not say it was their own choice. They could have chosen to stay there, but they did not. They moved away. And the defense is calling it ordering. No, they are not ordering this. We rest our case.
Thank you very much. So it is time. The court wants to conclude today's hearing and will be communicated regarding the proposal.
Right.
University of Kigali will stay here and will be
The prosecution is allowed 15 minutes to present its main arguments. We are going to be very strict. Those 15 minutes will not be interrupted. The defense will also have 15 minutes uninterrupted to present its case. Then we'll have 10 minutes where the prosecution will provide its rebuttal. These 10 minutes will be interrupted by questions from the judges. The same thing goes to the defense. You have 10 minutes to rebut the prosecution case, within which the judges can ask you questions through interruption, so be prepared for that. One member of the bench will be showing you the time left. She will show you when you have 5 minutes, she will show you when you have 3 minutes, and when you have 1 minute. We are going to be extremely strict with time. Prosecution, over to you.
Greetings, Your Honors. Greetings to the Honorable Court. I'm Prosecutor 1, I'm Mr. Ramadan, and with me here today are prosecutors, Prosecutor Uwizeyimana Esther, Prosecutor Nizeyimana Magwa. I, as Prosecutor 1, I'll be prosecuting on count 1, which is war crime of intentionally directing attacks on civilians. Prosecutor 2 will be prosecuting on war crime of rape, and Prosecutor 3 will be prosecuting on war crime of ordering civilians. If it pleases the court, I would commence to the summary of facts. Buba and Omri are two major religions that have coexisted for centuries. General Gerard Vande is a top military senior officer in Tukanov Ministry of Defense, and he's a radical Buban, and other leaders who are radicals, and due to this, there was oppression of the Ombris, especially in Kuka, which is a Tukanovan province. If it pleases the court, I would ask to proceed to the common elements to all counts, which is the awareness of factual circumstances that established the existence of an armed conflict. With regard to on 30th August 2014, the President convened an emergency meeting in order to discuss the issue of that was taking place in Kuka. And he ordered the General to take care of this problem. As I said, there was a resistance movement that was called to the oppression of Ombris, which is Free Kukan Army. With regard to this, the General committed numerous atrocities that constituted violations under HL. With regard to the first element, to the nature of the conflict, the prosecution finds that Free Kukan Army, which was formed as an armed group, due to the oppression that they were being committed on them, we submit this as it is an armed group because they were fighting with state forces. And these armed groups, Free Kukan Army, is considered non-state actors. They have a responsible command because FKA had one, referring to the facts of 8 of the paragraph, they had a structure, command structure, where they had colonels. Second, they had exercise of such control, with reference to paragraph 9, where they took control of the territory. This showed that they had control over the territory. The third one, they were able to carry out military operations. They recruited women, referring to the facts of the case, they recruited women and men to join their cause. So this qualifies them as an armed group, thus this is a non-international armed conflict. Proceeding directly to the counts, to the elements of the counts, the prosecution finds that General, with regard to the first element, General ordered the leader of the task force to protect the convoy with all necessary means. And this meant, even if it means directing an attack civilians, killing 110 and got 30 injured. We find this attack violated the principle of proportionality because even according to rule number 14 of the International Customary Humanitarian Law, which says that launching an attack which may be expected to cause incidental loss of civilians, injury to civilians, damage to civilian objects. The principle, Your Honors, it was violated in two ways, Your Honors. In terms of weapon used, which was 50 caliber machine guns, and the anticipated results, which is the death of the civilians, 110 compared to 10 of the task force. It was a heavy price to pay. Now, with reference to the weapons used, underlined in this honorable court that this is not a submission of evidence, but rather a demonstration of the weapons that were used. This is 50 caliber machine guns that was directed to the 110 unarmed, harmless civilians. And this constitutes the violation to the principle of proportionality. And these were the convoy, the armored convoy, which were carrying the demonstration of it, carrying a 50 caliber machine gun. The prosecution also finds that the attack is prohibited under Article 13, Paragraph 2 of the Additional Protocol 2 to the Geneva Convention, because civilians as well as individuals shall not be an object of attack or threats or violence of military purpose, which is to spread terror among civilians. Also, it violated rule number 1 of the Customary International Humanitarian Law, which provides that distinction between civilians and combatants. The party to the conflicts must distinguish civilians and combatants. Also, with regard to the third element, that the perpetrator intended the attack, the prosecution finds that this attack was perpetrated against civilians because the general knew very well that there were civilians in this, that actually it should be referred to the facts of the case that General Gerard Vande, he was a shareholder. He had 19% in the Lannister Enterprise business. So he was carrying business operations. So as a businessman, he could not risk it anymore. Thus, he did this at the expense of 110 harmless civilians. Thus, this was directed to the civilians. This shows that he to do that because it was not satisfied with military necessity, but rather personal gains. With this regard, the prosecution, if it may please the court, I would like to call upon Prosecutor Uwizeyimana Esther regarding the war crime of rape.
My name is Uwizeyimana Esther Mohozi. I'm here to proceed with count 2, war crime of rape, as the second counsel on the prosecution. If it may so plead the court, I would love to fully express what was going on in this. Your Honor, people that were being raped here were the weakest physically soldiers in the tough. This could be your brother, your sister, it could be your cousin, it could be your mother. In the coercive environment that these soldiers were in, hearing shotguns every second, working tireless nights, cooking for their leaders, taking care of their wounds. Your Honors, these soldiers were in a very coercive environment. I would like the court to take 1 second and think about this. was raping these people. Their leaders, the people that they see as exemplary, the people that they look up to, the people that should be protecting them, Your Honor, are the ones that are raping them. Justice should be served. These people left their homes as patriots to come and fight for peace for their country. Instead, they're being raped. Now, you might ask, the person accused is General Vande. How does he come in this case? I will elaborate that. This man happens to be the leader of the tough troops. He was asked of the atrocities that were taking place by the reporter, and instead, he said, whatever happens during the free time of my soldiers is none of my responsibility. At this moment, he failed on his responsibility, Your Honor, to be a protector, to be a leader. Your Honor, according to paragraph 28 of Roman Statute, it is stipulated, allow me to quote this. Your Honor, it is stipulated that all crimes committed by the subordinates will be held liable to their leader. Now, the prosecution also takes an approach on the prosecution versus Bemba, whereby they had 6 elements that they followed as to when a military commander should be liable. All these are met in our case. Was the commander of the forces that committed the crime? Yes. Was he in a place to stop and prevent the crime that was taking place? Yes, Your Honor. This man, had he stood up out of his comfort zone and approached these soldiers who we knew fully followed his orders, this crime would not have been happened and we would not have been here. How is this man not going to be held liable? May justice be served to these young, physically soldiers that are patriots. Allow me welcome the third counsel to come with the third account.
I'm Zemana Diodone Magloire. I'm the third counsel on the prosecution side. Allow me to proceed with the count 3, war crime of displacing civilians under Article 8, paragraph 2E, Roman 8. In this case, the prosecution is basing on 4 elements provided by the ICC element of crime under Article 8, paragraph 2E, Roman 8, since the perpetrator ordered, number 1, the displacement of civilian. For this element, it is the prosecution finds that during Operation Blanc, there was an order of mass incarceration of Ombrians who refused to turn into Bubans between March and October 2015. More than 80,000 Ombrians were imprisoned due to their religion. This is to establish that the displacement really took place. But, my lords, who is responsible for this displacement? The prosecution finds that there is sufficient evidence that General Vande, the accused, is criminally liable for the displacement of civilians. This is based on the fact that General Vande posted articles on his blog that all Ombrians must be removed from the sacred Tukanovan territory. This clearly indicates his mens rea of displacing those civilians, as he didn't want them to in the area of Kuka. The prosecution, in the case of prosecutor versus Radovan Kazic, the court reiterated that the term forced from displacement is not limited to physical forces, but it can also be based on the
criminally responsible
fear of detention and psychological oppression. Due to this, the prosecution finds that this is enough to declare that General Vande is criminally liable for this crime of displacing civilians under the element 1, ordering the displacement of civilians. The element number 2 is that the perpetrator was in a position to effect such order. So this is evidenced by the fact that on August 30, the perpetrator, the President elect, declared martial law, and for this, the prosecution adopted the approach taken by Ernest Wenrip Killam that in the case of martial law, the highest commander is the one to have the power to make and enforce law in the area of the martial law. So the prosecution, based on this, to prove that he was in a position to effect such order.
As a relevant citizen here. It has a rational temperance because the time. The Rome Statutes came in force in 2002. The crimes we are talking about here are crimes that took place from 2014 and ended in 2016. Your Honor, it has the territorial jurisdiction because Tukanova signed and ratified the Rome Statutes. Your Honor, and that is under Article 12(1) of the Rome Statutes. Your Honor, it has the material jurisdiction. Under Article 5(c), we are talking about war crimes here, a non-international armed conflict. War crimes, there was killing of the people in those and there was rape as a war crime here. Your Honor, if it pleases the court, I would like to move directly to count 1. Your Honor, count 1 talks about the incident that took place on 10th November 2014. Your Honor, 110 people died. Civilians, emphasize the point of civilians. 110 civilians died and 30 were injured. Compared to what? Only 13 people from the army of the Tokanovan. Oh, it's so amazing. Hearty, Your Honor. Your Honor, to be liable under this article of 25(3)(b) of the Rome Statutes, one must have used his authority to prompt the commission of crimes. General Vandi, yes, he did. In Article 16, he told the leader of the task force to do what he can to protect that convoy. Telling people to do what they can to protect it even involved killing, involved commission of crimes as long as that convoy was protected. Even if 100 or 1,000 people died, as long as the convoy and the humanitarian aid that was being transferred was protected. Your Honor, I invoke the case of prosecutor versus the former president of Ivory Coast, Laurent Gbagbo, paragraph 242 and 243, where it supports that any use of the authority to prompt a crime, to prompt another person to commit a crime. Thus, we find that General Vandi is criminally responsible for this incident that took place on 10th November 2014. Your Honor, 110 people died. 30 civilians were injured. Your Honor, I'm questioning proportionality here. On the side of the Tokanovan army, only 10 and 3 truck drivers died. Really? When I talk about proportionality, I don't mean 5 plus 5.
The civilian death occurred as a result of self-defense. Now, honorable judges, allow me to refer you to the legal doctrine defined under the Article 31 B of the Rome Statutes as ground for exonerating criminal liability when the troops are acting in self-defense. Honorable judges, I refer you to the facts of the case in paragraph 16, where it is stated that the TFL soldiers reacted due to the provocation and attack and overwhelming of the 200 civil Ambians who attacked the convoy. Honorable judges, in fact, after the reporting of the main Ambian group that attacked, the convoy that attacked the convoy, the civilians being civilians is similarly questionable. According to the IRCRC Rule 5, honorable judges, I refer you to the facts of the case paragraph 16, where it is clearly demonstrated that those referred to as victims were the first one to shoot at the convoy. Notwithstanding, the action of the TFA soldiers was justified and legitimately so under the UN Charter because they were acting in self-defense due to the overwhelming of 200 Ombians who attacked their defense, who attacked the convoy and the truck. Honorable judges, General Vande should be exonerated and cleared of all discharge because his troops were acting in self-defense, meaning there was no intentions to kill civilian populations. Now, honorable judges, an attention is a mental element. Is a component that is to be proven for a person to be criminally responsible for a crime. Now, honorable judges, I refer you to the facts of the case paragraph 16 that clearly states that, and I quote, the TFA soldiers fired warning shots within the intention to disperse the crowd, not with the intention to attack the civilians, but to disperse the crowd, which was overwhelming to them. By the number that was referred to into this paragraph, there were 200 Ombians who attacked the TFA soldiers. Now, honorable judges, in reaction to this overwhelming and attack of civilian Ombians, these troop soldiers shot 2 shots for warning and for dispersing the soldiers. This clearly states the intention of the TFA soldiers was not to attack the crowd, but to disperse the crowd. And however, following these warning shots were fired at the convoy from the middle of the crowd. Shots were fired at the convoy from the middle of the crowd and killed a TFA soldier and a driver. And afterwards, the TFA soldiers returned fire immediately in self-defense. Honorable judges, if you are being shot at, these people who are being called civilians had arms, and they were shooting at the convoy and the soldiers. These people were clearly acting in an action of self-defense, as clearly as I mentioned above. Honorable judges, this proves beyond reasonable doubt that the intention was not to attack the civilian population, but to disperse the crowd and escort the Lannister truck to where it was supposed to deliver the humanitarian food and other supplies which was delivered. Now, without further ado, I would like to invite my co-counsel for charge 2. Thank you.
Honorable judges, I'm Darius once again. Kindly permit me to proceed with defense to count 2. It is alleged that General Vending is liable for the crime of rape and sexual abuse on the basis of common responsibility pursuant to Article 28A and Article 8 or Sub-Article 2E of the Roman Statute. Honorable judges, I'm here to provide substantial evidence and proof with legal documentation that General Gary Vending is not criminally liable for the rape and sexual abuse. Honorable judges, to further proceed, I would like you to understand the principle of dubio pro bio. In dubio pro bio implies, and I would like to straightly read it from this. And interestingly, this favors the accused and exonerate my client, General Gary Vending. The principle, which means that the court, the ICC here, which has the jurisdiction, shall in no way charge, neither convict when there is a doubt in terms of the guilt.
Which composed the Aubrey.
Clearly, it proved that there was a doubt. And in prosecution to that, honorable judges, I move further to give you details that there were 2 conflicting reports in accordance to Article 17 and Article 18. This report previously in paragraph 17, it implies that previously the Takofo Press gave a report indicating that the major reason for the existence of the immunity within the TAF2 was due to the fact that there was a disenchantment within the soldier, that there were no vigorous action taken in order to protect the integrity of the state. And in paragraph 8, it implied that there was another report which was contrary to the previous report after the immunity. And they stated that there was a sexual abuse within the TF2. Honorable judges, these conflicting reports bring a lot of questions to our mind as to which of them is void of politics and sentiment. This principle is justifiable enough to exonerate my client, General Gary Vendi. Honorable judges, I would like to proceed with the mens rea of this case. Okay, the mens rea in this case entailed that there was no material element for the existence of this crime. If you are telling her that there existed what we reference as rape, there should be justifiable reason that actually rape and sexual abuse was perpetrated. Honorable judges, these reports are not in alignment with one another and it clearly contravene one another. Honorable judges, I would like you to understand the fact that there should be an expert assessment in terms of cases with rape and sexual that should be justifiable so that this act can actually be qualified and referred to as a rape crime. But in this case, there was no clear justification that it actually existed. It implied that this action of rape actually never existed. These are all hearsay evidence and presumption that there was an existence of such crime. Honorable judges, to give a clear demonstration, I'd like you to reference to Article 42 of the Rome Statute, which required that this competent court, in cases of such kind of rape and sexual abuse, have the right to hire legal experts who will be able to provide reason that there existed this. Honorable judges, on this basis and legal count, I would like to submit that General Gary Vendi is not criminally liable on a common responsibility for the commission of rape and sexual abuse. I'd like to submit and call on my co-counsel to proceed with charge number 3.
Honorable judges, as mentioned, I'm Counsel Kelly Uineza. Allow me to proceed on the defense to count 3 by asserting that General Vande did not commit a war crime of displacement of civilian population. Honorable judges, pursuant to Article 8, Sub-Article 2E, Roman 8 of the Rome Statute, General Vande has been accused of mass displacement of civilian population. Pursuant to Article 25, Sub-Article 3A of the Rome Statute, General Vande has been accused by prosecution on the basis of individual criminal responsibility. Honorable judges, allow me to defend this based on the grounds of the crime. The first ground of the defense, I will demonstrate that General Vande acted on superior orders. Honorable judges, allow me to refer you to paragraph 12 of the fact of the case, where the president gave clear instructions and an order to General Vande to undertake the military operations that lead to displacement of civilian population under crush Umbrian terrorists by all means. This marks that this was an order from President of the state. Honorable judges, pursuant to Article 33, Sub-Article 1 of the Rome Statute, which say that a military or civilian shall not relieve the person of criminal responsibility was under legal obligation to obey order of government or the superior in question. Honorable judges, pursuant to Article 8, Sub-Article 2E, Roman 8, General Vande should therefore be relieved of criminal liability. Honorable judges, allow me to proceed on ground 2 of the defense, where I will demonstrate the lack of mens rea to exonerate General Vande. Honorable judges, allow me to refer you to paragraph 21 of the fact of the case, where it indicates when more than 80,000 Umbrians were detained due to lack of time to attend Buba classes as it was ordered, most of Umbrians fled from those areas for orders that implicated to them. So they fear for detention. It is clear that the displacement of civilians occurred without an order that implicated them to do so. Honorable judges, Pursuant to Article 8, Sub-Article 2E, Roman 8 of the Rome Statute, it requires that accused must have ordered the displacement of civilian population for reasons related to the conflict. Honorable judges, an order cannot be implied, but must be an open statement that compels a person to do something. Honorable judges, the charge should be dropped and General Rwanda be exonerated from the alleged crime. Honorable judges, having presented the defense to the 3 counts and provided the grounds, allow me to proceed to present the prayer of the defense court to the court. Pursuant to Article 61, Sub-Article 7B of the Rome Statute, the defense hereby submits to the court to decline confirmation of all the charges and declare as follows: that General Rwanda is not criminally liable for war crime of intentional killing of civilian population, that General Rwanda is not criminally liable for war crime of rapes and sexual abuse on the basis of commander responsibility, that General Rwanda is not criminally liable for war crime of causing mass displacement of civilian population. Thank you, honorable judges.
At hand, General Rwanda knew nothing. Your Honor, the words of General Rwanda were to protect the convoy, not directing the attack to the civilians. Your Honor, we would submit to this court that the court interprets the language of General Rwanda, because this order should be interpreted strictly, not in a way of analogy. We also require this court to examine whether the order of Rwanda in substance was illegal. Protect the convoy by necessary means. I see no illegality in this concept. So we submit to this court to declare this order of General Rwanda legal. If it pleases the court, honorable judges, I would like to call upon my co-counsel to proceed with the defending the second.
Thank you, honorable judges. I'm Counsel Jan Kodigo, and I'm going to be replying to the second count. General Rwanda is not liable under command responsibility provided under Article 28, alinea A, under the Rome Statute for the war crime of rape punishable under Article 8, subparagraph E, alinea 6 of the Rome Statute. If it pleases this honorable court, I would like to demonstrate to this court how the elements of rape as a war crime have not been established, and how the elements of command responsibility have not been established also. Your Honor, in pursuant to the Kunara case against prosecution, in paragraph 1 to 7, the trial chamber held that the actus reus of rape as a war crime entails that the perpetrator invaded the body of the person by penetration, and the invasion must be committed by force or coercion. Pursuant to Article 64, paragraph 9 of the ICC statute, which provides for the court to rule on admissibility, the defense submits that there is insufficient evidence to prove that elements of this crime are fulfilled. The prosecution, based on uncorroborated evidence from a press release in The Guardian and an NGO report, Human Rights Watch, from the Human Rights Watch, cited anonymous. On this matter, this very court, in the Katanga versus prosecution, the court held that this kind of evidence is deemed to be unreliable since it is hard to establish its probative value. Honorable Judge, since the evidence brought by the defense lacked any authentication to confirm that it was not manipulated, no indication to the one who wrote it, and the motive behind it, its credibility as evidence is thus challenged before this court. Honorable Judge, moving to the charge of the count of charging General Rwanda under command responsibility, the defense admits that the elements entailing command responsibility are lacking. For element entail command responsibility, the military commander should have known that the forces were committing or about to commit a crime, and failed to take necessary means to prevent or punish the crime. The commander knew, in regards to the point where the commander either knew that his opponents were committing a crime or about to commit a crime, basing from the facts of the case, General Rwanda was not aware that this crime has been committed, just the fact that he wasn't deployed with the deployed soldiers. Moreover, when he came to visit the mutiny, when the mutined soldiers were expressing their grievances of corruption, no one came up and said we are being sexually abused. This further raises suspicion on the evidence brought before the court that there was even any rape. Moving forward, General Vande was a chief of defense staff, meaning due to his location, he is headed at the headquarters of the Turkana Army. There is no way he could have been aware of the crimes that were being committed. This was also provided in the Vemba case, where this very court decided that there are some factual elements that need to be taken into consideration to assess whether the commander knew that the crimes had been committed, the location, and the number of the forces. As I said, General Vande, as the chief of staff, and as indicated, he came to visit the meeting. It further indicates that he wasn't based with the army, so there is no any other way he could have known if it wasn't reported to him. Moreover, depending on the number of forces he was heading, it can't be proved that he would have known what is happening in one specific battalion that was deployed in Kauka when no one further reported this incident. Moreover, the defense further submits that General Vande did not fail to take necessary measures to prevent or suppress this commission or submit the matter to competent authority. As submitted, since General Vande lacked knowledge of this crime, there is no way he could have prevented it or could have punished the crime. Thus, due to this, it's with this regard that the defense submits that due to lack of knowledge and lack of elements establishing command responsibility, General Vande shouldn't be held liable under this charge. I would like to call upon my counsel to proceed next.
Your Honors, my name is Monisha Adikari, and I am going to proceed with defense on the third count raised by the prosecution. That General Vande, where the prosecution is alleging that General Vande is individually liable for ordering the displacement of civilian population without reasonable justification. I'm going to show this court that the elements of this crime are missing. Moreover, this
crime that is psychological, or I needed precision on that.
Oh yes, thank you, Your Honor. The precision comes on the fact that the acts that were being done by the subordinates of General Vande were after the orders that he made. Your Honor, if I believed in a certain religion and I was being forced to believe in another religion, and my fellow believers, 800 of them are being put in prison, there's no way I'm going to stay in that place. I'm going to flee to save my life. So of course there is an oppression leading to them fleeing due to fear. When a command is set and you have no genuine way of running out of it, you have no other way but to run away from it, and this can be classified as oppression.
I have a question for your first counsel. We've heard from the defence in relation to count 1 that the defence's case is that the people who were engaged in the gunfight were acting in self-defence under Article 30, and that would be a lawful defence under Article 31 from the Rome Statute. What do you say to that?
Thank you, Your Honor. With regard to the count 1 of the defense, that the soldiers acted in defense, the prosecution submits that they did not, because there was violation of the principle of proportionality, as this was intended, as it was stated in the facts. This was new that even way before that they used to march into the FK-controlled areas and their convoy could get attacked. And this was cited by Mr. Lannister. He said that despite our recent attacks against Lannister Enterprises truck, will continue into marching into FK territories. Thanks to General Vande, the TAF has agreed to protect our trucks, and yet they marched with 50 caliber machine guns. They knew well that the civilians were the ones who were attacking these troops, but then they took heavily guarded weapons to face these civilians. As I stated earlier, this General Gerard Vande, his shareholder of Lannister Enterprise. He holds 19.
I'm going to just interrupt you there because I remember you already making that same statement in your submissions. What is the difference between the principle of proportionality as a defense, encompassed within the defense of self-defense, compared to the principle of proportionality under the rules of the conduct of hostilities under IHL? And which of these tests should we be looking at here?
The prosecution submits that the principle of proportionality that is being looked at here is the one in the hostilities.
See, I'm not sure that I agree with you, and this is a point we've already addressed before. Have you got the elements of the crime in front of you?
Yes.
Where in the elements of the crime is the principle of proportionality incorporated?
Thank you, Honor. May I consult my...
You may. Well, actually, no, you need to answer right now because otherwise your time is up. Council, if you don't have a reply, we're going to have to finish it now. Your time is up.
Thank you, Honor. Sorry, is the time?
If you've got 2 sentences to address the question.
Your Honor, the principle of proportionality is not included into the elements,
right.
But the acts, these elements, they violated the principle.
Okay, thank you.
Law enforcement and law enforcement operation, and it should be considered to be unrelated to be related to human rights issues. If it pleases the court, I will end by making the prayers of the defense that based on the arguments advanced and authority cited, as well as the cases cited before this court, that General Rwanda should not be held liable because there is no sufficient ground to believe that the displacement truly happened. Moreover, the constitutive elements of these crimes are lacking, and the establishment of criminal liability is therefore lacking. Thank you so much.
Thank you. We are now proceeding with the photo from the prosecution. If you have 10 minutes.
Thank you, Your Honor. If it pleases the court, I would like to respond to the issues raised by the defense on count 2 with regards to General Rwanda's command responsibility and command responsibility. Your Honor, 2 things involved here, and I'd like to point out to the court that the defense is in between the lines. One, did the general know that this was happening or not? The defense came up and said that the General Rwanda could not have had the knowledge, that he could not have known that these crimes were going on, and then went on to say that because of the geographical location of the general, he was not in place to know. And then went on and said that he visited the place where the meeting took place. From that place where the meeting took place, the investigative journalists went there. When they went there, they discovered atrocities that the rapes that were going on. They went back to report to him. How could he have not known after all that information? Later on, the defense said that General Rwanda could not have known because first, it was the geographical location. Second, it was dismissing the report. The defense needs to stand on one leg. Did he know or did he not? Is it because the report was credible or because it was not? Because we are lost on where you base where the defense bases their argument. Did the general know that his sources were committing the crime of rape or not? Yes or no? Did the general was he dismissing the information because it was because the source was not credible? Yes or no? So at this point, we still submit to the court that this information, whether General Rwanda knew or not, and it fulfills material 1 of knowledge of what was going on, whether General Rwanda knew or not, it is established that he knew. He knew because he was told by the Human Rights Watch
which is being dismissed now as an NGO. It also brings into question whether NGOs...
Before you proceed any further,
yes.
According to what the defense has advanced,
yes.
we want to establish that in case the investigative journalist, like you're arguing, did not inform, in case it's established that he did not inform him, or in case he did not know, there's no source that he was informed about it. Would we establish under the concept of command responsibility, would we waive his responsibility over the rapes that occurred?
Over the rapes, thank you, Your Honor. I would like to submit to the court that it would have not fulfilled the two elements. The key element one is that the commander had effective, the element number three, he had the knowledge that it was going on. Number one, those who did it were under his control. Those are two key elements for this crime to be established. And by establishment here, I mean, was it the chief of command? Was it the chief of defense of staff? Yes. Was it the strategist? Yes. Did he make decisions? Yes. Was he in charge of them, of his subordinates? Did he have a duty and responsibility towards his subordinates? Yes. And what happened? When they committed crimes and he was brought up to knowledge, he said, what happens to adults is not my responsibility. I do not care. That's what he invoked. He did not at any point deny that this was going on. He said, what happens between them in their free time is not my problem. Your Honor, with this we submit that the material elements of this crime are established and the court should hold this crime, the crime should stand. And General Rwanda should be held on criminal liability and for command responsibility.
Also, can you elaborate the reason why the prosecution has qualified this armed conflict as a non-international armed conflict and the prison relevant to the facts?
Okay. I'd like to refer that question to the person, Marisa.
Thank you, Your Honor. This case is a non-international armed conflict because of the gravity. The gravity. We see crimes happening. Case count 1 talks about the death of the civilians, rape as a war crime, and then displacement of people. These cases give it that power to qualify as a non-international conflict. Second, the time frame. We are not talking about a day issue here. We are talking about 2 years, Your Honor. Thank you.
Your Honor, in addition, I would like to supplement her arguments on the fact that we qualify it as an international armed conflict due to the fact that the fighting going on is between the army of the Tucano TAF and the FKA, which is an organized armed group.
Can you please describe the intensity and the organization of the conflict?
Yes. So under intensity, to establish that the armed conflict is going on
ecology, the psychology involvement of General Vande. That's our case here. And in response to the first count, honorable judges, can I proceed to the first count? So they say that the prosecution stated that these people were civilians who were killed. And I mentioned in my defense submission that it is questionable for them being civilians. And I will call that in the rules of the international humanitarian law and rules under relating to the conduct of the hostilities on the regulations respecting the laws and customs of the war on land. In section 1, chapter 1 states the qualification of the belligerents. As we all know, the belligerents are the fighters in the war, are the combatants. And now in Article 1 state that the law and rights and duties of war not only apply to armies but also to militia and voluntary corps fulfilling the following conditions. The first condition is to be commanded by a person responsible for his subordinations, and as we all know, these FKA people, they introduced this armed rebel and appoint themselves as colonels and captains.
I'm going to interrupt you just because we haven't got a lot of time, and there is a question that I want to ask in relation to count one. Yeah. I'm going to go to your submission in relation to self-defense from Article 31, 1B of the Rome Statute, 1C. The requirement of self-defense requires that the person acts reasonably to defend him or herself. And I'd like you to comment more on the requirement of reasonableness in relation to self-defense, and in particular noting that as a consequence of the response by the arms bearer at that time, 110 civilians were reported to have died out of 200 that were present on the scene. Those seem like huge numbers, and I'd like to hear your case as to how the killing of more than 50% of the people in that space was reasonable under the principle of self-defense.
Honorable judges, in inquiring to your questions, I would like to state that the TFA troops who reportedly killed the civilians, they really knew that the civilians were not civilians. They were belligerents of the war. The question here is civilians not actually being civilians, because the first shot fired and killed the TFA soldier and the truck driver was from in between the crowd. So in exoneration of my client and his troop, I think, how can you differentiate between a civilian and a person attacking you, because they were all armed? They were armed. They fired back to the shots which were fired to them. And the fact that the TFA troops were really trained well to be able to defend themselves, I don't think that can exonerate my client as being responsible to the killing of civilians, being reasonable to the fact that these civilians are not really civilians. As I was mentioning above, the necessity which they were not really civilians, they were carrying arms. Otherwise, if they were not carrying arms, how do you define those shots which were fired to the truck and the TAF and the Lannister trucks?
It's unfortunately time. Thank you to both the prosecution and the defense. The bench, the trial chamber will actually give its decision, and we'll let you know when the decision will be made in due course. We thank both of you.
I would like to bring the attention of this court that the prosecution, based on unprovided facts within the case fact, in their arguments they say rape was used as a form of punishment and torture. Honorable judges, by referring to the facts of the case, there is no way it is written that rape is used as a form of punishment and torture. That is what I continue basing on, that they are formulating their own facts. Moving on the issue of whether General Vande would have been aware that crimes were being taken place. No, there is no way General Vande would have had the knowledge to establish that the crimes were being taken place. Due to the number of the forces that was in charge of as the chief of defense, due to the location of where he was when the crimes were alleged to have taken place, and due to the fact that when he came to visit the meeting, no one stood up while they were talking about the experiences of corruption and all the wrong things that happened in the meeting. No one spoke out that you are being sexually abused. So this further indicates that what the prosecution is alleging could even have happened, since no one came outright to report it. Moreover, General Vande couldn't, based on the allegation of the press meeting, when even effective commander, his nearby commanders never reported to him, when the alleged victims never went outright to report to him. So the defense further submits that General Vande was still carrying out investigations until the arrest warrant was being served of these alleged crimes, because up to now, no one had come forward to provide any information that would be reliable that indeed these crimes were taking place. It is on these grounds that the defense continues to further submit the elements that establish this crime are lacking, and the elements of command responsibility are lacking. Since there is no way he could have had the knowledge that the crimes were taking place, and since he lacked the knowledge, there is no way he could have prevented or punished that crime.
Do you want to submit to this court that General Vande had no effective control?
It is uncontested that he had effective control over his troops. But the other two elements that constitute command responsibility are lacking, such as the knowledge of when the crime has been committed and the ability to prevent and punish the crime, since he lacked any knowledge of the alleged crimes. That is what the defense says.
Counsel, you still uphold your position that General Vande cannot be held criminally responsible for rape of his subordinates.
He can't be criminally responsible since the elements that constitute human responsibility are lacking, such as the knowledge, which is a very crucial element. Because if he lacks the knowledge, then how can you punish anyone? Or can you repress anyone if there is no one, if there is no basis? He can't go around punishing people over an investigative report from the Guardian, Your Honor. It had to be corroborated by witnesses. It had to be corroborated by those alleged victims that the prosecution keeps submitting to this honorable court. The defense wants to call upon, I want to call upon my co-counsel to continue with
Thank you, Your Honors. What is stated before the court is what is given verdict. Therefore, if it was stated that it was Article 7, then that's what has to be given the gravity. But moving from that element, prosecution has accepted that the subject matter of this case are war crimes. And as we have already mentioned, war crimes requires an order to be made. That requirement of order was declared by this very court by the ICTY court in the Katovina case, that it is a crucial element to account for the order. Defense still submits that the substance of the order is what is supposed to be given gravity. Prosecution is deriving their charges from events that unfolded in the armed conflict. However, the prosecution is basing their charge of displacing people from an event of ordering to detain. And until this crucial object of the order is meant to be the displacement, then the crime cannot be held liable against the accused. Defense rests.
The hearing is concluded and you'll be duly communicated on the pronouncement of the verdict.
Good afternoon. Court is called to order. Prosecution, you have 15 minutes to make your submissions, your main submissions. Those 15 minutes will not be interrupted, but will be very strict. One of the judges will keep showing you both prosecution and defense. The minutes that you have left, she'll show you when you have 5 minutes, she'll show you when you have 3 minutes, and she'll show you when you have 1 minute. So look out for her papers showing you those minutes that are left. Defense, you'll also have 15 minutes. Will be strict, uninterrupted. And then we'll have 10 minutes each for rebuttal, which will be interrupted by the judge's questions. Prosecution, over to you.
Honorable judges, I am Darius Nessa Davis, the lead prosecutor, and I'm here along with 2 co-counsel, and they are
I'm Councillor Kelly Uwineza.
Councillor Esther Ingabide.
Honorable judges, it is much important and significant to give the classification of the conflict as it relates to the case. Honorable judges, as per classification, the current conflict as per the case is classified as a non-international armed conflict. Honorable judges, I would like to refer you to paragraph 2 of the fact of this case, which entails that the conflict existed between a sovereign state and an organized armed group. Honorable judges, according to paragraph 1, subparagraph 2 of additional paragraph 2, it entails that conflict of such nature is qualified as a non-international armed conflict, holding to the fact that it existed on the territory of the state, which is the higher contracting party. Honorable judges, there are 3 charges which the accused is charged of today, and they are: 1, ordering and soliciting of direct attack against civilian population; 2, is rape and sexual abuse classified as a war crime; and 3, mass displacement of civilian population. Honorable judges, the accused today is General Gary Vendi. He is a Bumben by religion. He is the highest and most senior officer within the TAF2. Honorable judges, he advised the president regarding the operation of military attack. Honorable judges, I would like you to understand the fact that the competent court has jurisdiction on this case. The ICC has jurisdiction on the current case in pursuit to Article 5, Article 13, and Article 25 of the Rome Statute. With this being said, honorable judges, I kindly submit and call on podium my co-counsel Esther to proceed with charge number 1.
Honorable judges, I'm Councillor Ingabire Esther, presenting the first charge. Now, General Vance is charged with the intentionally directing attacks against the civilian population in pursuant to Article 8, Sub-Article 2, Roman 1 of the Rome Statutes. It is on the basis of individual criminal liability that we base our charge today, pursuant to the Article 25, Sub-Article 3b of the Rome Statutes. Honorable judges, allow me to proceed to the actus reus, where I will be demonstrating the evidence of killing of civilian population. Now, honorable judges, I would like to refer you to the facts of the case, paragraph 16, where it was reported by the local media that 110 civilians were killed and 30 injured during this incident. This is evident enough to serve as evidence that there were active killing of civilian population. Honorable judges, allow me to proceed to the mens rea, where I will be demonstrating the manifestation that General Vande internationally directed attacks. Now, honorable judges, I refer you to the facts of the case, paragraph 16, where General Vande was aware or in a position to know that there was previous attacks against the Lannister Enterprises, hence to him being the 15% shareholder of the Lannister Enterprises and a good friend to Mr. Lannister, who referred to him as a hero and as a role model to the youth Bourbons. Now, General Vande's involvement in the Lannister Enterprises is an indication that the supplies by the conflict was more business related than humanitarian support. Honorable judges, according to the Article 30, Sub-Article 3 of the Rome Statute states knowledge as means awareness that a circumstances occur or a consequence will occur in the ordinary course of events. Now, honorable judges, I refer you to the facts of the case, paragraph 16. General Vande was aware or in a position to know that there were previous attacks against the Lannister Enterprises. Honorable judges, he then ordered the leader of the TAF soldier, the leader of the convoy, to protect the truck by all means. Hence, which in return induced indiscriminate attacks against the UN against the unarmed civilian, Umbrian civilians. Now, honorable judges, according to these facts, it is from the above grounds that the prosecution bases and submits to the court that General Rwanda is and should be held liable for the charge of intentionally killing of civilian populations. Thank you. I would like to invite my co-counsel on the second charge.
Honorable judges, I'm Darius Davis once again. I'd like to proceed with charge number 2, and the charge read, war crime of rape and sexual abuse. On the basis of common responsibility, General Vendi is charged with crime of rape and sexual abuse in relation to the true deploy and the Kuka preference. In pursuit to Article 28A of the Rome Statute, this qualifies this case as a war crime. The crime of rape is considered as a war crime in relation to Article 28A of the Rome Statute. Honorable judges, Article 8, Sub-Article 28 of the Rome Statute, it qualified this case. With this legal element, it clearly proved that General Gary Vendi is criminally liable in relation to the commission of war crime of rape and sexual abuse. Honorable judges, I would like to proceed with the actus reus of this case. I would like to reference you to paragraph 2 of the fact of this case, honorable judges, which entails that there are sufficient evidence provided by the investigatory journalist that imply that the sole reason and purpose for the commission of the immunity within the TAF was due to the fact that there existed sexual abuse and rape within the TAF too. Honorable judges, there was another corresponding report to this report previously, which was provided in paragraph 18 of the fact of the case. It implies that there existed a system of sexual predation, which was reported by the Human Rights Commission. Honorable judges, with these two evidence that are corresponding in conformity with one another, it clearly indicates that there existed the crime of rape and sexual abuse. With the mens rea being established, honorable judges, with the actus reus being established, honorable judges, I would like to proceed with the mens rea, which attribute the crime of the TAF2 to General Gary Vendi. Honorable judges, according to paragraph 20 of the fact of the case, under the Takuva law, General Gary Vendi, he is the senior most officer within the TAF2. He advised the president in relation to military operation. You can understand that he had command responsibility allotted to him in this paragraph. Honorable judges, according to Rule 153 of the ICRC International Customary Law, I would like to read that to you very clear. The law entails that commanders and superiors are criminally responsible for the crime committed by their subordinate if they knew or had reason to know that the subordinates are committing a crime and they fail to provide prevention within their power. Honorable judges, to illustrate that General Gary Vendi actually knew that there existed this immunity, when he was asked on the general television regarding the rape and sexual abuse within the TAF2, he clearly stated that, my subordinates, they are all adults. I'm not responsible for their actions within their, what we reference as their free time. That's what he referenced. And he said that the only responsibility as a commander was to give direction and strategy in retaliation to terrorists. Honorable judges, this clearly implied that he knew and had intention of this, and to relate this to him individually again for command responsibility, the fact that there existed a system of sexual predation that gave relevance to the higher ranking officer and the most combative senior officer within the kill, it gave him a motivation that his action, an intention to combat civilians was actually being portrayed. So he knew the reason why. Honorable judges, with this evidence being proven and given legal documentations in regard to that with provision, I kindly submit and call on my co-counsel who will be proceeding with charge number 3. Thank you.
Honorable judges, allow me to proceed on charge 3, war crime of displacement of civilian population. Honorable judges, pursuant to Article 8, sub-Article 2E, Roman 8 of the Rome Statute, General Vande is charged with criminal responsibility for displacement of civilians in an international armed conflict, and for reasons related to conflict, not for security for civilians. Honorable judges, pursuant to Article 25, sub-Article 3A, General Vande bears individual responsibility. Honorable judges, allow me to proceed on the grounds of this crime. Honorable judges, for the first ground, which is actus reus, I will demonstrate civilian displacement. Honorable judges, allow me to refer you to paragraph 21 of the fact of the case, whereby under Operation Blank, Umbrians were forced to convert to Buba religion. Civilians who failed to comply were detained. Honorable judges, pursuant to Rule 129 of ICRC, customary international humanitarian law, it prohibits ordering displacement of civilian population. Honorable judges, allow me to proceed to second ground mens rea, where I will demonstrate the commission of the crime whereby General Vande was chief architect of such displacement. Honorable judges, allow me to refer you to the paragraph 19 and 20 of the fact of the case, where General Vande ordered to flush all residents and forcing Umbrian to convert to Buba religion. Honorable judges, those acts are contrary to Rule 104 of ICRC, customary international humanitarian law, which guaranteed the respect of civilians' convictions and religious practice. Honorable judges, having presented the three charges and proven the element, I now proceed to present the prayer of prosecution. Pursuant to Article 61 of the ICC statute, the prosecution hereby submits to have adequately proven the legal, material, and mental elements for each of the charge. The prosecution counsel prays to the court to adjudge and confirm the charge as follows: that General Vande is criminally liable for war crime of intentional killing of civilian populations, that General Vande is criminally liable for war crime of rapes and sexual abuse on the basis of commander responsibility, and that General Vande is criminally liable for war crime of causing mass displacement of civilian population. Thank you, honorable judges.
Thank you to the prosecution. Can we hear from the defense? You also have 15 minutes, very strict timelines that must be respected. Thank you.
Honorable judges, opponent side, and the audience, good afternoon. I'm called Lisa Ange Ishimwe. I'm the first counsel from the defendant, and I'm with Nancy Uwase, the second counsel, and Omohoza Janvier, the third counsel. As the first counsel, I'll give the overview of the case, jurisdiction and nature of the conflict, and the inadmissibility of the case. The second co-counsel will continue with the count 1 and count 2, while the third co-counsel will continue with count 3. The case at hand concerns General Vande, who was the chief of staff at the time. General Vande is alleged of crimes committed between 25th March 2014 to 28th January 2016. Although the prosecution advanced that General Vande is alleged to have committed war crimes, the defense finds the fact in the case that this was only an internal disturbance, there was no armed conflict. Your Honors, if it pleases the court, allow me to show how this court doesn't have the jurisdiction over this case. In accordance to the rational martiae, the ICC has no jurisdiction to this case. Pursuant to the Article 1, Paragraph 2, in additional Protocol 2 of the Rome Statute, ICC has no jurisdiction of internal disturbance, riots, and others. On the basis of the practical guide of humanitarian law, internal disturbance is defined as the situations which are serious or lasting internal confrontation, which do not necessarily escalate to open struggle. And the authority may use large policies and even the armed forces to restore the peace within that country. Your Honors, in this case, the confrontation, of course, was serious, and it lasted from 25th March 2014 to 28th January 2016, which confirms that it was an internal disturbance. There was also no open struggle. Your Honors,
In this case, as there was no open struggles on paragraph 8, the Tukanov soldiers, along with the police, were just only trying to restore peace in their country. There was no open struggle. There was no continuous attacks in this case, Your Honors. The crimes committed were just ordinary crimes, and will request you to put it in the ordinary court. Your Honors, for that reason, the defense finds the case not to be under the jurisdiction of ICC. If it pleases the court, allow me to go to the inadmissibility of this case. Pursuing Article 17 of the Rome Statute on the issue of inadmissibility, the case must be inadmissible when it fulfills this criteria I'm going to talk about. It should have been investigated, Your Honor, or prosecuted by a state which has jurisdiction over it. Your Honors, on paragraph 8 of our case, on 28th November 2015, shocking stories broke over Washington Post. An employee of the Tukanov Intelligence Bureau, which was investigating the conflict which was happening from 24th March to 28th January 2016. That confirms how this case have been investigated before it came here. Also, in the case of the prosecutor versus Francis Kirimi Mahuru and also Uhuru Mongai Kenyatta and Mohamed Ali Hussein, they defined well investigation. Investigation is taking steps directed at ascertaining whether this individual is responsible for the conduct. Your Honors, in this case, the Tukanov Intelligence Bureau tried to find information about the conflict which was happening. As the defense side, that is why we see that this case is inadmissible to this court. The case also to be admissible in this court, it should have sufficient gravity to be taken to the ICC. Your Honors, as it was shown in the case of prosecutor versus Lubanga, to meet the gravity, the object of the case should be committed on a large scale. Your Honors, I want to draw to your attention that this conflict was not on a large scale. It was only a conflict which was committed, which was happening between the government authorities fighting against a simple armed group in a certain part of the country to restore peace in their country. This was no armed conflict. That is why, as the defense side, we found this case not to be admissible to this court. Your Honors, our client, General Gerard Van Dey, is alleged to have committed the following crimes, which my co-counsels are going to talk about. Count 1, war crime of ordering attacks against civilians. Count 2, war crime of rape. Count 3, war crime of ordering displacement. Your Honors, if it may please the court, allow me to let my second co-counsel to prove the innocence of our client. Thank you.
Thank you, Honorable Judges. My name is Counsel Uwase Nancy, and I'm here to defend our client, General Gerard Van Dey, under count 1, which states that General Gerard Van Dey is not criminally responsible under Article 25, Paragraph 3b for the war crime of directing attacks against civilians under Article 82E Roman 1 of the Rome Statute. Honorable Judges, according to the facts from the case, Paragraph 16, I quote him saying that before the departure of the TAF task force, he received an order. He received an order to protect the convoy with all necessary means. Honorable Judges, our client is not liable for the war crime of directing attacks against the civilian because he only directed them. He ordered them to protect the convoy. Honorable Judges. So the material element of this crime is not present because he only ordered them to protect the convoy. And again, according to the precautionary principle, Honorable Judges, before the soldiers did not attack the civilians, 200 local Ombrians came out nowhere. They outnumbered the tough soldiers and tried to attack them. So, as the precautionary principle says, they fired shots in the air, trying.
Counsel,
yes?
Can you slow down a bit? The court registrar cannot follow what you're
Okay,
saying.
Thank you. So, under the precautionary principle, the tough soldiers, outnumbered by the local Ombrian civilians, on 10th November 2014, they were outnumbered by the local Ombrians. They fired shots to disperse them as a precautionary principle. But instead, they received an attack from them, which led to them to defend themselves. So our client, General Gerard Van Dey, is not liable for ordering an attack against civilians because it did not happen. Thank you.
allow me to continue drawing facts from the case of prosecutor versus Radovan, which says that the court held that for the mens rea requirement of this crime to be fulfilled by the prosecution has to prove that the perpetrator was aware or should have been aware of the civilian status of the persons attacked. Honorable judges, when General Vande was giving out orders, he wanted them to protect the humanitarian convoys, which was going to take food and all necessary things which are required for the Bubans who were in the FKA-controlled areas. He was not directing the attacks on the civilians. He just wanted them to protect the convoy from the FKA combatants. But from...
Council, can you please slow down so that the registrar can understand and take down what you're saying?
Okay, sorry. So continue from there, he was not aware that the civilians were the one who were going to be attacked. So the mental element is lacking here, and the prosecution is required to show us the mental element which is showing that General Vande was aware that they were going to attack the civilians. Because for him, he just ordered his convoys to protect the convoy from the FKA combatants, general judges. So we find General Vande, he is not criminally responsible under Article 25, 8b, for ordering the crime. He is not individually criminally responsible because we draw facts from the case of prosecution versus Mirosevic, paragraph 270, whereby Mirosevic ordered the military campaign, but according to the appeals chamber, they further concluded that there was no basis for the conclusion that he planned and ordered the crimes on the ground that occurred from the military campaigns, which goes hand in hand with our case right now, where General Vande only ordered the convoys to be protected. But the crimes which were the outcomes, they're just the outcomes because they were defending themselves. So he's not individually criminally responsible for the war crime of attacking the civilians who were not taking very part in the hostilities. Honorable judges, allow me to continue with count 2, which says that my client is not individually responsible for the war crime of rape under Article 82E Roman 6 and sexual abuse within troops in Kuka province based on command responsibility under Article 28. Honorable judges, it was alleged by the prosecutor that General Vande is individually criminally responsible under command responsibility to stop acts committed by his soldiers, but he is not individually criminally responsible because, honorable judges, the rape soldiers were within the tough soldiers. They are within the troops of General Vande. They are within the camps. So here we have seen that the conventions of the 12 August 1949, Geneva Conventions, they do not provide for us. They're nowhere that they're mentioned that within these troops, the people of the same armed forces, there's nowhere that it mentions that they have to be protected, honorable judges. So it was not benefiting the TAF. It was not benefiting the TAF to cause defeating the FKA. Therefore, it is an ordinary crime under an ordinary court. And honorable judges, he was not aware because he's not liable because of the material ability. He had effective control, but at that time, the material ability was not present because he was at the battlefield and the crimes were being done in the free time. Honorable judges, allow me to present the mic to my co-counsel to continue with count 3. Thank you.
If it may please the court, your honorables, allow me to defend my client, saying that our General Gerard Vande is not individually criminally liable for ordering the displacement of civilian population for reasons related to the conflict unless the security of civilians involved or imperative military reasons so demand punishable under Article 82E Roman 8 based on committing crimes whether as an individual or jointly with another person under Article 25 3A of the Rome Statute as it was alleged by the prosecution. Your honorables, the elements of this crime are not satisfied. The prosecutor has the duty to prove beyond reasonable doubt that the elements of the crime committed, like linked to the crime that you're alleging our client, there was no order of displacement, your honors. She didn't tell the subordinates to displace the Umbrians from this place to this place or from this organization to this organization. Only the only thing that was done was to get back the FKA-controlled areas as their main goal of General Gerard Vande. They saw the Umbrians so wanted to go back to Akova, and they went willingly. No one forced them to go, your honors, your honorables. Drawing from the fact, paragraph 21, it says that most other Umbrians fled to FKA-controlled areas in Kuka or to Akova for fear of detention. Your honorable judges, this detention is no way a displacement. And particularly for the notorious sanitary condition of detention centers. So, because of this, Your Honors, Honorable Judges, we declare...
He had information or not. By virtue of being the commander, the chief of staff of command, he knew that this was going on. Your Honor, I'd like to point out to the court that with all this information, General Rwanda still chose to sit and wait, and rapes occurred to death. There has been no investigation to show that there is willingness at least to investigate what was going on. By this, we go with established reports from Human Rights Watch and also from the investigative journalists. With that, I'd like to call my co-counsel to go to court 3.
Thank you, Your Honor. I would like to continue our submission in relation to count 3. The prosecution requests the court to find that General Rwanda is individually criminally liable for the war crime of ordering the displacement of civilians under Article 25(3)(a) of the ICC Rome Statute. Your Honor, this provision establishes the individual criminal responsibility when committed such as a crime as an individual, joint with another, or through another. Your Honor, we invoke the case of prosecution of Katanga, paragraph 488, where it reaffirms these 3 modes of establishing liability. General Rwanda should be found individually liable for General Rwanda is individually liable for establishing a hostile environment which coerced the Obrian to flee to the FKA controlled areas in Akolo. How did he do this? Through Operation Block, having conquered multiple municipalities, he issued a martial law personally. Under that martial law, he established, he forced every person whose religion was not a Buddha religion to follow classes. And those who didn't follow classes of the Buddha religion were to be jailed. For fear of jail, a lot of the Obrian were forced to flee for their freedom. The prosecution, Your Honor, we submit that to the court that there is sufficient evidence to establish the material and moral elements of the war crime of displacing civilians. Article 17 of the additional protocol, the second additional protocol, and Rule 129 of the customary rules of the international humanitarian law prohibits the ordering the displacement of the civilian population in whole or in part for reason related to conflict or unless the security of civilians involved or imperative military reasons of the The prosecution further submits to the court that the element necessary to establish the war crime under Article 8, paragraph 2E, Roman 8 of the ICC statute provide that the perpetrator must have ordered his displacement. Such order was not justified by the security of the civilian involved or by military necessity. The perpetrator was in a position to effect such displacement by giving such orders, and the conduct took place in the context of and was associated with an armed conflict, not of an international character. Your Honor, we refer to the case of, we pray to the court from the charges of war crime brought against Rwanda.
Thank you, prosecution team. We may now proceed with the defense. Kindly make the submissions.
Greetings, Your Honor. Greetings, Your Honorable Court. I'm Mr. Ramadan, the defense counsel number 1. I'm going to defend our client, General.
Article 5 of the Rome Statute. The fact that this case existed between a state, a sovereign state, and that of a organized armed group on the territory of the higher contracting party, the state, that alone qualified this case as a what? Non-international armed conflict.
The definition requires more than just the existence of a non-state armed group on the territory. Can you elaborate more?
So, For the legal element of this, according to Article 1, Sub-Article 1 of Additional Protocol 2, it implied that the fact that the case existed between a state and an organized armed group that run their own operation and have governance, it implied that this case, once it takes place within the territory of the higher contracting party, with the exchange of arms and the level of casualty, it implied that this case is a non-international armed conflict, and it do exist.
Okay, thank you, counsel.
Thank you so kindly. I was proceeding. They did mention the fact that there wasn't a material element to this case. Honorable judges, it is established that the killing of 10 and 110 civilians and the injuring of 30 is a material element to justify that. Honorable Gary Vendi automatically there's what we reference to as establishment of this. It is so unfortunate that I don't know why they are saying with these casualties that have been referenced and there existed a change of fire, and they are saying there is no establishment of the material element. It become questionable. And they did mention the fact that there was the action of General Gary Vendi's team was due to what we refer as humanitarian act. It still become questionable. How can a humanitarian act be performed into another territory without the emblem being displayed that this act is actually a humanitarian act? And taking into consideration that General Vendi actually have a percentage within the business operation that was going on, this was actually not a humanitarian act, but rather considered as a business trade that they intend to gain profit. As you may be aware, in reference to the fact of the case, there was a depreciation within their profit making, and implied that they wanted to generate more revenue and have a good balance in the market scale. This is the reason why they ordered that. Thank you. I call for one of my co-counsel to respond.
Thank you, Your Honor. I would like to emphasize on the raised defense from the defense team that stated that this was a non-international conflict, and I would like to state the definition as you required, which I didn't really think it was given to you clearly. So a non-international or internal armed conflict refers to a situation of violence involving protracted armed confrontations between government forces and one more organized groups. Now, Your Honor, the FKA group is an armed organized group. It was functioning. It was in the Free-Kukan group, and it was armed as well, and it was fighting against the TFA. So this is a non-international armed conflict, and I hope that we were able to answer your question, Your Honor. In pursuant to the fact that they stated that General Vande didn't know that the truck was attacked before by these local Ombrians, I would like to refer you, Your Honor, to the facts of the case, paragraph 13, that states that General Vande possesses 90% of the shares in Lannister Enterprises and is a good friend of Mr. Lannister and is the chief commander of the TAA forces. This puts him in a position to know that the trucks were attacked by the local Ombrians, and it was mentioned above. Moving forward, I would like to emphasize the fact that General Vande knew that that he was going to emphasize to attack the. I would like to give 1 minute left to my co-counsel. Thank you.
Honorable judges, shortly they mentioned that there was no order of displacement. Honorable judges, allow me to refer you to the fact of the case, paragraph 20, whereby the Bourbons, when all residents were flushed out, those who answered as believers of Bourbon were greeted and sent back home, whereas Ombrians were assembled and forced to take commitment to convert to Bourbon. On whether you deny, you were detained. So the fact that the means were being used is the fact that they ordered displacement of civilians indirectly. So another more thing, the fear of detention was the one which makes Umbrian move to her cover. As you mentioned, that their will was to move to her cover. So that was not, that's not will, because
Councillor,
that's what the
time
fear
is
of
up.
detention. Thank you, Honorable.
Defense, can we have your rebuttal in 10 minutes and we'll interrupt you?
Thank you, Your Honors. Your Honors, I would love to draw to your attention on what the prosecution side said. The prosecution side, they are a little bit confused. They agreed with us that it is an internal disturbance, as their counsel said, this wasn't an international armed conflict. Your Honors, as they well said, it was an international armed conflict. They based on the Article 1, Paragraph 2, on Additional Protocol 2. Yeah, of course, this wasn't an international armed conflict. Basing on that article, it says that ICC has no jurisdiction on the case of internal disturbance and riots. So this says that this wasn't an international armed conflict, and ICC doesn't have jurisdiction over this. I want to draw to your attention the meaning of internal disturbance. Internal disturbance, there are situations in which there is serious or lasting internal confrontation, which do not necessarily escalate to open struggle. The authorities may use...
Counsel, I'm going to interrupt you there because I feel like you're defining the negative rather than the positive. What we're looking for is there a non-international armed conflict, rather than the definition of an internal disturbance? Is there a non-international armed conflict? Do you agree with the definition that was provided by the, I would say, the second counsel for the applicants? If you don't agree with that definition of NIAC, why?
Okay, there was no international armed conflict, as there was no gravity which is required for a conflict to be called an international armed conflict. For that case, there was no international armed conflict. And also, there was no open attacks. There was just the conflict where the authorities were trying to restore order in their country.
Are you able to provide the court with a simple definition of a non-international armed conflict? What is the legal definition of a non-international armed conflict?
An international armed conflict, based on the case of Prosecutor versus Tadic, it says an international armed conflict is a conflict, it exists when there is a prolonged conflict between government authorities and the organized armed group, and also it must reach at a minimum level of intensity, and also the armed group should have the organization, which the prosecutor didn't show us. There was no organization, there was no minimum level of the intensity. For that reason, the defense says this was not an international armed conflict.
Let me also take this opportunity to ask you about something that the third counsel mentioned during your main submissions, and if you can't respond to it, you may request her to respond on behalf of your entire team. She stated that Umbrians went by themselves, no one forced them. And that's a direct quote. And I want you to address the policy of the state vis-a-vis they left by themselves. Is there a correlation between what the policy of the state was and what happened?
Pass the mic to the counsel.
Honorable Judge, can you repeat the question, please?
Counsel, do you recall during your main submissions you making the statement that Umbrians went by themselves, no one forced them?
Okay, yeah, I know.
So can you correlate that to a state policy, or is there no connection? And if you can't respond, you just say simply you can't respond.
I can let my co-counsel
answer. Your Honors, you asked us the states in which the thing was happening, if I got well the question. When the Buban was moving, we believe, as the defendant, it was because they wanted to move, because they didn't want to change from to change from one religion to another. Like what
And
General
that is
Jared
the
Van...
policy that I'm talking about. That is the policy of requiring them to change their religion. Do you see a correlation between that state policy and the Umbrians leaving?
Your Honors, on that question, the policy relating to the Umbrians moving, there was no exact policy which made them move, because if anybody wanted to stay, that person should have stayed. Thank you.
You can proceed, Council.
Council, I might ask a question in a similar vein. Oh, sorry, I've actually lost my question now. Yes, Council, your submission was that the orders were provided to protect the convoy. I feel like I just want to comment on what do you think the meaning of protect the convoy with all necessary means is? Can you comment on the expression with all necessary means and whether that could be considered to be implying the use of lethal force?
Thank you, Honorable Judges. Commenting on the words of protecting the convoy using all necessary means, it doesn't mean that they were supposed to attack the civilians, but they're just supposed to apply military necessity whenever necessary, just to protect the convoy and make sure that it reaches the destination.
Council, do you have your written submissions?
Yes, I do.
Your written submissions don't have page numbers, but I think it's on the second page at point number F. Are you there? So it says about the duty to prevent and punish, General Gerard Vande, as the superior, is not liable since the acts of the subordinates were justified. Thus, objectively not unlawful, and thus the superior cannot be accountable for not preventing or punishing. Can you submit on justification and how that connects to the duty to prevent or punish on a superior?
Yes, Honorable Judges. The acts were justified because they were outnumbered by the local Umbrians, who came at a large number of 200 local Umbrians, Honorable Judges. They came with the intention of trying to rob the trucks, of the humanitarian trucks. Then the tough soldiers fired just for precautionary measures so that they can disperse and give them way to reach their destination. So the acts were justified because once the local Umbrians fired back and killed the tough soldier and the driver.
In talking about justification,
yes.
Were you trying to refer to self-defense?
Yes, Your Honor.
I might add to the comment from my learned judge, my fellow colleague. In relation to justification and self-defense, on our facts we have 110 civilians of the 200 present killed and 30 more injured. So 110 out of 200 that were killed in response to the firing of shots that resulted in 2 casualties. Can we truly say that that's an act of self-defense? I mean, I'm just even thinking about the physical act of shooting 110 civilians. That's not an isolated targeting of whoever it was that issued the first shots. That's going to be the spraying of, at the very least, 140 bullets, because we have 110 casualties and deaths and 30 injured. So can you comment on that reasonableness and justification?
Yeah, commenting on that, Honorable Judges, the 200 local Umbrians, when they tried to rob them and attack them, and in the midst of them, they fired to the tough soldiers. So because it was a crowd of them, they could not where it was coming from. So as a form of defense, they responded back to the attack. Thank you. And coming back to what the prosecution has just said, They say that the exchange of fire alone is not, they say that the exchange of fire is a material proof that General Rwanda is individually responsible for ordering direct attack against the civilians, not taking direct part in hostilities. The exchange of fire alone, honorable judges, as a defense office, we do not find it full proof that it is a material element, because as I've just explained, they were attacked first, and they used precautionary measures to try to disperse the crowd, but from nowhere the crowd, they tried to rob the trucks. And General Rwanda possessing 19% of the shares in Nista Enterprises is not, they mentioned this comment because General Rwanda possessing 19% of the shares in Nista Enterprises, it does not have any link with him being liably individual criminally responsible for the war crime of attacking the civilians. That was just his shares in the company. He was doing what he was supposed to do to deliver the remaining trucks to the Bubans who were stuck in the FKA-controlled areas. Thank you, judges.
On behalf of the bench, we thank both prosecution and defense for your fiery arguments. We remain to see whether we have been convinced by both either side. So we thank you, and we'll let you know about the decision in due course. Thank you. UNILAC, you're going over to the defense side, and we're going to have University of Kigali on the... No. UNILAC is on the prosecution side.
That their response is proportional to the attack and the threat that they are facing. The threat that we are facing was not of such gravity that it entailed the death of 110 civilians and 30 being injured. Their response was excessive, Your Honor. The defense, I would like to call my co-counsel to
Thank you, Your Honor. If it pleases God, I'd like to supplement on what my co-counsel has elaborated. One, let it be known to the court that the defense did not at any point try to absolve General Rwanda of the crime of being held criminally liable with regards to the command responsibility, implying that they agreed that he was responsible and had effective control for his troops. The question that the defense had was this crime of rape a war crime or an ordinary crime that happened between soldiers and should have gone to a military court rather?
Counsel, can you prove to the court that General Rwanda had material ability to prevent and punish the commission of the rape incidents that occurred, and if he took any significant steps towards the implementation of his responsibility as a commander?
Thank you, Your Honor. If it pleases the court, I would like to point out to the court that General Rwanda, being the chief of defense staff in the hierarchy, he was in charge. He had the power to decide when, where, how, and military strategy should happen. As the chief of the defense staff, he had a responsibility, both moral and also professional responsibility towards this individual. He never took care. Why? When information was brought to him that the people were being raped in his army, that soldiers who were weak and wounded were being raped, he dismissed it. He said, what happens between soldiers in their free time is not my business. That is what he implied, Your Honor. This shows that he had effective control and failed to take necessary measures to address the issue at hand. Your Honor, let it be pointed out to the court that throughout our engagement with the defense, there was no point where rape was denied as having happened. There was not the point where there was denial that General Rwanda was in charge of the DAF troops. There was no denial that he had effective control. I will demonstrate this further. General Rwanda was sections of the military mutinied and would have guessed and said they mutinied against the whole army. No, they mutinied and pledged their allegiance to General Rwanda. This shows you that the loyalty to them, they had loyalty to him. He had effective control over them. He would have said stop. He didn't say stop. Your Honor, we have not gone further into demonstration on whether rapes happened or not because the defense is in agreement that it did happen. To establish this, they did not They never contested that he was of the information, and by virtue, should it be contested, by virtue of him being the chief of defense staff, by virtue of him heading the chain of command, he should have had the knowledge, and it had nothing to do with geographical location, it had nothing to do with him being given the information. By virtue of being the leader of the military in this case, he should have known, and he had reason to know and act. He did nothing related to action. He was aware and just conformed to what was going on as simply an act between adults, not even consenting adults, say between adults. This was in response to weak, wounded, tired soldiers who are from combat, who can barely defend themselves. And as addressed by my co-counsel, it is established that by that they became non-participants in the war, so hence protected. So this amounts to a war crime. Without Your Honor, we rest our case.
Thank you. We now proceed with the rebuttal from the defense. You have 10 minutes and the judges will be asking the questions.
My name is Muzeimana Esther and I am on council coming to rebuttal. I would like to confirm and ask for this honorable court to please underline that we did not say that the crime did not take place. We agreed. We agreed that the rape happened, but it is not a war crime. Therefore, it is not protected by the IHL. These soldiers are not protected by the IHL. Your Honors, the element does not matter of whether the crime happened.
So can you elaborate on that? You agree, the defense agrees that rape occurred, but it does not constitute a war crime.
Exactly. Which stipulates that General Van Day, for him to be liable, he would only be liable because of the command responsibility. But in this matter, the command responsibility does not matter because the crime that happened is under the IHL. Literally meaning the people are not protected under this law. Therefore, the jurisdiction under this court is on the ordinary courts, not the ICC.
So there is no command responsibility?
The command responsibility would only occur if the crime was falling under IHL. I would proceed when they talked about the proportionality, and the defense submit to the court that the defense proving how the principle of proportionality is linked to General Van Day was something that the prosecution did not show, because the principle of proportionality in itself is not an element of the crime that is happening at this stage. It is not an element of the crime now. How is this linked to General Van Day, him who is being accused in this matter and this case? Your Honors, the prosecution failed to state the prayers. I do not understand what they are praying for. If they say the crime happened, and they are very, very attached to how this should have been criminally liable to our client, and then they did not pray towards the court. Allow me call for my co-counsel to proceed.
Thank you, Your Honors. Thank you, Honorable Court. I'm Counsel 1, I'm Ramadan from the defense side. I would like to, on the website, I would like to underline on what my learned counsel, also the prosecution, raised as an issue on the involvement of direct participation of civilians. These civilians, note that there are 200 Ombrians. Please kindly highlight that. The counsel brought up, prosecution brought up on the issue of running. I would like us to refer to the paragraph 16 of the facts, where they shot warning shots, and then they returned fire. Following these warning shots were fired at the convoy from the middle of the crowd, killing a tough soldier and the driver. Tough soldiers immediately returned fire. The armored vehicles also opened fire. They first opened fire while the civilians were running. Why were they running? They were running because they were participating in profit. They were running because they were accomplices. So they know the attack was going to be returned to them. Therefore, they fled the scene. Also, on the issue of proportionality that was raised also by the prosecution, I would like to pose a legal question about this. I would like to know if they can highlight. We cannot infer the principle of proportionality only based on anticipated results, which was the death which they raised as their points, as their argument. We also have weapons. How sure are you what was the rate, what was the weapons that were shot from the convoy? If it wasn't for the strong armored vehicles that they had, they could all have died.
Council, your council has mentioned that there were no war crimes in this situation. Do you agree with this statement, or you want to elaborate?
Regarding the second count as war crime of rape, yes, we do agree. Can I proceed, please? Also, still on the issue of proportionality. Therefore, we cannot infer this was a violation of proportionality, and yet you did not know what was kinds of weapons that these people from the crowd had. Please refer to first paragraph 16, that these task group had two armored vehicles. Imagine what would have happened if they had normal cars, meaning they could have all died.
What does the principle of proportionality entail under IHL?
The defense of instead with regard to the means used. Can I proceed? With this regard, there is a doubt. There is a doubt on the weapons that were used by these shots that were fired from the crowd, Your Honor, if it is to be highlighted in this court. Therefore, on the issue raised by the prosecution that they directly participated into the hostility. Therefore, they lost. I did say they lost their civiliancy. They lost the protected status, meaning targets, meaning they could be targeted. Therefore, running, it was too late for that. That could never take it on. With it may please the court, I would call upon counsel.
Thank you, Your Honors. I'm Kasuri from the defense. Assisting my counsel 2 on the war crime of rape, the alleged war crime of rape. This to be established as a war crime, there must be a relation of who raped whom. So, for this relation to be established, there must be protected persons under the Article 3 of Common to all Geneva Conventions. So, if those combatants, those raped staff soldiers, in the case, they say that they were the one responsible for cooking and medical care of the wounded soldiers. Does being in the kitchen make you a non-combat? No, it does not. Because being in the kitchen does not incapacitate you from defending yourself. This means that they don't fall under the category of the combat. So being in the kitchen as a soldier, does it grant you a civilian status? No, it does not. So if they don't fall under the civilian status, and if they neither fall under the civilian status, nor all the combat, who are they? They are combatant, lawful combatant. So the law does not grant a protection on these lawful combatant against these types of crimes. I can call upon my counsel.
Also, in addition to what my co-counsel 3 has said, in reference to paragraph 18 of the facts of the case, it's written that the young soldiers have been selected at task. Your Honors, note 1, logistical services. 2nd, such as preparing meals, maintaining military supplies, and providing medical care for the wounded. Would like the prosecution to highlight how these people are protected, because this does not fall under the mentioned article of my second counsel, Esther, who mentioned about Article 3 of Article Commentary of the Geneva Convention and Article 4 of the Additional Protocol
to the Geneva Convention. This cannot grant them either the status of hors de combat because they are not incapacitated.
You still have 1 minute if you want to use it.
Okay, for the Council 3 from the defense, I want to correct him as he stated at first part that General Vande issued personally the martial law. General Vande did not issue personally the martial law. So this is a first part. Then, continuing on the crime of displacement, the defense has made a general impression on the cohesive environment created by the general. But basing on the Nahimana appeal judgment, in paragraph 726 and paragraph 727, the court looks each statement and order individually, not based on general impression. Therefore, the prosecution did not manage to show clearly which order or which post constituted an order of displacement to the civilian. Thank you.
Thank you. The court announces the conclusion of today's hearing, and you'll be duly announced the day of the
This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence and injuries. So ICRC work here is trying to mitigate that.
Today, 65 million people are fleeing conflict, more than any other time in history. For those on the move, we support them on the journey where we can. But for those who don't want to leave their homes, or can't, they remain stuck in besieged cities. Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized the children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
Again and again, we connect brothers and sisters, fathers and mothers. When the circumstances aren't so fortunate, our forensic experts work to bring closure and the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont l'affaire des femmes. C'est pour cela que nous allons continuer en tant que volontaires à faire nos sensibilisations pour qu'un jour, toute la communauté puisse être au courant et de savoir que le viol, c'est quoi.
Throughout the world, we work to help the most vulnerable people and those who may be overlooked. We care that detainees are treated humanely, no matter what they've done, visiting 1 million detainees in almost 100 countries.
Assalamu alaikum. Sa mga tarima po namin, ma'am, 23 inmates po kami, yung iba, nagdadalawa-dalawa na lang po sila. Dito sa sahig po, ma'am, mas marami po yung...
From the diplomatic level to the front line, we remind fighters on all sides that wars have limits. Named in the Geneva Conventions as an authority on the laws of war, we work to regulate the use of weapons, the methods of warfare, and to ensure civilians are spared. No matter who they are or what side they're on, we treat the sick and wounded.
So it's spontaneous. You don't even have to think about it. Anybody comes with emergency, you take them in, no question.
And in the wake of war, when weapons, bombs and mines are abandoned, We clean up what we can and help those whose lives have been changed by war regain their independence. Often first on the ground and the last to leave. Neutral, impartial, and independent, we are the International Committee of the Red Cross. This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence and injuries. So ICRC work here is trying to mitigate that.
Today, 65 million people are fleeing conflict, more than any other time in history. For those on the move, we support them on the journey where we can. But for those who don't want to leave their homes, or can't, they remain stuck in besieged cities. Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent Network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized the children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
Again and again, we connect brothers and sisters, fathers and mothers. When the circumstances aren't so fortunate, our forensic experts work to bring closure and the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont
presentation without interruption, and 20-minute 10 for each team for rebuttals. Now, as each team has met each other, we are going to use 10 minutes for presentation, and rebuttals take 5. I repeat, 10 minutes presentation, 10 minutes presentation. Rebuttals, we take 5 minutes for each team. Those were the new instructions. All eyes, the court.
You may be seated. Good afternoon. As you know, we have time constraints. So I think you've been told that we are reducing the amount of time for all teams because you've all met each other in previous rounds. So for this round, we have Ines as prosecution, and then we have UR as defense. You'll each have 10 minutes for your main arguments, and then you'll have 5 in rebuttal. We are going to be very strict with the time, and we may interrupt you with questions during rebuttal. Prosecution, this is your turn. And my fellow judge on the left will actually be telling you the time that is left using a piece of paper, so pay attention to what he writes to you. Thank you.
Thank you, Your Honors, opponent side and the audience. Good afternoon. I'm called Lisa Ange Ishimie. I'm the first counsel from the prosecution side. I'm with Nancy, the second co-counsel, and Janvier, the third co-counsel. As the first counsel, I'll talk about the overview of the case, jurisdiction, and nature of the conflict, and also the admissibility of this case. The case at hand, the accused General Gerald Vandi was the chief of defense at the time these crimes were committed. At the time, the Buban state was a party to the Geneva Convention, Additional Protocol 1 and Additional Protocol 2, Rome Statute of ICC, Vienna Convention, the Law of Treaties, and the UN Charter. The prosecution is charging General Gerald Vandi on the war of crimes committed between 25th March 2014 to 28th January 2016. Your Honor, the prosecution finds the case to be under the jurisdiction of the ICC. Your Honor, pursuant to the Article 5 of the Rome Statute, which categorizes crimes to be tried by the ICC, we found that the war crimes lies in this jurisdiction. As we have said, this is a war crime, specifically an international armed conflict. For an international armed conflict to exist, there should be the existence of a prolonged conflict between the government authorities and the organized armed group. Your Honor, in this case, there was a prolonged conflict between the government authorities and the armed group. As from the 25th March of 2014 till this conflict happened between 25th March of 2014 up to 28th January 2016. And this shows there have been a prolonged conflict between these two parties. And also for an international armed conflict to be it, there should be the intensity. Your Honor, there was the intensity. There was the intervention of the UN nations. Your Honor, on paragraph 24 of our case, the overall humanitarian condition in Kuka drew international attention and was condemned by the UN Security Council, which led to the adoption of the resolution. Your Honor, there was also the deployment of government forces to this crisis. Your Honor, the Turkana armed forces were deployed. This shows that this conflict has the intensity to be called an international armed conflict. Your Honor, if it may please the court, allow me to jump to the organization of the armed group. For an international armed group, for an international armed conflict to be called, so there should be the organization of the armed group. Your Honor, there was the organization. They had the command structure, as they have appointed themselves as the colonels and majors of this of the FKA to fight against the police of the Turkana armed forces, appointing themselves as majors and colonels. Your Honor, this FKA managed to recruit 2,000 men and women to take arms and obtain light weapons, including assault rifles and grenades. Your Honor, the organization here was made. That is why we are saying that this conflict is an international armed conflict. As it was established in the case of Prosecutor versus Thomas Lubanga, a group is said to be organized when it can plan and carry out a military operation. Your Honor, in this case, the FKA in paragraph 9 on 20th June 2014, Your Honor, they were able to plan and carry out a military operation where they took over a territory called Bureau. Your Honor, the prosecution side also finds this case to be admissible to this court as the rational temporis. Pursuant to Article 11 of the Rome Statute, ICC can only exercise jurisdiction over crimes committed after July 1st, 2002. Your Honor, this crime was committed in March 25th March 2014, and therefore we found this case to be under this jurisdiction. Your Honor, if it may please the court, allow me to jump to the admissibility of this case. For the case to be admissible to this court, it should fulfill the following criteria. There should be no states with the jurisdiction has investigated or prosecuted the accused for the same crime. Your Honor, in our case today, General Gerard Vande was neither investigated or prosecuted by the Tukhanov government. Your Honor, in paragraph 12, the Tukhanov government formally referred the situation in Kuka from 25th March to 28th March to the ICC, 5th Feb 2006. This shows the unwillingness of their state to try the people who committed crime in this period. Your Honor, as it was shown in the case of Prosecutor versus Lubanga, to meet the gravity, 3 questions must be answered. And here we found that it was answered. Where the object in paragraph 16, 110 FKA people died, and also the accused falls under the category of senior leaders. Where General Gerard Vande was the chief of defense of the TAF. There should also be that the suspected should be responsible for the allegation by their acts or omissions or role played by it. And here, General Gerard Vande was the commander as he ordered in paragraph 16 and ordered displacement in Operation Blah, paragraph 20 to 21. Your Honors, allow me to lead to my second co-counsel to give proof beyond reasonable doubt on count 1 and count 2.
Thank you, honorable judges. My name is Nancy Wase. I'm here to prove beyond reasonable doubt and to plead with this court to charge General Gerard Vande on the following crimes. General Gerard Vande is individually criminally responsible for the war crime of intentionally directing attacks against the civilian population, not taking direct part in hostilities, punishable under Article A2E Roman 1, based on ordering, soliciting, or inducing the commission under Article 25, 3B. Honorable judges, the perpetrator here is liable for ordering attacks on the civilian population. According to the case records facts on 10 November 2014, he gave out orders to the TAF soldiers that they should protect the convoy by all necessary means. But he did not tell them what it means by protecting the convoy by all necessary means, which led to the TAF soldiers to kill 110 civil local Umbrian honorable judges. And also the prosecution finds General Gerard Vande individual criminally responsible for ordering the war crime of intentionally directing attacks against the civilian not taking direct part. Ordering, as it has been speculated in the Naganda's case in paragraph 115, he ordered his bodyguards to kill an armed Lendu man in front. So this ordering, the speculation of ordering, according to our current case that we have right now, General Gerard Vande was in a position of authority, whereby he gave an order and his soldiers adhered to the order, which led to the killing of 110 and injured 30 local Umbrians. Honorable judges, allow me to continue to count 2, whereby it says that he is individually criminally responsible for the war crime of rape, punishable under Article A2E Roman 6, based on command responsibility. Honorable judges, the material elements of these crimes have been satisfied, being the moral element and material element. The TAF invaded the bodies of the victims by conduct that resulted in penetration of their bodies. Because the ones who were being raped here, honorable judges, they were the physically weakest soldiers in the camps who were given just normal works of doing of cooking for the highest ranking officers in the TAF soldiers. Honorable judges, the fact that the war crime of rape was committed by persons within the same camp the victims' protection under the law of armed conflict should not be denied by them. So, honorable judges, we find General J. Vande liable for the crime of rape under command responsibility. Allow me to pass the mic for the last count.
Your Honors, if it may please the court, allow me to continue to the count 3. General Judge Vande is individually criminally liable for the crime of ordering the displacement of civilians population for reasons not related to the conflict, unless the security of civilians were involved. Under Article 8.2 Roman 8, based on committing crime, whether as an individual or jointly with another person, under the Article 25.3a of the Rome Statute. Ordering, according to Nanganda's case, paragraph 115, means a person in a capacity of authority to instruct another person to commit an offense. Continuing with this Nanganda's case, the issuance of another within the political or military chain of a command is sufficient. The order itself needs only to instruct another person in any form to commit a crime, to displace a civilian, or to perform an act or omission as a result of which displacement would occur. And drawing from the fact, the General Judge Vande ordered the detention of the Ombians who missed the religious classes 3 times a day on the 5th day of missing the classes. The intention, to displace must emanate from a person who was in a position to effect such displacement by giving such order. The General Judge Vande, being a chief of defense and vesting the authority from the martial law, he ordered displacement with intention of detaining civilians with the sole purpose of tell them to convert to Buba without their intention concerned. If it may please the court, allow me to move to the prayer for relief. The prosecution, after proving beyond reasonable doubt that General Judge Vande is criminally liable for the charges against him, we respectively request this honorable court to confirm that General Judge Vande is criminally liable for the alleged crime and receive this case. Your Honors, thank you. Respectively submitted.
Thank you to the prosecution for those submissions. Now we turn to the defense. You have 10 minutes, very strict timelines.
Thank you, Your Honors. If it pleases the court, the defense may start with responding to the first crime alleged by the prosecution. Your Honor, the elements of the crime of directing attack against the civilians not taking part in the hostilities under Article 8, Paragraph 2, Subparagraph E, is not fulfilled. The actus reus is lacking because the attacking object was not the civilians. Your Honor, in Common Article 3 of the Second Geneva Convention and Article 13 of Additional Protocol 2, it really gives the protection to the civilians. But under the case at hand, these civilians had lost their status of protection. The tough soldiers also had employed the principle of the precautionary principle, which is enshrined under the Rule 15 of the customary international law. Since they first shoot in space, and if presumptively the order given to the commander was to directly shoot at the civilians, the tough soldiers would have immediately shot at the civilians but not shooting in the space. Your Honor, the attack of the tough soldiers was lawful pursuant to the exception under Article 13, that if the civilians, they directly act in hostilities, they lose their protection. Your Honor, it was therefore also ruled in the Inter-American Commission on Human Rights in the case of Tablada case in Argentina that civilians directly taking part in hostilities, they legitimately become the military targets. Your Honor,
The defense was, the TAF was responding in the context of the self-defense. We are submitting to this court that since it is not clearly shown who were the armed forces and those who were not armed, Your Honor, and if the armed, if any, the court should regard this as the collateral damage. Your Honor, it was also ruled in the case of Prosecutor versus Roda Van Karavich that the perpetrator of the crime, of ordering the crime, at least should be aware of the civilian status. But in the context, General Vande never knew about the civilians' invasion. If it pleases the court, honorable judges, the concept of protecting the convoy, it did not mean directly attacking the civilians. Your Honor, and also it was ruled in the Mudachumra case that for the authoritative person to give the direct orders to the subordinate to commit a crime, at least the one giving the order should at least know that the action of giving an order will result into the crime. But General Vande never knew that the order is giving was tantamounting to the commission of the crime. Your Honor, the court should also interpret the language used by General Vande, and the prosecution should not take it as directing attack to civilians, but it was the mere protecting of the convoy by the necessary means. Your Honor, the order was also given by Vande. It was in context not illegal, because it was simply to protect the convoy, not attacking civilians. Your Honor, if it may please the court, I would like to call upon my co-counsel to proceed.
Thank you, Honorable Judge. Counsel Lilian Karijirwa, and I'm going to be proceeding with I'm going to be replying to the second count. General Vande is not liable under command responsibility provided in under Article 28, Alinea A, for the war crime of rape punishable under Article 8, Paragraph 2, Subparagraph E, and Alinea 6 of the Rome Statute. Honorable Judge, the prosecution has failed to elaborate how the elements of this crime have been established, since the only source of evidence is from anonymous sources and collaborated press release. Honorable Judge, in order to prove that General Vande had command responsibility over his troops, he has to have had knowledge that the crime alleged was committed, so as to be able to prevent or punish that crime. Drawing from the facts of the case, the prosecution based on circumstantial evidence to prove that General Vande had knowledge of that alleged crime. Honorable Judge, from the facts of the case, General Vande was not deployed with the forces in Kauka. As the Chief of Defense Staff, he was headed at the headquarters of Tukanov Armed Force. So there is no way he could have been aware of such knowledge that those crimes were being committed. Moreover, when he came to visit the mutiny, as they were reporting the other discrepancies of corruption, they never outrightly said they were being abused in any way. So there is no way to prove that General Vande had any factual knowledge that the alleged crime was being taken place. Moreover, due to his position and due to the number of forces that he had under his control, it was so rare for him to know what was happening in each battalion if it wasn't reported to him directly. So if General Vande wasn't aware of that crime being taking place, how could he have punished, or how could he have prevented that attack from taking place? The prosecution has failed to establish that, and it is upon these grounds that due to lack of knowledge and lack of elements establishing command responsibility, General Vande shouldn't be liable under this crime. I'm going to call upon my co-counsel to proceed with the next count. Thank you.
Thank you, Your Honors. I'm Defense Counsel Monisha Dikaya, and I'm going to proceed with the third count. Prosecution is alleging that General Vande made an order to displace. However, this is not how the facts unfolded, Your Honor. The facts unfolded as an order to detain civilians who were not conforming to the religious policies of the country. It was held in the Katuvina case by the court that this requirement of ordering is relevant when it comes to war crimes and irrelevant when it comes to crimes against humanity. And
And it is by this that the defense submits before this court that not only the action of ordering should be taken into account, but most importantly, the substance of ordering. It was an order to detain and not an order to displace. Moreover, prosecution is basing on facts that do not provide substantial basis, substantial evidence. This is because they are basing on information that came from the UN Commission, which is a preliminary report, Your Honor. It is not even the final report given by the investigative commission. And moreover, this report itself does not have any additional evidences to corroborate what it is saying. So it is hard to establish that even the information of saying that there was displacement of civilians. How are we sure that there was displacement of civilians upon just information like this that is not admissible before the court? I will proceed to show that even the element, not only the element of ordering is missing, but also the contextual element is missing in this crime. This is because the order to detain upon which they are deriving the displacement was not done in the context of an armed conflict. Rather, it was done to implement state religious policies. Your Honor, it was a state religious policy depending on paragraph 4 to change the federal religion to change the federal state to become a religious state of Buba. And it is because of this that General Rwanda was implementing the state policies given by the power of the martial law that was declared. Therefore, there is no element, there's no fulfillment of the elements. They are basing on evidence that is not collaborated, and it is the prayer of the defense to not admit all these crimes upon General Rwanda since he is not liable. Thank you.
Thank you, counsel. We now turn to the prosecution for rebuttal. You have 5 minutes, and we may interrupt you with questions from the bench.
Thank you, Your Honors. The defendant side, they said that General Gerald Vandi was not aware of what was going on. Your Honors, Article 28 of the Rome Statutes on the responsibility of commander and other superiors, paragraph B, it says that the military commander or person, either knew or owing the circumstance at the time, should have known that the forces were committing or about to commit such crimes, Your Honors. In this case, General Gerald Vandi had all the reason to know what was going on. For that reason, General Gerald Vandi should be held criminally liable for this crime. And also, they raised the issue that they weren't the protected civilian, Your Honors. They didn't conform with the IHL principle of distinction and proportionality, Your Honors. They went to attack the civilians, whom they called the local Umbrians, which they didn't say they had arms, the local Umbrians, using the 50 caliber machine guns,
Counsel,
Your Honors.
when you have, you talk about two principles, are they both equally applicable in this case, or if one applies, then the other one doesn't?
Thank you. They failed to show the principle of this distinction, where they failed to show who were the combatants and the non-combatants. And as we know, in the international armed conflict, they should make sure that they confirmed with this principle. And also they didn't abide with the principle of proportionality, where they used the 50 caliber machine guns just to attack the local Umbrians who did not even possess arms, Your Honors. I regret to present this, but it was so inappropriate, and we here as the prosecutor find General Gerald Vandi to be liable for this crime. Thank you.
Thank you, Your Honors. Allow me to answer the question that was raised by the defense on the last count, which is the war crime of displacement of civilians. They say that it was detention, not displacement. By detention led to some Ombians to flee to Kuka to go to her cover and for the fear because they had no time to attend class because of working for long hours. The detainees cannot exercise many of their freedoms, including that of leaving the place of detention of their will. It was stipulated in the appeal judgment of Milorada case, paragraph 218. It notes that the prohibition against forcible displacement aims at safeguarding the right of aspiration of individuals to live in their communities and homes without outside interference, and they were detained. Hence, it led to displacement. Again, I stipulated in Haganda case that the order itself needs only to instruct another person in any form to displace a civilian population or to perform any act or omission as a result of which the displacement would occur. It doesn't mean that displacement had to be as such, like go and displace these civilians. But their action, the so-called state policy, they are alleging that it was for the state policy. They had to take into account the liberty of the civilians. They have the right to take, they have the right to take to choose what they want. And under Article 5.1.
Council, does displacement have to be forceful or not?
No, not necessary.
Proceed.
Under Article 5, Paragraph 1, D and E of Additional Protocol 2 of 1977, that protects victims of NIAC, the civilian's liberty must not be restricted. They have to be taken care of, allow them to practice their religion, and if made to work, have the benefits of working condition. Under this operation blank that happened from March to October 15, they didn't allow the Ombians to practice their religion, no benefit from working condition. So we hereby request the Pretrial Chamber to confirm this charge under General Gerard Vande.
Thank you, Counsel of the Prosecution. We now turn to Counsel for the Defense. You have 5 minutes, and we will be...
Thank you, Your Honors. I would like to respond about the alleged concept by the prosecution about that the principle of distinction was not considered. Your Honor, yes, it is. The fact is that among the crowd there were some who were armed and others were not armed. But as a matter of defense, the TAF was retaliating to those who were armed in the way of self-defense. And that's why we submit to this honorable court that if there was some civilians who were not armed and in the process they were harmed, we submit to this honorable court that it should regard those as the collateral, they should regard them as the collateral damage, Your Honor. Thank you.
Thank you. I'm going to proceed with refuting on what the prosecution alleged on count 2. Honorable judges, effective control is not the only element that can be used, that can be only used in assessing that command responsibility has been fulfilled. The Bemba case in paragraph 431, this very court held that there are other factors that need to be put into consideration while assessing that the commander really did have knowledge of the alleged crime. One of them is the location of the geographical location of the commander. Was he based with the troops? The second of all, the number of forces that are under his control. General Vande was the chief of defense staff. He had a lot of troops under his control. So it was very it was very hard for him to know what was happening in each battalion if it wasn't reported to him. Moreover, when he came to visit, no one alleged, they all came outright and spoke outright that this crime was being committed. So all of that should be put into consideration by this court while assessing on this matter.
Counsel, from your submission, you're alleging that General Vande did not have factual knowledge that the crimes were occurring, right? What do you think, or don't you think that as a commander, he failed to take necessary and reasonable measures to prevent the crimes from occurring, the crimes that were being committed by his subordinates? And even when they occurred, didn't he fail to punish his subordinates for the crimes?
Well,
I want you to establish the nexus.
Okay, well, thank you. Drawing from the facts of the case, all from the chain of, when General Vande visited the mutiny, he promoted some commanders within that mutiny. So there were immediate commanders that were based with the deployed troops within the mutiny, who should have reported back to General Vande if there was really a crime being taken place. Moreover, General Vande can't be held to punish or repress the crime when he didn't have actual knowledge that the crime was taking place.
I actually have a concern about actual knowledge. Are you trying to suggest that the prosecution has to prove actual knowledge, or there's a standard of he knew or had reason to know?
Thank you. The prosecution has to believe beyond reasonable doubt that really General Vande had that knowledge. As I began my submissions as the defense, I alleged that the prosecution, based on circumstantial evidence to prove...
Counsel, I don't think any of us are contesting the burden of proof and what the prosecution has to prove, what the standard they have to meet. My question is, what exactly must the prosecution prove? Is it actual knowledge, or that Vande knew or had reason to know?
The actual knowledge. The actual knowledge, General Vande had to have had actual knowledge to know that the crime was in progress, or to know that the crime had happened.
So what then happens to the angle of prevention or punishment? If it's actual knowledge, how does punishment come in? That comes after the fact.
Yeah, thank you. Well, thank you. In order to punish, you have to have actual knowledge that the crime really did take place. In this case, there is no evidence to prove that General Vande had actual knowledge of the crime being taken place.
Proceed, Counsel.
Okay, I would like to call upon my co-counsel to proceed.
Thank you, Your Honor. To supplement a little bit on what my co-counsel just said, this article
Counsel, it's actually time, so 30 seconds to finish your thought.
Oh, okay. So, okay, I'm not going to supplement, then let me continue to what the prosecution said. We are raising an issue of factual causation, Your Honor. According to paragraph 6, there was a coercion of, paragraph 6 of the facts, there was coercion to try to convert into the religion prior to even the qualification of this as an armed conflict by itself. So this coercion itself, it is linked up with the state policies. And this is why defense bases to say that this was not a crime in the context of an armed conflict. Rather, what the actions of General Vande to detain was in conformity with the state policies that were initiated even prior to the existence of the armed conflict. Therefore, without prosecution establishing that detention, displacement is derived from detention, or the substance of this action is displacement and not detention,
Counsel,
there is no liability.
Your time is up.
Thank you.
Thank you to both teams for your submissions. The bench is mindful that we have to give you a date on when to pronounce on the things that you have requested, but we'll let you know in due course when we'll do that. Shall we call the next groups to come? We will have ULK on the prosecution side and Ines on the defense side. Shall we have, which team is it? From UFK? Good afternoon. So the prosecution as well as defense, you both have 10 minutes uninterrupted of your main submissions, and then you have 5 minutes in rebuttal in which members of the bench can actually ask questions. The times will be very strict. Prosecution, it's your turn.
Greetings, Your Honors. I'm Prosecutor 1, Mr. Ramadan. I'll be prosecuting count 1, which is war crime of attacking civilians. With regard to our elements, the first and the second elements, the prosecution submits that they were fulfilled as the object. The perpetrator directed the attack. The attack was directed against the civilian population, which is Umbrian's population. And it was on the order of General, the accused, in this case, who is General Gerard Vande. He told the leader of the task group, protect the convoy with all necessary means. The prosecution submits that this sentence carries heavy weight. Your Honors, even he told the leader of the task force to protect it, even if it meant attacking civilians, as long as the convoy was protected. And the prosecution submits that this violated the principle of proportionality in 2 ways. Your Honors, in terms of the weapon used and the anticipated results. The weapon used, the 50 caliber machine gun against 110 unarmed, harmless civilians and 30 injured, which cost them their lives. Also, the weapons that were used to kill 110 civilians and injure them, they were not equal to the weapons that were used to kill 10 soldiers of the TAF, which is Tokanovan Armed Forces, and injured 3 drivers, meaning these weapons, they carried different weight of the results, meaning the gravity of it. Therefore, this proportionality was attacked in this sense. Another one, it's violated rule number 1 of the customary international humanitarian law, which provides about distinction between civilians and combatants. Parties to the conflict must at all times distinguish between civilians. They did not. another element, which is the perpetrator intended civilian population. It should be highlighted in this honorable court that General Gerard Vande was a shareholder in Lanista Enterprise. He had 19% of shares, meaning this attack was not necessitated by military advantage or necessity, rather personal gains, because he did not want his business to risk it. Therefore, he sent the task group to protect the convoy even if it meant killing the civilians. If the court may please, I may welcome my prosecution.
Hello, my name is Uizemana Esther Muhozi, and I am the second counsel on the prosecution. Now, first of all, I would like us to imagine of a very serious moment that is happening at this moment, whereby soldiers that are patriots, soldiers that have gone to war to fight for peace, soldiers so described by the case that they were the physically weakest soldiers, are being raped by their leaders, people that they see exemplarily, people that are supposed to protect them, people that they see and look up to. Your Honor, these people were violated sexually by their leaders. And in hearing this, the accused did not take counterable measures that were necessary to prohibit and stop this crime. Instead, when he was asked about it, he said, I quote, "My soldiers are adults. I am not responsible of whatever happens during the free time." Your Honorable, as a commander, as a leader, right at this moment, he violated Article 28 of Roman Statute, which states that for the subordinates, thank you, all subordinates are not criminally liable. Instead, the person who is criminally liable of their crimes is their leader, which in this case is Honorable Commander Vande, the accused. Your Honor, the prosecution also based on the approach that was taken during the prosecution versus Bemba, whereby it accumulates all the 6 elements as to which a person who is a commander is liable during an armed conflict of such a crime, whereby it states, I will state a few because of the time. Did this man have knowledge of what was going on? Yes, because he was told by the reporter. Was this man in place to stop it? Yes. Did he stop it? No. Your Honors, this man is liable of the crime of rape. Allow me welcome the counter 3 to follow.
Counsel 3 from the prosecution. My name is Nzeman Mdedune Magloire, and I'm going, allow me to proceed with count 3, all crime of displacing civilians. So the prosecution finds that, as based on 4 elements provided by Article 8, Paragraph 2, E, Roman 8 of the elements of crime by the ICC, where the first element is the perpetrator ordered the displacement of civilians. So to prove this element, we must first establish that this displacement really took place. So during Operation Blanc, the General Vande ordered mass incarceration of Ombrians due to their religion, where between March and October 2015, more than 80,000 Ombrians were detained. So this induced fear into other Ombrians, which led them to flee away from the tough controlled areas. So who is liable for this? The prosecution finds that there is sufficient evidence to prove the criminal liability of General Vande to this. Therefore, the prosecution finds that the use of words, all Ombrians must be removed from the sacred territory of Tukhanov, constitute the mens rea that the victims are not returning
So in the case of prosecutor versus Radovan Kazic, the term forced from the first movement of civilians, it was not limited by the physical force, but it also included the fear of detention and the psychological oppression. And in the case of prosecutor versus Bosco Ntaganda, the court concluded that the order of displacement was not imperial as long as the displacement took place. So, in this regard, the prosecution prays for the court that it adjudicate and declare that all claims are admissible. Second, there is sufficient evidence against the accused Vande in the charges below. Number one, General Vande is criminally liable for war crimes of intentionally directing attacks against civilian population under Article 8, Paragraph 2, E, Roman 1. Number two, General Vande, the accused, is criminally liable for war crimes of rape under Article 8, Paragraph 2, E, Roman 6. And lastly, the prosecutor finds that the general is criminally liable for the war crime of ordering the displacement of civilian under Article 8, Paragraph 2, E, Roman 8 of the ICC elements of crime. May justice be served to this, and that it serves as an example to all commanders who will try to prevent, to evade, to cause, to...
Counsel, your time is up.
Thank you.
Defense, you have 10 minutes.
Your Honors, the opponent side and the rest of the audience, good afternoon. I'm called Lisa Ange Ishimwe. I'm the first counsel from the defense. I'm with Nancy Wested, the second co-counsel, and Janvier Mohoza, the third co-counsel. As the first counsel, I'll be talking about the overview of the case, the jurisdiction, and the nature of the conflict, and the inadmissibility of the case. The case at hand concerns General Gerard Vande, who was the chief of staff at the time. General Gerard Vande is alleged of crimes committed between 25th March 2014 to 28th January 2016. Although the prosecution advanced that General Gerard Vande is alleged to have committed war crimes, the defense, basing on the facts, finds General Gerard Vande not liable to this conflict, which they are calling an international armed conflict, rather to be an internal disturbance where General Gerard Vande and his army were fighting against the armed group. Your Honors, allow me to continue to the jurisdiction of this court. Basing on the Article 1, Paragraph 2 on Additional Protocol 2 of Rome Statute, it says that ICC have no jurisdiction on the cases of internal disturbance, riots, and ISIS. On the basis of the Principal Guide to Humanitarian Law, internal disturbance, there are situations in which there is serious or lasting internal confrontation, which do not necessarily escalate to open struggles. The authority may use large police and even the armed forces to restore order within the country. Your Honors, at the case at hand, in the case there was the confrontation was serious and it lasted a long period of time, as it started from 25th March 2014 to 28th January 2016. Your Honors, there was no open struggle. There was just a simple attack where the TAP soldiers was trying to restore peace within the country. You can see on paragraph 8, the Tukanov soldiers, they were just trying to restore peace within their country. Your Honors, the crimes committed was just ordinary crimes. For that case, we asked the court to bring this case to the ordinary court. Your Honors, allow me to go to the inadmissibility of the case. Pursuing Article 17 of the Rome Statute on the issue of inadmissibility, the case to be inadmissible, it should fulfill this criteria. It should have been investigated or prosecuted by a state which has jurisdiction over it, Your Honor. On paragraph 25, on 28th November 2015, shocking stories broke over the government Washington Post. An employee of the Tukanov Intelligence Bureau under the pseudonym Mr. Nesumo, disclosed thousands of confidential documents where the Tukanov Intelligence Bureau were conducting an investigation of this internal disturbance which was happening. Your Honors, in the case of the prosecutor versus Francis Komei Mataru and Uhuru Mugai Kenyatta and Mohamed Hussein Ali, they defined investigation as taking of steps directed at ascertaining whether this individual is responsible for that conduct. Your Honors, in our case today, the Tukanov Intelligence Bureau took steps in addressing the situation of crime which happened between 25th March 2014 to 28th January 2016. Your Honors, the case has no sufficient gravity to be taken to the ICC. Your Honors, as it was shown in the case of the prosecutor versus Lubanga, to meet the gravity, there should be these things. The object of the case should be committed on a large scale. Your Honors, this conflict wasn't committed on a large scale, as the conflict was just what happened in a small part of the state, and compared to the Buban states of Tukanov, few people lost their lives. As the prosecution, we find this case not to have enough gravity to be admissible in this court. Your Honors, our client, General Vande, is alleged to have committed the following crimes: count 1, war crimes of ordering attacks against civilians; war crime of rape; and count 3, war crime of ordering displacement. Your Honors, if it may please the court, allow me to lay to the second co-counsel to prove the innocence of our client on count 1 and count 2. Thank you.
Thank you, Honorable Judges. My name is Nancy Wase, and I'm here in front of this honorable court of ours. As the prosecution said that they're here to prosecute, Honorable Judges, for us, we're here to plead with this pretrial chamber that our client should not be held liable responsible for these following crimes that I'm going to explain. Count 1. General Vande is not criminally responsible under Article 25(3)(b) for the war crime of directing attacks against civilians under Article 8(2)(e) Roman 1 of the Rome Statute. Honorable Judges, the tough soldiers, although they received an order, they used the precautionary principles. Honorable Judges, according to paragraph 16, we have seen that the tough soldiers were outnumbered, and the local Ombrians are the ones who launched an attack on them first. So they fired shots as a precaution to disperse them, but they did not adhere to. So that made them to defend themselves, and which led to the death of 110 local Ombrians. So he had no intention of directing attacks to the local Ombrians. And Honorable Judges, according to count 2, we have the war crime of rape, whereby our client we deny that our client can be held liable for this war crime because he was not, at the time, he was not in effective control due to lack of material ability. According to Prosecutor versus Popovich case, effective control has been defined as the material ability to prevent offenses or punish the offender. Honorable Judges, at the time, General Vande, when the war crimes were happening, he was at the battlefield, so he lacked material ability. He lacked material ability to discipline his subordinates and control the crime of rape. Honorable Judges, allow me to pass the mic to the other one to explain count 3.
If it may please the court, allow me to represent my client before this honorable pretrial chamber. It was alleged by the prosecutor that General Vande is individually criminally liable for ordering the displacement of civilian population for reasons related to the conflict, unless the security of civilians involved or imperative military reasons so demand, punishable under Article 8(2)(e) Roman 8, based on committing crimes whether as an individual jointly or with another person under Article 25(3) Roman 3a of the Rome Statute. Your Honors, the prosecutor has the duty to prove beyond reasonable doubt that the crime was committed under the principle of actori incumbit probatio. The elements of this crime are not satisfied. The prosecutor has the duty to link the elements of the crime with the crime committed. There wasn't an order of displacement, Your Honorables. The only thing that was done was to gain back the FKA controlled areas. The civilians who went back to Akova, they went willingly. They went willingly. No one forced them to go there. Drawing from the fact, paragraph 21, most other Ombians fled to Kuka, to the Kuka-controlled areas in Kuka or to Akova for fear of detention. So we hereby say that our client, General Advande, should not be held liable for this crime of ordering displacement of civilians with military reasons not involved. And the prayer for relief is that the defense denied to confirm the charges of the prosecution and respectively request the Honorable Pretrial Chamber to declare that the case is inadmissible because of this is not an armed conflict, it is an internal disturbance, and that General Advande is not individually criminally liable for the war crimes that the prosecution alleged, respectively.
Thank you, Counsel, for the defense. Prosecution, rebuttal 5 minutes, and we can ask questions.
Thank you, Honours. I will start on the argument of non-international armed conflict. The prosecution submits that this is a non-international armed conflict because there was an armed conflict between an armed group and state forces. Now, I will say why it is an armed group. For an armed group to be established as an armed group, it must have a responsible command. Now, let's refer to the violence at Kuka province and establishment of FAK. On paragraph 8 of the facts, where it says that they organized a resistance movement, Free Kukan Army, appointed themselves as majors and colonels. This
Counsel, I have a question. For it to be a non-international armed conflict, must there be at least one state involved?
If I may ask Your Honor.
For it to be a non-international armed conflict, must there be at least one state as a belligerent or not?
There is a state in our case, which is Tukanovan, Buba state of Tukanovan, Your Honor.
Proceed.
Yes, Your Honor. Second element, which is exercise of control over territory. The FKA fulfilled these elements. You can refer to facts paragraph 9, where they said, after 3 days of heavy fighting, FKA took over Teria and controlled the connecting road of Teria and Havoka. And this fulfills the element of having a control over territory because they conquered it after a long fighting. Last element, which is able to conduct military operations, referring to facts paragraph 9, which is during this window, the FKA managed to recruit 200 women and women who were divided into 3 battalions, led by Ombre veterans, obtained light weapons, including assault rifles, grenades, and rocket propelled. It fulfills this last element of be able to carry out military operations. Thus, we say that this is a non-international armed conflict. Another one on the argument raised by the Defense Council, saying that according to Article 17 about the admissibility of the case, that the state carried out the investigation. The prosecution submits that this was not investigation. Rather, it was mass surveillance. The paragraph reads, the Nuson leaks and impingement of President Alert. And on the last paragraph, they say, Mr. Nelson claimed that the Alert administration intended to use this program to suppress its political opponents. They were carrying secret mass surveillance on its own people. Therefore, does not constitute a limit of investigation. If it may please the court, allow me to come prosecution. Thank you.
Thank you. I'll proceed with a rebuttal of a point that was raised by the defense, talking about self-defense. I would like to ask the prosecution to please elaborate to me how a self-defense comes in to 200 people that were there, yet 110 died.
Counsel? You're not allowed to ask, but you can challenge what they said.
Thank you, Your Honor. I challenge them, and I allow my co-counsel to proceed with this.
You have 20 seconds.
With regard to Article 31, which provides grounds for excluding criminal responsibility, it provides that the person acts reasonably to defend himself. This person might be excluded from criminal liability. With regard to the number of civilians died, is this reasonable for a defense? For 110 unarmed, harmless civilians to die and 30 injured, is this reasonable? If it may please the court, I would raise my case.
Thank you. Defense counsel, rebuttal 5 minutes, and we may ask questions.
Thank you, Your Honors. I want to start on refuting about the thing they said about the personal gains and about the inadmissibility of the case. Your Honors, pursuant to the Article 17 of the Rome Statute, it says that it should have, if there have been an investigation or prosecuted by a state, this case shouldn't be admissible in the ICC. Your Honors, as I have elaborated, investigation in the case of the prosecutor versus Francis and Uhuru Mugai Kenyatta and Mohamed Hussein Ali, they clearly define what is investigation. Investigation, this is taking of steps directed at ascertaining whether this individual is responsible for that conduct. Your Honors, in this case, on paragraph 25, that's all the Tukhanov Investigation Bureau was doing. Your Honors, I might also proceed.
I have a question. During your main submissions, you said that there was no material ability on the part of your client. However, it is undisputed that he managed to put down a mutiny. How do you connect those facts to the lack of material ability that you mentioned?
Let me pass the mic to my co-counsel.
Thank you, Honorable Judge. As accordingly in the facts of paragraph 18, according to the mutiny and the material liability, Honorable Judges, General Jervande, I use the case of prosecutor versus Popovich case, whereby they say that effective control has been defined as the material ability to prevent offenses or punish the offender. And before, after the mutiny, the investigative journalists of the gang reported that the mutiny was in effect partly due to the dissatisfaction of the soldiers due to the large-scale rapes that was going on within the tough soldiers. So, Honorable Judges, John Jervande lacked the material ability to prevent the crime to go on, and that's why he was not liable, criminally responsible under command responsibility.
Thank you, Your Honors. If you can proceed. On the prosecution side advanced something about the personal gains, that this war was it was because of the personal gains of General Jervande. Your Honors, as I said, we can't take the personal gains and put it in ICC. In ICC, the only crimes which the ICC has jurisdiction over, they are crimes against genocide, war crimes, crimes against humanity, and the crimes of aggression. Your Honors, personal gains, it equates to the internal disturbance. That is why we come here on inadmissibility of the case. As the defense side, we find this case not to be admissible to this court. Your Honors, if I can let my co-counsel to conclude.
Counsel, before you leave the stage, you have mentioned in your submissions that this is a situation of an internal disturbance, and I would like you to ask to differentiate an internal disturbance from a non-international conflict as put forward by the prosecution.
On the basis of the principle of practical guide to humanitarian law, internal disturbance, there are situations in which there is a serious or lasting internal confrontation which do not necessarily escalate into struggle, and also the authorities may use large police forces and even the armed forces to restore peace. In our case today, the confrontation of course lasted a long period of time. There was also an open struggle, though it didn't, there was no open struggle. It was just simple attacks where the TAF were trying to restore peace within their region. Your Honors, the crimes committed, the crimes committed were just ordinary crimes, where we can't say the intensity to which these crimes were on can amount to an international armed conflict. For an international armed conflict to exist, the intensity should be at a level which allows it to be called so. So as the defense side, we found this case not to be an international armed conflict, as there was no intensity and the gravity was not there.
So I want to take you back, Council. Do you have the facts before you? I want to take you back to the issue of the mutiny that was put down by General Vandi. Do you have your facts with you? Look at paragraph 17. So there's a sentence that says, in a public statement, the leaders of this revolt pledged their allegiance to General Vandi and demanded that the TAF engage with the HDA directly and, if necessary, across the border in order to respond to Hakova's support of the IKE. The mutiny ended in March 2015 after General Vandi visited the military camps where the insubordinate troops were based. So my question still is, didn't he have effective control where he could actually prevent or punish, because these guys had actually accepted his command?
Thank you, Honorable Judge. According to
that's the
paragraph
last question, because your time will be up.
So according to paragraph 17, whereby he came and formed these Buba Guards, the crime of rape was reported after the mutiny, where the investigative journalist of the Guardian reported that the mutiny had been caused, and that's when the rape crime was.
Materiality. That means he can prevent or punish because they pledged allegiance to him. But thank you, Counsel, for all your submissions. We thank both Prosecution Counsel and Defense Counsel for your submissions. Court is adjourned. Can we have the next teams who are going to be UNILAC on the prosecution side and UOK on the defense side? Can we have the next teams, please? Julien? Good afternoon. Court is called to order. Prosecution, defense. You will both have 10 minutes for your main arguments, and then you'll have 5 minutes each for rebuttal, where we can ask questions. We are very strict on time. So we are going to be very, very strict with time. And the judge on my left will be showing you what time is left, so please pay attention to that. Okay? Prosecution?
Honorable judges, I'm Darius Nessa Davis, the lead counsel for prosecution. I'm here today along with two co-counsel, and they are
Honorable judges, I'm Counsel Kelly Ineza. Honorable judges, I'm Counsel Esther Ingaviti.
Thank you both. Honorable judges, before we proceed to the case, we like to give the qualification in regard to the conflict within the case. And to qualify this case, the conflict indicates that this is a non-international armed conflict. Honorable judges, according to paragraph 2 of this case, it implies that the armed conflict here existed between two states, one state and an organized armed group. And according to Article 1, so Article 2 of Additional Protocol 2, it entails that conflict of such nature that exists between a state and an organized armed group is qualified as a non-international armed conflict. We proceed. The accused here today is General Gary Vende. He is the most senior officer within the TAF2. He provides advice to the president and that of the defense minister in regards to military operation. Honorable judges, I do further proceed to let you know that the ICC have jurisdiction on a case that is about to be adjudicated today. Honorable judges, ICC have jurisdiction on the current case in pursuit to Article 5, Article 13, and Article 25 of the Roman Statute. With this being said, I kindly submit and call for the first speaker of co-counsel to proceed on the charge number 1. Thank you.
Honorable judges, I am co-counsel Ingaviti Esther, and I'll be presenting the first charge. General Vande is charged with intentionally directing attacks against the civilian population in pursuant to the Article 8, Sub-Article 2E, Roman 1 of the Rome Statute. It is on the basis of individual criminal responsibility that we base our charge, pursuant to the Article 25, Sub-Article 3B of the Rome Statute. Honorable judges, allow me to proceed to the actus reus, where I will be demonstrating the evidence of the killing of populations. Honorable judges, I would like to refer you to the facts of the case, paragraph 16, where it was reported by the local media that 110 civilians were killed and 30 were injured. This is to prove as evident that there were active killing of civilians by these incidents and by the TAF forces. Without further ado, honorable judges, allow me to proceed to the mens rea, where I'll be demonstrating manifestation that General Vande intentionally directed attacks on the civilian populations. Honorable judges, according to the Article 30, Sub-Article 3 of the Rome Statute, that states knowledge means awareness that a circumstance exists or a consequence will occur in the course of ordinary events. In reference to the paragraph, to the facts of the case, paragraph 16, where I will refer you that General Vande was the owner of 90%. General of the Lannister Enterprises, General Vande was a good friend of Mr. Lannister, which puts him in a position to know that the trucks were robbed before, and he ordered the troops to protect the Saint Enterprise at all costs, meaning giving them the right to kill civilians on site. Without further ado, judges, I refer you to the facts of the case, paragraph 16. This cap demonstrates General Vande is involvement in the Lannister Enterprises is an indication that this humanitarian thing that they were referring to is actually business related more than humanitarian support. Without further ado, honorable judges, I would like to welcome the co-counsel for the charge number 2.
Thank you. Honorable judges, I'm going to be proceeding with charge number 2, which is war crime and rape. On the basis of command responsibility, General Gary Vende is charged with crime of rape and sexual abuse that happens at the TF2 deployed at Kuka Province in pursuit to Article 28 of the Rome Statute. The actual crime here is qualified as a war crime in reference to Article 8, Sub-Article 2, Roman 6 of Additional Protocol 2. Honorable judges, to establish the atus real of this case, it implies that there are two reasons that qualify that there existed rape and sexual abuse within the TAF. The report from the investigator journalist, it confirmed that the major reason for the immunity within the TAF was due to the large scale of sexual abuse within the TAF. Honorable judges, another report came in conformity to the previous one. That was the report from the human rights, according to paragraph 18 of the fact of the case. It confirmed that there existed another, what we reference are sexual predation within the TAF. Honorable judges, with these two tangible reports, taking into consideration that the Human Watch is an independent body, these two reports that confirm that there existed what we reference as rape and sexual abuse, it qualifies the atus real. In reference to what we refer to as the mens rea, honorable judges, I'll make a clear reference to Article Rule 153 of the ICRC International Customary Law. It implies that commanders and superiors are under responsibility to provide, they are under responsibility basically to take responsibility of whatever crime that is committed by their subordinate if they knew and had all reason to know and did not provide supervision in order to prevent it. Honorable Judge, with this, you can clearly understand that General Gary Vandy knew the actual existence of the rape and sexual abuse within the TL. With all this evidence and fact, I do submit and welcome my co-counsel. Thank you.
Honorable judges, allow me to proceed on Charge 3, which is war crime of displacement of civilian population. Honorable judges, pursuant to Article 8, Sub-Article E, Roman 8, and Article 25, Sub-Article 3A of the Rome Statute, General Vande is charged with criminal responsibility for displacement of civilians in an international armed conflict, and General Vande bears individual responsibility of the crimes. Honorable judges, allow me to proceed on the grounds of the crime. Honorable judges, the first ground of the crime, which is actus reus, I will demonstrate civilian displacement for reason related to armed conflict. Allow me to refer you to the paragraph 21 of the fact of the case, where under Operation Brank, Umbrians were forced to convert from Umbrians to Buba religion. And allow me to pursuant to Rule 129 of ICRC Customary International Humanitarian Law, it prohibits ordering displacement of civilian population. Honorable judges, allow me to proceed on second ground, mens rea, where I will demonstrate the commission of the crime, whereby General Vande was chief architect of such displacement. Allow me to refer you to paragraph 19 and 20 of the fact of the case, whereby General Vande orders to flush all the residents and force Umbrian to convert to Buba, which is contrary to Rule 104 of ICRC Customary International Humanitarian Law, which guarantee respect for conviction and religious practice. Honorable judges, having presented the three charges and proven the elements, allow me to proceed to the prayer of the prosecution. Pursuant to Article 61 of the ICC statute, the prosecution hereby submits to have adequately proven legal, mental, and material elements for each of the charge. The prosecution counsel prays to the court to adjust and confirm the charge as follows: that General Vande is criminally liable for war crime of intentional killing of civilian population, that General Vande is criminally liable for war crime of rape and sexual abuse on the basis of commander responsibility, and that the General Vande is criminally liable for war crime of causing mass displacement of civilian population. Thank you, honorable judges.
Thank you, counsel, for the prosecution. Counsel for the defense, 10 minutes.
Good afternoon, Your Honors. I'm Didier Avugimana, together with my co-counsel, Latifa Maliza and Geoffrey Kabagame. We stand here as counsel for the defense of General Gerard Vande. Your Honor, if it pleases the court, I will be addressing the court with regard to the jurisdiction and the mode of liability and material prerequisite for war crime. My co-counsel Geoffrey shall address the court with regard to the lack of the specific element to establish rape as a war crime, and co-counsel Latifa shall address the court with regard to the court's lack of specific elements establishing the displacement of civilian as war crime. Your Honor, the defense respectively request the court to find that it lacks jurisdiction due to the fact that it lacks material jurisdiction, Your Honor. Your Honor, under Article 12, Paragraph 1 of the ICC statute, it stipulates that the precondition that the accused must have committed crimes referred to under Article 5, that is either genocide, crime against humanity, war crime, or crime of aggression. Your Honor, the defense argues that General Vande committed neither of the crime alleged against him, especially war crime. Your Honor, the defense requests the court to find that there is no material and contextual element to establish war crime. Your Honor, the prosecution alleges that there is an international armed conflict, and that has been going on since March 2014 to January 2016. However, there is no evidence to support the existence of the intensity of intense confrontation between the TAF and the FKA. Your Honor, an armed conflict does not just exist because the prosecution wanted to exist. Your Honor, the engagement and confrontation between TAF and FKA should not be presumed. During this whole period, not even once has either a member of the TAF or a member of the FKA ever met on a battlefield or exchanged fire or any other ground that could establish intensity or any form of confrontation between the two. That's why we find that the court should deem that there is no material element. Your Honor, referring to the court to prosecution Vastadich, paragraph 561, the precondition necessary to establish an international armed conflict that the protracted armed violences must exist between a government authority, force, and an organized armed group. Hostilities must reach minimum level of intensity and duration. And as we have proven, so far, there haven't been any conflict or active engagement between the two armed forces that mentioned. In relation to the situation Kuka, I would like to carry on in relation to count 1 of attack against civilian. Your Honor, Article 8, 2E, 1 of the ICT covers the provision of intentionally directing attacks against civilian population. Your Honor, I would like to repeat the word intentionally. This means that the perpetrator must have intended the civil population as the target of the attack, which is not true to the case at hand. Your Honor, General Vande intention was protection for the trucks that had facing attacks whenever they were entering and delivering the humanity through the FKA controlled areas. Furthermore, Your Honor, we would like the court to find that the individual referred to as civilians during the incident of 10th November 2014 are not civilians. Your Honor, the defense invoked the case of prosecution Vascalist Barushimana, paragraph 148, in which the chamber affirmed that in instances where civilians they lose their civilian status, protection civilian. the civilian instigated the incident of the 10th November, Your Honor, by deliberately attempting to rob the convoy and shooting the first shot, Your Honor. It is on, Your Honor, I would like to call my co-counsel to make their submission.
Thank you, Your Honor. As mentioned by my co-counsel, my name is Geoffrey Kabagambe.
As mentioned by my co-counsel, my name is Geoffrey Kabagambe, and criminal activity of the Rwanda and the Rwanda state regarding to the crime with regards to the crime, the next crime committed.
Thank you. Yes, with regards to whether to find that General Vande is criminally responsible for is criminally liable for the rapes that occurred in the Kuga province by the senior army officers against the junior army officers. Your Honor, the prosecution case tonight is based on information from journalists. I'd like to draw attention to the fact that there was an investigation mandated by the United Nations General Assembly, and it came back with inconclusive results, meaning there was no evidence to show that there were people who were raped. Your Honor, I'd like to point out that there needs to be two elements so that for this crime to be established: the perpetrator and the victim. Throughout the engagement and throughout the case files here, we do not see a name. We do not see a name of who raped who, where, when. This disqualifies the material element of the argument that there was a crime of rape as a war crime. Your Honor, for the crime of rape, as explained already, there needs to be a perpetrator and a victim. General Vande could not have established this has happened if there was none that came to him. Also, let me point out that after the mutiny, General Vande went to find out what had gone wrong. And what was brought to his attention was that the military officers were not satisfied with their positions. They were promoted, and he sorted the problem. Now, rape came on later on from journalistic investigations that are also highly questionable when it comes to credibility and neutrality in the conflict, because the United Nations mandated investigation here came back and said we cannot confirm, came back and said they couldn't confirm that there was actually rape. Your Honor, the crime not existing absolves General Vande of the criminal liability of any crime by his subordinates, because that crime does not exist. The crime could have only existed if there was a perpetrator, if there was a victim, defined perpetrator and victim, not generalizations, because at this point what we see throughout the engagement is people were raped, junior soldiers were raped. Who raped? Where? When? Did all the soldiers rape? Were all the junior soldiers? With that, we would like to submit that General Vande shouldn't be held criminally liable for a crime that is inexistent. With that, I'd like to call my co-counsel to address count 3.
Thank you. My name is Maliza Latifa, and I'll be addressing count 3. The defense submits that General Vande is not criminally responsible for the commission of the war crimes of displacing civilians provided under Article 8, 2E, 8 of the Rome Statutes. Your Honor, the Operation Blank started from March and ended in October 2015. Your Honor, in this Operation Blank, General Vande had a name of restoring the territorial integrity. And he did this because we can see that multiple municipalities were recaptured. Your Honor, there was no aim of ordering displacement of people here. Even checking that the facts of the case, there is nowhere where they say that General Vandi said or told them to move away from the state. No, it's not there. Therefore, we find that General Vandi is not criminally responsible for this case. Your Honor, the elements to define this crime. One, the perpetrator must have ordered the displacement of the people. It was not there. They did not order the displacement of the people. Your Honor, element 2, such an order must have been justifiable by the security of the civilians involved or the military necessity. No, he was trying to spread his religion, the Buban religion. He was not telling the people to go away. Your Honor, we as the defense play that General Vandi should be found, should not be charged of the crimes in count 1, count 2, and 3 respectively, and proving that the legal basis and there is no legal basis and factual evidence to prove that these crimes were indeed committed. Because we only see hearsays, we don't see him ordering, we just see people said, people reported. With this, Your Honor, we arrest our case.
Thank you, Counsel, for the defense. Prosecution, you have 5 minutes for rebuttal, where we can ask questions.
Thank you, Honorable Judges. So I'd like to make a comment in regards to the questioning of the jurisdiction of the case in the ICC. Honorable Judges, we'd like to establish the fact that according to Article 5 of Additional Protocol 2, it implies that ICC have jurisdiction on this case. There are cases of which ICC have jurisdiction on. Kindly permit me to reference them. 1 is crime against aggression. 2, crime against humanity. 3, war crime. And these crimes are actually perpetrated in the truth. It implies that the court here have competent jurisdiction to adjudicate this case. It is so unfortunate that we will be questioning the jurisdiction of this court when Article 5 clearly references that the court has jurisdiction in regards to these cases that they are subject to. Honorable Judges, there was another thing here mentioned by our opposing counsel. They did mention that there was no intense evidence. It is unfortunate that a conflict that existed that resulted to the death of 110 and injuring 30, and you are saying that there is no level of intensity to that. That is a barbaric. I don't even know the description to give this.
Counsel, is there a requirement for intensity as an element of the crime you're alleging?
Your question again?
Is there a requirement that there be intensity?
Fine, Honorable Judge. Thank you so kindly. There is no specific evidence to prove that there should be a intensity before it is qualified. The fact that a single civilian died into the process, automatically it gave a qualification to this case. Thank you, Honorable Judge.
What's your basis for saying that?
Okay.
Are you relying on law? Are you relying on jurisprudence for the one civilian that you just mentioned as proof of a crime?
Thank you so kindly. I will resort to that in a subsequent time. Can I proceed? Thank you so kindly. In reference to count 3 here, they said that there was no material element for the qualification of this case. Honorable Judges, we have given you 2 justifiable reports that are in conformity with one another, indicating that there existed sexual abuse within the TF2. Taking into consideration that the Human Rights is an independent body, and their report actually came in conformity with the previous report provided by the investigator general guy. Honorable Judge, this alone qualifies.
Counsel, what is the weight that the chamber should give to a human rights report?
Your question?
What is the weight that the chamber should assign to a human rights report? You seem to be suggesting that it is proof beyond reasonable doubt.
The rate? Actually not.
Counsel, the question is, what value should we add to a human rights report? What is its legal value in terms of the charges?
Okay, so in reference to the charges that are meant to be allotted when there is a violation of such kind, it is mentioned in the fact of the case here. Article 28 of the Rome Statute, it implies that this particular crime actually is a war crime. This is the legal qualification to give to that. Thank you.
Proceed, counsel.
Okay, in proceeding to the next here, there were additional point that was referenced by our colleague here for. It is unfortunate that they are actually now much more familiar with the case. The last counsel here mentioned that the conflict existed between March of 2014 to October of 2015. This is unrealistic. The conflict actually existed from March. The conflict actually existed from March in 2015 and it ended in December. We urge that they familiarize themselves with the merit of the case. Honorable judges, with this point, I submit and wait on the adjudication of the competent court. Thank you.
Thank you, counsel, for the prosecution. Now we turn to the defense. Your rebuttal for 5 minutes where we can ask questions.
Thank you, Your Honor. We would like to address the prosecution mentioned that there was sufficient element to establish the. We would like to highlight that the prosecution has failed to establish a nexus between the isolated incidents that happened with a war going on. The incident of the 10th November has no link with the alleged armed conflict that is going on between the TAF and the FKA. They failed to prove any nexus where it was, and this is one of the contextual elements that must exist for any war crime to be established under in front of the ICC.
Counsel, let me stop you right there.
Yes.
I want to quote you on what you said during your main submissions.
Yes.
You said, civilians instigated the incident.
Yes.
So if a civilian instigates an incident, does that take away from them being a civilian and being protected?
In our submission, we wanted to highlight. We highlighted that being a civilian does not preclude someone from. There are times when a civilian could lose their protection status as a civilian the moment they engage into hostilities, and the action of the civilians in the incident of the 10th November by attempting to rob the convoy and shooting the first shot, which led to the death of those civilians. It was clear that they were actively participating, no longer, and this removed their protection status as civilians. Thank you.
Proceed.
I'd like to.
Thank you, Your Honor. I'd like to address the questions raised by the prosecution with regards to count 2 on criminal liability of General Vande. Your Honor, we waited for the prosecution to establish that this crime actually happened with no speculation and with no imagination and personal opinion. They should have established facts. It happened.
Council, let me stop you right there.
Yeah.
In your main submissions, you did in fact say that the prosecution did not define perpetrators and victims. Am I right?
Yes, Your Honor.
Is it a requirement?
For a crime of rape to exist, for a crime of rape to be defined, to exist, there needs to be the person who committed the rape and the person who was raped. Under command responsibility, this would have existed if General Vande would have been criminally responsible for this action having happened if it actually happened. You see, Your Honor, I'd like to submit to the court that every argument brought about by the prosecution is all based on speculation and vague information and also large terms. So that, in a way, that actually makes puts away the material element of the crime.
I'm not quite sure that you're leading your argument all the way to the end. You're saying it's speculation, you're not telling us how it is speculation. You're saying they needed to have defined perpetrator and victim, you're not saying how they didn't define and what they should have done.
Yeah.
Can you assist the chamber, please?
Yes. I'd like to assist the chamber understand this. For the element of the crime, to exist, one, there needs to be the material element. There also needs to be the mental element and the legal element. Your Honor, the material element here is lacking. The material element being the people, the abusers, and those who were abused. The moral element that we can establish.
Counsel, is it enough for the prosecution to just define by saying the senior soldiers in, for example, FKA raped the victims?
It is not enough. It is not enough because we need to see the victim. We need to know that the victim this and that was abused in this way, and it cannot come from a vague and large term because there is also. Yes,
What's
sir.
the basis for your argument?
By basis.
Jurisprudence, law, to support your argument?
Yes. Under Article 2, under Article 8, Paragraph 2, Roman numeral 6, there is an establishment of when, number one, the elements of rape, the elements of rape as a war crime, they are established here where there needs to have been forceful penetration. It explains it in three forms: forceful penetration or anally or any other form for the.
Counsel, I am now completely confused. Are we talking about the elements of the crime, or we are talking about the definition of the perpetrator and victims? But I think you're also out of time.
I'm out of time.
Okay. Thank you to both counsel on both sides for your submissions. The bench will let you know what follows next in due course. We thank you. And we now invite the last group. You are on the prosecution side, and UNILAC on the... Court is called to order. Prosecution and... Can we have silence in the gallery, please? Thank you. Prosecution and defense counsel, you have 10 minutes each for your main submissions, and then we'll give you 5 minutes each for rebuttal, where we can also ask questions. Prosecution?
Thank you, Your Honor. This is the prosecution prosecuting General Rwanda for the crimes of directing attacks to the civilians not taking part in the hostilities, command responsibility under the, for the crime of rape, and directing and ordering displacement of civilians. Your Honor, I'll start talking about the admissibility of the case pursuant to Article 17, Paragraph 1 of the Rome Statute. It gives the state of where the crimes are being committed the priority, and the court can only have, the ICC can only have the jurisdiction when the state is unwilling to prosecute. And per case at hand, the state was not willing. Pursuant in Katanga case, paragraph 78, it was held by the court that the unwillingness of the state to prosecute, it can be derived from the undue delay. Your Honor, the nature of the armed conflict is a non-international armed conflict, as it was stated in the Tadic case, that it should involve the protracted violence of the armed group vis-a-vis the government authorities. Your Honor, the Article 3 of the Geneva Conventions plus the ICRC commentary have highlighted two things that should be evidenced in the non-international armed conflict, which is the intensity and the organization of the armed conflict. For the intensity, it can be vindicated by the weapons and military equipment used, plus the number of civilians fleeing. And about the organization of the armed group, it should have the capacity to sustain the military capacity. And in the Rubanga case, it was also ruled that the operations were prolonged, which makes this conflict a non-international armed conflict in nature. Your Honor, if it may please the court, I would call upon my co-prosecutor to proceed with prosecuting on first account.
Thank you. Prosecutor Lilian Karijirwa, and I'm going to be proceeding with the first count. General Rwanda is criminally liable under Article 25, Paragraph 3, Alinea B, for inducing the commission of war crime of directing attacks against civilians not taking direct part in the hostilities under Article 8, Paragraph 2, Subparagraph E and Alinea I of the Rome Statute. The prosecution submits that the accused intended to direct an attack against civilians not taking direct part in the hostilities. On 10th November 2014, General Rwanda gave an order to the leader of the task force to protect the convoy with all necessary means. This order is what induced an indiscriminate attack against Umbrian civilians who had come to rob the trucks, leaving 110 dead and 30 injured. Your Honor, the prosecution submits that during this attack, the principle of distinction and the principle of proportionality were not respected. The principle of distinction, which tells that under Rule 1 of the IHL customary rules, that the combatants must always distinguish between the civilians and the combatants. It is an uncontested fact that the shots came from within the crowds, but nothing ties all the shots to the civilians to entail the loss of their protection. Moreover, they used excessive force, which caused massive casualties. Because when you look at the number of civilians who died, 110 dead and 30 injured, this entails the principle of proportionality wasn't used by the task force, because they should have only used that force against the ones who were attacking them. The prosecution further submits that the mens rea element is met since the accused intended for the civilians not taking part in the hostilities to be the object of attack. Honorable judges, General Rwanda had actual knowledge that the civilians robbed the trucks whenever they arrived at the FKA-controlled areas due to his affiliation with Landstar Enterprises. General Rwanda, when giving this order, and I quote, protect the convoy with all necessary means, meant protected from the civilians, and by interpretation, protection meant attack. It is with this that the prosecution holds that the accused bears individual criminal responsibility under Article 25, Paragraph 3 of the Rome Statute, basing on Rule 152 of the IHL, which provide that superiors are responsible for the war crime pursuant to their orders. General Vande gave this order which induced an attack, thus rendering him criminally liable for this crime. I'm going to proceed to the next, I'm going to call upon my co-counsel to proceed to the next count. Thank you.
Thank you, Your Honors. I'm Counsel Monisha Adika, and I'm going to proceed with the second count, that General Vande is liable under command responsibility of Article 28, Alinea A, for the crime of rape committed by his subordinates, basing on the fact that he had effective control over the troops, and he failed to take the appropriate measures upon the knowledge of the commissions of the crimes. Secondly, I'm going to talk about the third count, which states that General Vande is individually responsible for ordering the displacement of civilian population pursuant to Article 25, 3A. To begin, the Birigirishema case has stated this court should answer affirmatively. First, that was there a crime? Yes, the crime of rape was there, and it was perpetrated by the subordinates of General Vande, basing on the facts in paragraph 18, investigative report of the Guardian, which is in corroboration word to word with the Human Rights Watch report, which states that there is a system of sexual predation within the TAV troops. Moving forward, General Vande is held liable also pursuant to Article 50 of the Second Geneva Convention and Rule 153 of the IHL customary law. And as stated, the three-part test of command responsibility is established. There was a superior subordinate relationship of effective control. General Vande was in charge of all TAF troops in the country, and this entailed that he had the responsibility to control properly over the forces. Therefore, the acts of these forces are attributable to him when he did not take into account to control them. Moving forward, General Vande also had reason to know that the crimes were about to be committed or had been committed. It is stated that it only in the Muchik et case that it is sufficient to have reason to know about the commission of the crime. General Vande had reason to know, and this is established by the interview of the Guardian, whereby he was asked about the question to make a statement on the sexual abuses, and this establishes that he was made aware of the sexual predation activities present in his troops. Your Honor, with this knowledge, General Vande, what is going to hold him liable is what he did next. He should have taken the necessary measures. General Vande did not take the necessary measures as prescribed under Rule 153 of IHL, which states that he should either prevent, punish, or report. Basing on the facts, it could be probable that he did not know prior to the commission of the charges, but however, he knew, he had reason to know because of the Guardian, and he did not punish. He did not punish or report, rather he tried to escape liability by saying that he's not responsible for the acts of his troops. If the court pleases, I will move forward to the third count. The accused is individually liable for the crimes of ordering the displacement of civilian population. And this is because of the order that he gave of detention, in which the circumstances or the actual consequence was the displacement of civilian population, basing on facts, on the paragraph 21 of the facts. It is evident that the Ombrians were intended to be the object of displacement, and according to Naganda case, it is not limited to the order. It should not be limited to the order to displace, rather the circumstances of the order when they are met. Upon this, Your Honor, I would like to present the prayers of the prosecution that General Vande be held liable by this honorable court upon all charges, since liability has been established. Thank you.
Defense, 10 minutes.
Honorable Judges, I am Darius Nestor Davis, lead counsel for defense. I'm here today along with two co-counsel, and they are
Honorable Judge, I'm Counsel Uineza Kelly.
I'm Counsel Ingavide Esther.
Thank you. Honorable Judges, to proceed with the merit of the case, we want to give the classification of the conflict in relation to the case. Honorable Judges, I would like to refer you to paragraph 2 of the fact of the case that entails that the conflict existed between a sovereign state and that of an organized armed group. According to Article 1, Sub-Article 1 of the Additional Protocol 2, it entails that conflict of such kind that exists between a state and that of an organized armed group and take place on the territory of the state automatically is an or non-international armed conflict. Honorable Judges, the accused today is General Gary Vendi. He is the most senior officer within the TAF. He advised the president in relation to military operation. There are basically 3 charges here today. Charge involving the ordering and soliciting a direct attack against civilian. And charge number 2, rape and sexual abuse. Charge number 3, the displacement of civilian population. Honorable Judges, the court here has competent jurisdiction to adjudicate the case. The ICC has jurisdiction on a current case based in pursuit to Article 5, Article 13, and Article 25 of the Rome Statute. With this being said, I kindly submit and welcome my co-counsel to proceed with charge number 1.
Honorable Judges, I'm co-counsel Ingavide Esther, and I'll be presenting the defense of General Vender. Honorable Judges, I would like to proceed to the first charge, where the first count where General Vender had no intentions of killing civilians. The civilian death occurred as a result of self-defense. Now, as we mentioned above, in reference to the facts of the case, paragraph 16, it is clearly stated that the 200 Ombians was the first one to attack the convoy, and due to their overwhelming and attacking, like trying to take arms from the TFA troops, that's when the troops shot in the air to disperse the crowd. There was no intention to kill the civilians, it was to disperse the crowd. In reason to that, the crowd, the 2 shots were fired from in the middle of the crowd, which caused a TFA soldier to die and the truck driver. Now, based on this, on Article 32 of the Rome Statute, based on the Article 32 of the Rome Statutes that clearly distinguished the criminal liability from Lycarian, since he was acting in self-defense. Pursuant to ground number 2, there was no intention to kill civilian. Actually, as I mentioned before, Honorable Judges, an intention is a mental element. It is a component that has to be proven for a person to be criminally liable of a charge. Now, in this case, Honorable Judges, I refer you to the facts of the case, paragraph 16, that clearly states, and I quote, that the FA troops fired of warning shots with the intention to disperse the crowd, not to attack the crowd. Honorable Judges, this proves that beyond reasonable doubt that the intention was not to attack civilians, but to disperse the crowd, and as so our client should be exonerated and cleared of this charge. Thank you, Your Honor. I would like to welcome my second counsel to talk about the second count.
Honorable Judges, I would like to proceed to defense to count 2. It is alleged that General Gary Vendi is liable for the commission of rape and sexual abuse on the basis of command responsibility in pursuit to Article 28A and Article 8, Sub-Article 2E of the Roman Statute. Honorable Judges, this is in relation to the report provided by the investigatory journalist. In our defense, there are 2 things we're going to be taking into consideration here today. Honorable Judges, there is a general principle of law that implies that And it is the in dubio pro bio. It implies that when there is no sufficient evidence to prove the guilt of the accused should be exonerated. And my client, General Gary Vendi here, should be exonerated in reliance to this principle. Honorable judges, there are two, basically there are two reports that are contradictory. The first report from the TAF press, it implied that the sole reason for the immunity was due to the fact that there was dissatisfaction of the civilian population, that there was no vigorous approach in order to protect the territorial integrity. And the second report entails that there was a sexual abuse. Honorable judges, there are questions that are racing through our mind as to which of these reports should be taken into consideration. And the principle of in dubio pro bio is exonerate my client, General Gary Vendi. To move on further, honorable judges, the lack of material element of the issue of sex or sexual abuse within the truth. Honorable judges, how can you define that there was a rape and sexual abuse within this or TAF when they are contradicting report? We'll move further that, in fact, cases relating to rape and sexual abuse, there should be an expert assessment to qualify that the actual crime existed. There was no assessment in regards to that. Honorable judges, it's because of this that Article 42 of the Rome Statute on the case of sexual violence, it report that the judges of ICC should be able to indicate legal expert to provide that there was a system or there was a reason for the establishment of rape case. This particular case lacked mental element. To further conclude in regards to charge 2, honorable judges, with this evidence being provided, General Gary Vendi is not criminally liable for the commission of rape and sexual crime because it does not have material element, and there are also contradictions that provide that in dubio pro bio can exonerate my client. Thank you. And I move on to my next counsel as well.
Honorable judges, allow me to proceed on the events to count 3 by asserting that General Vendi did not commit war crime of displacement of civilian population. Honorable judges, pursuant to Article 8, sub-Article 2E, Roman 8 of the Rome Statute, and pursuant to Article 25, sub-Article 3A of the Rome Statute, General Vendi has been accused of mass displacement of civilian population and on the basis of individual criminal responsibility. Honorable judges, allow me to defend this based on the first ground of the crime, which is actus reus, where we demonstrate that General Vendi acted on superior orders. Honorable judges, allow me to refer you to paragraph 12 of the fact of the case, where President Arrett gave instructions and in order to General Vendi to undertake military operations that lead to displacement of civilian population and crush on terrorists by all means. Honorable judges, pursuant to Article 8, sub-Article 2E, Roman 8, General Vendi should therefore be relieved of criminal liability, whereby I will proceed on the second ground of the defense, where I will demonstrate the lack of mens rea to exonerate General Vendi. Honorable judges, allow me to refer you to paragraph 21 of the fact of the case, whereby more than 80,000 Umbrians were detained due to lack of time to attend the boot camp classes as the act was ordered. So most of the clients fled from those areas because of fear of detention. It is clear that displacement of civilians occurred without another that was implicated to them to do so. Honorable judges, pursuant to Article 8, sub-Article 2E, Roman 8 of the Rome Statute, it requires that accused must have ordered the displacement of civilian population for reason related to conflict. An order cannot be implied but must be an open step that compels a person to do something. Hence, the charge should be dropped and exonerated from my client. Honorable judges, having presented the all charges for General Vendi, allow me to present the defense prior to the court. Pursuant to Article 61, sub-Article 7 of the Rome Statute, the defense hereby submits to the court to decline confirmation of all the charges and declare as follows. General Vendi is not criminally liable for war crime of intentional killing of civilian population. General Vendi is not criminally liable for war crime of rapes and sexual abuse. That General Vendi is not criminally liable for war crime of causing mass displacement.
Thank you, counsel, for the defense. We shall now have 5 minutes to hear from the prosecution in rebuttal, where we will be also able to ask questions.
Thank you, honorable judges. Let this be brought to the attention of the court that the only threat that the civilian posed was to rob the trucks. That was the only threat. From the facts of the case in paragraph 16, it is indicated that once the convoys arrived at the FK controlled areas, the civilians only attacked the convoy to rob. Honorable Judge, that threat shouldn't have induced them to lose their civilian protection status, as the prosecution alleges. Even if the court does find that all the task force did was in the name of self-defense, that shouldn't have stopped them from using the principle of proportionality, as it was held in the prosecutor versus Garlic, where the ICTY held that the parties must first assess that the intended target is not a civilian and refrain from excessive force. The tough soldiers employed excessive force, leading to an excessive loss of lives. Honorable judges, 110 people lost their lives and 30 people got injured. From this, it shows that from this omission, the gravity can be seen. From this, it tells that the principle of proportionality wasn't respected due to the fact that the task force employed excessive force that wasn't necessary. And due to the fact that General Vande is the one who gave the order, he should be held liable over this because all the task force did was done in the name of protecting the convoy with all necessary means. I would like to call upon my counsel to continue with the next one.
Thank you, Your Honors. I will be replying to what was stated by the defense. It was stated in the Gombo case. They challenged the evidentiary substance as it was not collaborated, as they have said. But in Gombo case, it was ruled that open source evidence, such as press release, should be left to the discretion of the court to declare whether it has the weight or it has higher weight or lower weight. So it is still admissible before this court, the report of the Guardian and also the report of Human Rights Commission, since it is in conformity together, the information is consistent. Moreover, General Vande, when questioned about this, he did not reject the accusations of rape upon his subordinates. He rather tried to escape responsibility, and this does not exonerate him from liability. To answer what was raised by the third defense counsel, it was raised in the Pinochet case before the International Crimes Division, whereby the House of Lords rejected the defense of acting in official capacity. This is because...
Counsel, Pinochet case of where?
It's from the UK. It is a common...
Is it binding on this court?
It is not binding on this court. However, it is sought out for inspiration, since it is the case that shows how official capacity, acts in official capacity cannot be taken as a defense.
Proceed.
Yes. This cannot be taken as a defense because it must establish that displacement, acts of displacement, is done as a duty. Therefore, since displacing civilians was not the duty of General Vande, therefore, he is still supposed to be held liable.
Counsel, in your main submissions, you referred to a case of Bajiri Shema.
Yes.
Which year was that case, and are you referring to the appeals case or the prosecution case? Sorry, trial chamber.
Your Honor, the Bajiri Shema case that we referred to is of 2003, and it's in the paragraph 401.
Is it an appeals case or a trial chamber case?
It is a trial chamber case on confirmation of charges.
So in terms of hierarchy of jurisprudence, should this chamber be relying on a trial chamber jurisprudence, which may have been overruled on appeal?
If I may confer with my co-counsels. as this case of Bigirishema was brought before this court itself, therefore it should be regarded as inspiration. And since there is no more other, even other cases like the Bemba case still referred to the same requirements as set in Bigirishema, therefore this court is called upon to take the same
Thank
approach.
you, counsel, and that ends your time. Shall we hear from the defense in rebuttal? 5 minutes.
Thank you, honorable judges. I would like to proceed to what the prosecution say in the principle of proportionality, and I would like to explain to your honors that you can distinguish the civilians who have already been immediately objective. In reference to the Article 32 of the rules of the international humanitarian law and other rules to the conduct of the hostilities, these civilians were armed. They were carrying forces. So there was to be no distinctions between them being civilians or not because they were armed. On following to the second account where they refer to, where General Vande was accused of knowing that the soldiers were performing sexual abuses and rape to the subordinate people. There is no person who came up as a victim as a result of rape and sexual abuse. And there is no report from a specialist or a person specialized in sex offenses to qualify that this was not consensual sex, as it was stated by General Vande that all his subordinates are adults. And proceeding to the...
I'm not quite sure I'm following. Are we talking about consent in this particular, the circumstances of this case?
Yes, we're talking about consent.
So what happens to the jurisprudence in international criminal law where coercive circumstances override the requirement for consent?
Your Honor, I did not get the question.
Okay.
I would like to repeat you.
So during war or massive crimes being committed, as long as you can prove coercive circumstances, you don't have to prove consent. So can you link that to the circumstances of this case and how your client is actually innocent?
Thank you, Your Honor. To the coercive circumstances of this case, it was based on hearsay because there was not actual person who came forward and say that the soldiers raped him, the superiors raped him or her. There was no actual person who came before and stated those facts, in which the humanitarian support should have acted, and based on the fact there should have been we have an actual person who was raped, and even though they would actually choose to hide his identity, we should be given that he is actually there. It is not all based on the fiction or hearsay.
Proceed.
On the third count, they were referring to Naganda's case. In reference to Naganda's case, the ruling of the court that states that without an order, people can be displaced. I rule to disagree because in the Naganda case, which is relevant to our case, Naganda was actively killing the Abalentus, which led them to be displaced in search of a safe place to live and in search for safety for their lives. So I think this reference is not really relevant to the case here.
Counsel, your co-counsel has mentioned something that General Vande was implementing the orders from the president. Does that make him innocent from the current charges as a commander?
I would like to consent with my co-counsel's present. Your Honor, according to, allow me to refer you to the Article 31 of the Rome Statute, which says that a military or civilian shall not relieve that the person of criminal responsibility unless, unless was under legal obligations to obey under the government or the superior in question. So, Honorable Judge, I hope I answered your question.
Should all orders from a superior or a commander be implemented the way they are?
I think the superior nature of the president gives General Vande the obligation to fulfill the requirements from the presidents. Thank you, Your Honor. I would like to invite my co-counsel if there's still time.
Counsel, you also mentioned about the principle of proportionality not being irrelevant because the civilians were armed. Do you want to mean that the civilians were taking active part in hostilities, or just being armed was sufficient not to benefit from civilian protection?
I would like my co-counsel to respond to that question. Thank you.
Thank you so kindly, honorable judges. This is the point. We have to look at the rationale in this. What is the possibility of an ordinary civilian to be able to kill up to 10 members of the soldier that have 50 caliber machine gun, that have a platoon of soldiers? We got to understand that these people were fully armed and they were directly involved into hostility. They actually were civilian for the fact that they were able, try to think about a civilian fighting 50 caliber machine gun people who are fully armed and a platoon of soldiers to be able to kill that amount. It implied that they were automatically not civilian, but rather military objective as well. Thank you.
Can you refer to the facts of the case? Which paragraph can we read about what you say?
Which paragraph? Okay, paragraph 16 of the case entails that there were up to 10 civilians who died, and up to what we reference are 10 military personnel from the TOF too. So with this, you can clearly understand that the fact that 10 can be able to die from the troop that constitute up to what we reference are 50 caliber machine gun and these large weapons is enough to justify. Thank you.
Thank you so much to both prosecution counsel and defense counsel. This has been very, very interesting for us. I hope you have had fun throughout the day. You must be very exhausted. But this concludes today's group rounds. And then I think we take a short break, and I hand back to the MC to tell us what follows after this.
Hello, 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 hello. In 10 minutes, we are going to hear deliberations. So don't go far. In 10 minutes, we hear the court's deliberations. Thank you.
qu'un jour, toute la communauté...
This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence and injuries. So ICRC work here is trying to mitigate that.
Today, 65 million people are fleeing conflict, more than any other time in history. For those on the move, we support them on the journey where we can. But for those who don't want to leave their homes, or can't, they remain stuck in besieged cities. Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized the children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
Again and again, we connect brothers and sisters, fathers and mothers. When the circumstances aren't so fortunate, our forensic experts work to bring closure and the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont l'affaire des femmes. C'est pour cela que nous allons continuer en tant que volontaires à faire nos sensibilisations pour qu'un jour, toute la communauté puisse être au courant et de savoir que le viol, c'est quoi.
Throughout the world, we work to help the most vulnerable people and those who may be overlooked. We care that detainees are treated humanely, no matter what they've done, visiting 1 million detainees in almost 100 countries.
Assalamu alaikum. Sa mga tarima po namin, ma'am, 23 inmates po kami, yung iba, nagdadalawa-dalawa na lang po sila. Dito sa sahig po, ma'am, mas marami po yung...
From the diplomatic level to the front line, we remind fighters on all sides that wars have limits. Named in the Geneva Conventions as an authority on the laws of war, we work to regulate the use of weapons, the methods of warfare, and to ensure civilians are spared. No matter who they are or what side they're on, we treat the sick and wounded.
Being an organization which is very neutral and impartial, that's what we do. So it's spontaneous. You don't even have to think about it. Anybody comes with emergency, you take them in, no question.
And in the wake of war, when weapons, bombs, and mines are abandoned, we clean up what we can and help those whose lives have been changed by war regain their independence. Often first on the ground and the last to leave. Neutral, impartial, and independent, we are the International Committee of the Red Cross. This isn't a story about hate. It's a story about love. In the last 5 years, we've witnessed violence in Syria, South Sudan, Ukraine, Central African Republic, Yemen, and a score of other nations. A few of more than the 80 countries we've worked in, without fear or favour for more than 150 years. In that time, we've garnered 3 Nobel Peace Prizes, more than any other organisation in history. But this comes with losses. Every year we see colleagues caught up in the crossfire, sometimes killed or kidnapped. Amidst some of the harshest conflicts on earth, we assist with the basics of life: water, food, shelter. We work with communities to repair central infrastructure, like roads and water systems. We support people to support themselves through small businesses and loans. And we send war surgeons, nurses and doctors to where they're most needed.
We do get postage all over. Here in South Sudan, it's in civil war, and the systems are quite broken down, so there's not enough resources to care for the many people who are victims of violence.
Through preference or circumstance, the conditions they face can be dire.
لأنه لا بصوبة لا يعني حرامات لا بسفنجات يعني ما عندنا شيء يعني حوشنا.
We try to reach people stranded in conflicts and make sure they have what they need. The Red Cross and Red Crescent network spans 190 countries. Through this global reach, we help families find those they've lost in the chaos of war.
Once we realized that children had no family members with them at all, we collected all the information they could give us about their families. We used the pictures of the children, we used the names of the children and the names of their family members, and this is how we managed to locate their parents, their siblings, and their grandparents.
You may be seated. Ladies and gentlemen, on behalf of the bench and the judges, those present and those that are no longer with us for this session, we want to thank all of you for a very, very, very hard-fought battle. Since morning up to now, you have conducted yourselves very remarkably. Each and every one of you should be very, very proud of what you have done today. This experience, I kid you not, is a very, very good experience which will stand you in very good stead in your legal careers. Whatever lessons you learn here, take them to heart because they will help you in your careers. Not in just your conduct, but also in how you present the material and how you communicate. But we'll give you more in-depth feedback tomorrow as is scheduled. But as of now, I want to thank every one of you for even taking the step to get involved. IHL is a very interesting field of law that you must get involved in, whether you end up in somewhere else. You should always be interested to know what's going on in this field. So, without further ado, we are going to announce the teams going into the final tomorrow. Those whose names we are not going to call out, please don't feel discouraged. This is not the only competition. Try again another time in a different space. And be proud of yourself because you conducted yourselves very, very well. And you must know that with each year, the standards go higher. So you should be proud of yourselves. So in no particular order, the teams going into the final, and once we read out your names, please pick a member of the team to come forward to help us with a small exercise. So the teams in the final are, drum roll please. Everybody is too serious. Release the tension, the day is gone. There's nothing you can do anymore about anything. Anyway, you are and you're okay. So shall we have one member of each team to come and pick, because you have to decide who is going to be. You're going to arm wrestle to find out whether you're prosecution or defense. I'm kidding, you're not going to arm wrestle. You're just going to pick a piece of paper. For a moment there, I saw them turning to the male members of the team to come and arm wrestle instead of them. All right, we have two pieces of paper here. One says prosecution and one says defense, so pick. So you are is defense and you okay is prosecution. On behalf of the bench, we thank you, and I think our job is done for today. So I'll let the MC tell everybody what next. Thank you, everyone.
Thank you, honorable judges, for the work you've done. You are amazing. So for tomorrow, we will arrive here by 8, and we do registration of participants until 9. From 9 to 10 and 10 minutes, final round of competition will be held. From 10:40, deliberations from the judges, and 11, tea or coffee break, and from 11 to 12, public lecture, which is IHL and sexual violence in the event of armed conflict, and question and answers. From 12 to 12:40, awarding prizes. From 12:40 to 1 p.m., concluding remark by HRD. From 1 p.m. to 1 p.m. and 20, concluding remark of our guest of honor. You should be there to know who he is. Yes. And from 1 p.m. 20 to 2 p.m., lunch and departure. So I wish you a pleasant evening. Thank you very much. There is a coffee break there. You can pass there and grab one.
And the opportunity for a dignified burial. We care for victims of sexual violence and work to prevent such crimes.
Les hommes réagissent en niant cette réalité. Ils disent que ce sont l'affaire des femmes. C'est pour cela que nous allons continuer en tant que volontaires à faire nos sensibilisations pour qu'un jour, toute la communauté puisse être au courant et de savoir que le viol, c'est quoi.
Throughout the world, we work to help the most vulnerable people and those who may be overlooked. We care that detainees are treated humanely, no matter what they've done. Visiting 1 million